Justice and Justices of the Supreme Court of Pennsylvania. Oyez, oyez, oyez. All manner of persons who stand bound by recognizance or who otherwise have business before this court may now appear and they shall be heard. God save the Commonwealth and this honorable court. Please be seated.
Good morning, everyone. Welcome to our second day of oral arguments here in Harrisburg in our beautiful courtroom at the Supreme Court of Pennsylvania's chambers in the majestic State Capitol building. As architect Alfred Houston envisioned this building to be a palace of art, I highly encourage everyone in attendance to visit the rotunda, the legislative chambers, and the governor's reception room with an eye toward the beautifully crafted artwork, particularly the famous Violet Oakley murals, which were installed in 1927 and which surround this courtroom. Violet Oakley was the first female artist to receive a major public art commission, and her murals on the evolution of law are simply spectacular. The majesty of this courtroom is designed to remind us all of the seriousness and importance of the work we all do here. I'd like to draw your attention to Violet Oakley's mural in the back right corner, my left, of the courtroom. In it, the Supreme Court of Pennsylvania sits around the time of the Revolution in its courtroom now known as Independence Hall. Presiding is Chief Justice Thomas McKean. McKean voted to declare independence and immediately departed Philadelphia to lead a militia in Delaware, returning to Philadelphia in 1781 to be the last signer of the Declaration of Independence. Controversially, McKean served as a congressman for Delaware at the same time he served as Chief Justice of Pennsylvania. Chief Justice McKean's legal accomplishments include shaping the U.S. Constitution and establishing judicial review as precedent in Pennsylvania 10 years before Marbury versus Madison. Next to him is George Bryan. Bryan was the second president of Pennsylvania, serving in that role created by Pennsylvania's Constitution of 1776. A staunch abolitionist, Bryan's most notable accomplishment was ushering through the first law banning slavery in the country's history. That legislation served as an example for other northern colonies. Another justice pictured in that mural is William Augustus Aplt. Aplt, a fervent patriot during the Revolution, was appointed to serve as a justice in 1777, and after the Constitution of 1790 required judges to be learned in the law, he was appointed as the president judge of Lancaster County. Edward Shippen IV stands to the right in the mural. Shippen descended from a wealthy merchant family of Philadelphia and was, for the most part, neutral during the war. However, interestingly, his daughter Peggy was the highest paid British spy in the war and was married to Benedict Arnold. In the hallway entering our courtroom, Chief Justice Shippen's portrait is displayed next to his grandfather, who also served in the same role. Finally, not a Pennsylvania Supreme Court justice, but one of the original United States justices, James Wilson, is dressed in blue. You can see him speaking in the mural. You can't hear him, but you can see that he's speaking. He was discussing the westward expansion of the nation with those in attendance. Wilson was one of only 6 people to sign both the Declaration of Independence and the Constitution. During the Constitutional Convention, Wilson advocated for governance by the people as far as practical and is credited for adding the word "we" to "we the people." Finally, as you likely noticed when you were entering the courtroom, the court has a tradition of hanging oil portraits of former Chief Justices in our courtroom space. I'd like to just briefly touch on 3 of the portraits on the right side of the entry and their significance to the court. Chief Justice John Bannister Gibson is the longest-serving justice in the court's history, serving from 1816 to 1851, God bless him, and having held the office of Chief Justice for 24 years. Gibson studied at Dickinson College, and he filled the seat left by his legal mentor, Hugh Brackenridge. A man of many interests, Gibson wrote prolifically, with one of his most famous opinions being a dissent arguing against the principle of judicial review, a dissent that may well have cost him an appointment to the U.S. Supreme Court. Displayed next to Gibson is a portrait of his successor, Jeremiah Black. In 1850, the Pennsylvania Constitution was amended to require that judges be elected for the first time in the Commonwealth's history. The entire bench was emptied, and an election was held in 1851. The 7 newly elected justices drew straws to determine seniority, and Justice Black drew the shortest straw, meaning he would only be able to serve a 3-year term, but he would serve as Chief Justice. The next shortest straw served a 6-year term, with the final 3 years being Chief Justice. The final portrait on display is the most recent Chief Justice to serve from the Harrisburg area, Thomas Saylor. We were privileged, most of us, to serve with Chief Justice Saylor, and listing his legal accomplishments would take too long. However, one of his most notable actions as Chief Justice was selflessly to turn over that position to my predecessor, Max Baer, 7 months early, to allow Max to have more time as Chief Justice. Chief Justice Saylor now serves the court in the capacity of Chief Justice Emeritus, and together with Chief Justice Gibson and Chief Justice Black, they are the only chiefs to serve as a justice following their service as Chief Justice. Before we hear the first case today, I would like to remind counsel of a few things. Appellant counsel, please approach the podium when your case is called. I will then give a short summary of your case. You may then begin by stating your name and the party you represent, and by introducing your co-counsel to the court. The justices are familiar with your cases, so I ask that you avoid any unnecessary recitation of facts or procedural history, and instead focus on the main issues on which we granted review. Counsel is welcome to rely on your briefs for particular issues. In cases in which there are multiple parties represented by separate counsel, please avoid repeating the same arguments as your prior counsel. Please try not to interrupt the justices when we are asking you a question, although we may be interrupting you. A justice's question is not meant to trip you up. Rather, it indicates there are particular issues we wish to explore further. I remind you that we do not allow rebuttal. While there's no set time limit for argument in our court, I will advise counsel when the court is satisfied that all of its questions have been answered, and at that time, I will ask that you conclude your argument. Mr. Minner, would you please call the first case?
Mark R. Schmidt, Schmidt, Kirifides, and Rassias, representing Appellant, Mr. John Kennedy, representing himself, Mr. Mark Schmidt.
Good morning.
Good morning.
The claimant in this case injured his back in the course of his employment at Appellant's law firm, and a workers' compensation judge awarded him medical expenses related to his injury. Claimant's treatment was limited to pain management, which included the use of opioid medications. Because claimant continued to experience pain but did not want to increase his use of opioids or undergo surgery, his doctor gave him a prescription for CBD oil. Claimant purchased the CBD oil from a health food store, which did not require a prescription, and obtained pain relief by taking it orally before bed. When claimant submitted the prescription and receipts to appellant for reimbursement, Appellant refused to reimburse him. Claimant filed a penalty petition alleging that appellant violated the Workers' Compensation Act by failing to do so. We granted review to consider whether a product such as CBD oil, which can be purchased without a prescription, qualifies as medical services or medicines and supplies that are reimbursable under the Act. Please proceed.
Thank you, Chief Justice. May it please the Court, my name is John Kennedy. My co-counsel with me today is Attorney Robert Elias. We've had the pleasure for the last 5 or 6 years or so of representing the claimant's law firm, the employer in this case, and the insurance company, Donegal Insurance Company. We are here today to request that Your Honors reverse the Commonwealth Court determination finding CBD oil is a medicine or a medical supply under Section 306 F.1 of the Pennsylvania Workers' Compensation Act. My goal today, Your Honors, if the Court allows, is to address 3 primary areas. First, I'll address the issue of whether CBD is actually a medicine or a medical supply under Section 306 F.1 of the Act. Second, I want to address the prescription that was submitted by the claimant in this case from his treating provider. And third, I'll analyze Section 306F as it relates to the facts in this particular case, which are unique. How the Section 306 F.1 applies to the prescription, and address some of the arguments, not all the arguments, but some of the arguments the claimant makes in his brief. Now, since we filed our brief in July of 2024, CBD oil is still a very dangerous product which carries significant health risks. That can't be disputed.
Why is your assertion in that regard superior to the appellee's physician's recommendation or quote prescription, unquote?
Excellent question, Your Honor. The Court's not bound, certainly, by the FDA or the CDC in their opinion on a substance, but the Court has to determine whether CBD oil falls under Section 306 F.1 of the Act. It's either a medicine or a medical supply. So the status of any substance that a claimant might purchase out of pocket without a prescription certainly must be reviewed by the Court to determine if it falls under Section 306 F.1 of the Act. This is a substance that, and I'll get into this more in my presentation, but this is a substance that is relatively new. It wasn't until the Farm Bill of 2018 when the federal legislature allowed individuals to take hemp and make products out of it. So the concern that the Court should have is, what is this substance that we're dealing with? What is the chemical that we're dealing with? What is it that the claimant's actually purchased? And if we can't dispute that it's a dangerous substance, so it has to be something that the Court has to look at because the statute speaks.
You just said we can't dispute that it's a dangerous substance.
Well, according to the FDA.
Well, we're not governed by the FDA. His medical provider gets his license here in Pennsylvania, and we're not talking about FDA drugs, we're talking about medicine. The General Assembly used the word drugs elsewhere. They didn't use it here, they used the word medicine and supplies. And I don't know what yardstick you're offering us to look behind the judgment of his licensed medical provider. I don't understand why a lawyer's opinion of what's dangerous or an FDA bureaucrat's opinion about what's safe and effective has much to do with what his licensed medical provider says is medicine that could help alleviate his pain.
2 things on that, Your Honor, and those are excellent questions. Number 1, the prescription that we received was for topical use only. And the claimant admitted when he testified that he was taking this substance orally. So that's the first question that we had about why the claimant was using this substance in violation or against what the actual prescription that we received said. And I understand the Commonwealth Court reasoned their way out of that, found a way to get around that issue. That's the number 1 issue on that. Number 2 is the statute speaks in terms of reasonable medical services. There has to be some analysis of what a doctor is prescribing for a claimant and how it's being prescribed is reasonable.
Well, there is. It's called the UR process.
Utilization review, Your Honor, wouldn't apply until this substance actually falls within a medicine or a medical supply.
Okay, so I'm not going to go down, I don't want to go too far down this road, but if you could actually use the statutory language instead of the language you're using, it's not medication or medical supply. It's medication and supply.
Medicines and supplies, Your Honor.
Medicine and supply. So if you could stick with the statutory language instead of going medication and medical supply is not the statutory
Sure, Your
language.
Honor.
It's
Actually-
medication and supply.
And Your Honor, the section, actually, I'll read it word for word, because I think every word, once again, it's a statutory analysis, so we have to give every word import. The first sentence, of section 306F.1, subparagraph I. The employer shall provide payment in accordance with this section for reasonable surgical and medical services.
Right, but that's services. We're not talking about services. You got to go to the other. You got to go to the other part of that statute that deals with medications and supplies.
Well, this is
this wasn't a medical service. This wasn't a doctor's visit. This is a This is something a doctor prescribes. So it's not a medical service. Because a medical service has to be given by a healthcare provider.
I would think so, yeah.
Right.
Although I think medical services pharmaceutical services would fall under that too.
Sure, but this wasn't distributed by a pharmacy either.
Correct, it was
so
not.
It was not provided by a healthcare provider. So,
Correct.
So you have to go to medications and supplies, and let's go to that status.
Well, this is all the first sentence, Your Honor, of section 306F.1. It's the entire.
I'm very familiar with the statute.
Yes, and I think, Your Honor, when we're analyzing a statute, you have to look at all of the provisions of the statute, not pull out just one phrase, which would be the last phrase, medicines and supplies as and when needed. Section 306F.1 talks about medical treatment and medical services, the entire section. I don't think when we're analyzing a statute that the proper way to analyze that is to pull out just one phrase, medicines and supplies, and look at only that phrase and ignore what the rest of the statute says. That's our argument. That's our position.
Yeah, I'm not ignoring it. I think the debate here is, does this fall within a you can have coverage under the Workers' Comp Act for medications and supplies, even though medications and supplies are not medical services.
Medicines
Medicines and supplies.
Yeah, medicines and supplies.
Yeah.
Even though they're not
The Act covers services and medications and supplies. Medicines, gosh, I keep doing that. Medicines and supplies, yes.
Your
But
Honor,
not medical supplies.
our position is that you have to read the entire statute and take it in context, but I understand Your Honor's position on that.
And I think Justice Weck's question was simply, if a doctor says you've suffered a chemical burn, and instead of giving you this prescription topical ointment, I'm going to enter a treatment plan that requires you to engage in a daily oatmeal bath.
A daily what bath?
Oatmeal bath.
Okay.
I thought you said opium bath.
No, is that a thing?
That's why
That would be so interesting.
That's why I asked for clarification.
Oatmeal bath.
Thank you.
Would and you know, it's in the treatment plan for the doctor, healthcare provider, probably the best medical provider in the Commonwealth of Pennsylvania says, instead of giving you this expensive topical ointment, I'm going to tell you to take a daily oatmeal bath.
Plain oatmeal or apple?
Steel cut oatmeal. They submit that the purchase of the oatmeal for reimbursement. Does the carrier have to pay for it?
You know, and Your Honor, this was one of the things I was concerned about with the argument today. I think CBD oil is such a unique
No, I'm asking
product.
about oatmeal.
I understand.
Okay.
It's so hard to draw analogies to other
Well,
situations that
I'm
are
asking
present,
you-
but let me see if I can answer that.
All you have to do is tell me whether, under your theory of the case, of the statute, your interpretation of the statute, can the claimant get reimbursed for the cost of the oatmeal?
I would think, Your Honor, in a situation like that, if a doctor has formally prescribed it and it's for the work-related injury and we have the medical reports to back it up, I would find it hard to believe that any insurance carrier would deny payment for something like that.
So the answer is yes.
Yes, Your Honor.
Okay.
Yes.
So I guess, I guess, to me, your best argument is the fact that the healthcare provider who set forth this treatment plan didn't comply with the cost containment regulations.
Before we get to the cost containment regulations, Your Honor, we have to make a determination if the court is going to include a product like CBD oil under Section 306F.1, given what the FDA and the CDC, the state of Pennsylvania, at least two legislators that we know of in
CBD
Pennsylvania.
oil is not illegal in the Commonwealth of Pennsylvania. CBD and oatmeal are both as legal in the Commonwealth of Pennsylvania as the other.
Right.
I mean, so I'm not sure why you want to focus on that. The question, it seems to me, under the Act is, did a healthcare provider provide this as part of the treatment plan for a work-related injury? And if they did, and assuming it's not an illegal substance, then you have to pay for it if it's part of the treatment plan, unless, assuming the physician, the healthcare provider who prescribed it as the treatment plan, complies with all the documentation so you can seek a UR review if you want to seek a UR review. Why am I wrong?
A lot of questions there. Let me see if I can break down your questions.
Actually, there were a lot of statements, but it was one question. Why am I wrong?
I think the comparison between an oatmeal bath for a burn victim and CBD, it can't really be made. Those are separate analysis. We have to deal with CBD oil and CBD products in this case because that's the product that the claimant in this case sought for reimbursement. And it's so difficult to answer by analogy because CBD and all the hemp-derived products that are out there now is such a new product. It is admittedly controversial, to say the least. And it's something that, it didn't come about until the 2018 Farm Bill, where they put that legislation in place that said that you can possess CBD and hemp-related products if it has a Delta 9 THC concentration that's under a certain level. That's why it's very hard to analogize CBD to something like an oatmeal bath or
But
other
the Farm
products.
Bill, but doesn't the Farm Bill, which I appreciate that you mentioned a couple times, doesn't that combine with the proliferation of these shops, these CBD shops, combined with, most importantly, with what his physician did here, suggests clearly the trend is opposite your argument. In other words, it seems apparent that the therapeutic trend for CBD oil is much stronger than the trend for oatmeal. I return, I guess, to the problem of how this court should find a way to credit your argument over what his physician, in his professional judgment, thought was most therapeutic, short of a utilization review, which is your right.
Thank you, Your Honor. Two things on that. Factually, in this case, Dr. Murphy, the claimant's physician, gave a prescription for only topical CBD oil. And that's clear from the prescription that's part of the record. I think it's 79A, if I'm not mistaken. That prescription was limited to topical application of CBD oil. It says right there, apply as directed PRN. So there was no question that when we received that prescription, that was the first question we had. This is an application of it topically, not orally. Then we took claimant's deposition testimony. I think it was a live hearing testimony. Claimant testified that he was taking it orally.
Both, right? Didn't he say both?
He said he was taking it orally. He said he understood that the prescription was for topical application of a CBD oil, and that he had decided to try both, topical and oral worked better. Sublingual worked better. That's important because you're talking about if a doctor prescribes something, doesn't the doctor's opinion reign supreme? That may be a good argument, quite honestly. But in this particular case, that's not what happened.
Yeah, well, why isn't that something you'll deal with in the UR review?
That's an excellent area. We might as well get into that. UR, Your Honor, wouldn't apply until there's a determination. First of all, let me take a step back. Claimant is asking to just be able to submit a receipt.
No,
Look,
I understand that, and I understand that. I understand what the claimant is trying to do. I'm asking you, and I asked you to go to the cost containment requirements because I think you have a very good argument that a healthcare provider who sets forth a plan of treatment for purposes of a work-related injury and doesn't document the required documentation necessary for the insurer or employer, if self-insured, to perform a review and potentially ask for a UR, that's a problem. I think you have a pretty good argument on that. My question is, this issue over whether he followed the doctor's instructions seems to me to be something you can raise as part of the UR process, because the medical necessity and treatment determination is going to make based on the prescription or the treatment plan that the doctor prescribed, not based on how he is using it. And if he's not using it the way the doctor prescribed, I agree, you wouldn't have to claim it, but that would come out in the UR review process.
If I understand your question, Your Honor, I don't believe that as part of the UR process, the Utilization Review Organization will look at the issue of whether claimant is using CBD oil in accordance with the prescription. They will look at the doctor's cost containment records, and the doctor's cost containment records should disclose how the patient is using the medication and whether the patient is using the medication according to the treatment plan. Maybe. It's possible. They might, like in this case, it just said try CBD oil.
Well, no, the doctor didn't provide the reports. That's your whole argument.
Correct.
So the doctor didn't do anything they're required to do. I don't know. I don't understand why you keep saying there has to be sort of threshold determination. I don't know where that is in the act that you're arguing for this threshold.
Well, that's right in the first sentence of section 306F.1I. That's where I'm taking that from, that there has to be a determination about it. And that's what happened in this case. Quite honestly, I was counsel of record at the time these receipts came in from claimant, and the prescription came in. And the first question we had was, we can't tell from the receipts what was purchased. And the other question we had was, the receipt's handwritten, and there was, is the claimant using it? And in answer to your question, Judge, I'm sorry, I'm getting off track. Answer to your question, Your Honor, I don't think as part of the UR process that UR reviewer will know, just by looking at the medical records, the doctor's chart, if the claimant is using it in accordance with...
Well, that's true of every medication. A doctor could prescribe an opioid, and it may be possible that the claimant is abusing the opioid medication. The doctor could prescribe an antibiotic, and it may be that the patient is giving part of the antibiotic to their child because they can't afford antibiotic for the child. I mean, that's just inherent in the context of treatment.
That's true. Yeah, I would agree with you there, Your Honor, that it's possible with any type of medication that the claimant is not using that medication in accordance with the prescription that was issued in the case. That's
Counsel, what you're talking about now is really sort of in the weeds, and if what we're talking about is whether or not he appropriately used the CBD oil, there's an inherent acceptance of the fact that it's a medicine. I mean, I thought you were telling us that CBD oil is not a medicine. I mean, that's the overarching issue here.
It is.
I mean, but if you're okay with the fact that if he had applied it topically, we wouldn't have a problem? Is that what you're saying?
I don't think that changes the analysis, and we're not okay with that, Your Honor. It still would not fall under, in our opinion, our argument is CBD oil, because of its inherent dangerousness, the adverse reactions and so forth.
Yeah, but then we always get back to the same point. Who are we to say that if his physician prescribed it? And your answer to that is, he didn't prescribe it to take it orally, he prescribed it to take it topically. That's not an answer to the question of who are we to say it's not a medicine. I mean, if his physician prescribed CBD oil for whatever type of application, doesn't that get us over your argument? Yeah, but some people think it's dangerous, and this is not something that we want to encourage. I mean, that's for his doctor to decide.
There are many things, Your Honor, that doctors might prescribe that might not fall under the definition of a medicine or a supply under Section 306F. There has to be some procedure in place.
Well, that's whether it's reasonable and necessary. It's a different issue. It's a different issue.
It wouldn't get... Our analysis is that you don't get to reasonableness and necessity and a utilization review process until you make that determination that whatever the substance is that the claimant is using falls under Section 306.
Your argument that it's not a medicine and supply is that it's not reasonable.
Correct.
It's not that it's not reasonable, it's that it's...
So are you saying CBD oil is reasonable for this
No,
condition?
CBD oil today is certainly something that has significant side effects.
Is it unreasonable?
It's not a reasonable medication to take.
It's unreasonable?
Correct.
Okay, well then, reasonableness and necessity is decided in the UR process.
I think it's beyond that, Your Honor. I think it's something that's unsafe. It's something that shouldn't be prescribed.
But the fact that you think that, I don't know where I know this is the third time I'm raising this, but I'm still not getting an answer about why an insurance company's thought that something is unsafe trumps a licensed medical provider's judgment.
If you go back in time to when this happened, Your Honor, this was all in 2019 and 2020. So the Medical Marijuana Act had just been passed in 2016. So we had legislation in place at that time for medical marijuana that addressed how that product should be sold, how it should be dispensed, the fact that individuals had to get a medical marijuana card, had to see a doctor, meet one of the diagnoses in the act, go to a dispensary, be qualified to use that product. And then CBD oil comes into place. CBD oil, hemp-related products, and marijuana were both Schedule I drugs at one time. They were both under the federal designation of a Schedule I drug.
Do you think that his physician doesn't know this?
I don't know.
Do you think you have superior, I don't mean you personally, do you think your carrier has superior knowledge about the the pharmaceutical backdrop than a licensed medical provider?
I don't think an insurance adjuster or carrier would have superior knowledge about what the doctor thinks, but I do think the carriers would have an idea as to whether these products fall under the Workers' Compensation Act, and specifically Section 306.
But that doesn't mean it's not a medicine. It means it's a substance that your carrier believes is unreasonable for use under these circumstances. This is a legal substance. We keep, going in a circle on this.
Yeah. It could be a legal substance, Your Honor, and that's an excellent question, if you allow me to explain.
It is a legal substance.
Well, it's definitely a legal substance. I mean, I often drive on McKnight Road in the
Absolutely.
Pittsburgh area, and you can't go a block without
Absolutely.
seeing a store for this.
It's a legal substance, but there are times, and that's why we cited this in our brief, there are times when CBD products contain THC. And there are plenty of cases, not the least of which was a U.S. Supreme Court case where they just had oral arguments last month, where a trucker took CBD after he had contacted the manufacturer and found out, they sent him a correspondence saying it's THC free, don't worry about it, you're fine to take it. Well, he took it, failed a drug test, lost his job. It's called Horn versus medical marijuana. That's not in my brief. But in that case, he took what he thought was a legal product. It was not a legal product because he had a positive THC drug test after he took it, and as an over-the-road DOT driver, he lost his job. Sued that company, and that they just had oral arguments last month in front of the United States.
I don't understand how this has any bearing on it. You took his deposition, right?
The claimant's deposition?
Yeah.
Claimant testified live at a hearing, yes.
Okay, so did you ask the claimant where he purchased the CBD
Oh,
oil?
yes.
Did you ask for a sample of it so you could test the THC content?
No. As a matter of fact, Your Honor, the only thing that had come into us were the receipts, and they're part of the record, the prescription from Dr. Murphy, and some records from
Well,
Dr.
I'm not
Murphy.
saying you had an opportunity to ask him where he purchased it, right?
Sure. Well, that
And you
came
had
up-
an opportunity to ask him for the CBD oil so you could presumably test it.
we didn't do that, Your Honor, and
I
that's
know,
a
but
good
you had an
point.
opportunity to.
That's a good point.
I'm not sure why, considering I'm Justice Weck and I do not shop at the same CBD oil store. I live in Harrisburg, but there's a CBD oil store right next to the Giant that I shop at. And are you suggesting that we are to assume that the CBD oil that the claimant used here is an illegal substance?
Is an illegal substance?
Yes.
It depends on what the THC
I'm
content.
asking you if you're asking us to assume it.
No, I'm not asking the court
Then
to
whose
assume anything
obligation?
like that.
Let's assume he's taking an illegal food, because it says CBD oil. I'm not sure if it's a drug regulated as a food or a drug. Let's assume he's taking an illegal drug, a drug that on its face is legal, or a medication that's on its face is legal. But you're saying because of a certain chemical composition, it's illegal.
It could be.
Okay, who has the obligation to prove that?
It's a claimant's burden of proof in a penalty petition, Your Honor.
Did you at the penalty hearing demand proof that the CBD oil that he was using was a legal substance?
At the hearing, I asked the claimant if he was aware that the FDA had raised these issues with CBD.
That's not what I asked you. I asked you, did you raise the issue of the CBD oil that he was seeking reimbursement of, whether it was legal CBD oil? Did you raise that issue?
I know that issue came up, Your Honor. I'd have to go back, and I don't want to misspeak and look at the record. It's in the record. It's in the reproduced record. I know I asked claimant where it was purchased, and I know I asked for specific information on the product that was purchased, because we only had the receipt, which had a shorthand designation, and there were 4 or 5 receipts that spelled out what he purchased. I actually went and found what I thought was the label, which is also part of the record, for the product at issue. And I believe there's testimony from the claimant. I don't want to misspeak because I don't have that transcript memorized. But we didn't test it, Your Honor. Honestly, I'll be honest with you, that thought never even occurred to me to test the product and see if it was legal or not. I think the point is that CBD products, right now today, as we sit here today, could potentially have THC content that is higher than medical marijuana. And people are buying it without a medical marijuana card.
And then it would be unreasonable to prescribe that.
How would we know?
There is a way. Do what you're doing here. Do what you did to the claimant here, but take it to a utilization review board and say, here are all the problems with CBD. We don't know if this is adulterated or unadulterated, and consequently, it's unreasonable to prescribe this under the current circumstances.
I made those arguments, Your Honor, to the WCJ, and they were not received favorably. In other words, I lost.
I know.
So I did raise those arguments with the WCJ.
But see, that sort of proves the point, doesn't it? I mean, we're talking about a presumptively legal substance that's been prescribed by a physician who understands the risks and rewards of using it. I mean, the alternative for this gentleman was using opioids. Is that what we want to encourage? I don't think so. I mean, this was a reasonable approach to avoiding the use of opioids. The physician agreed with it. How can we say it's not a medicine? Based on what?
Your Honor, excellent questions. Let me address the opiate issue. Do we really want a process in place? This is what the claimant is arguing for. The claimant is arguing for a system where injured workers, on their own, go out to a health food store and purchase products to treat a potential opiate issue? Is that the system?
Because his physician told him to.
I'm sorry?
Because his physician prescribed that for the treatment of the work-related injury. I mean, without that causal connection by a physician that this was prescribed for the treatment of a work-related injury, then you're in a different ballpark. But that's not what we have here.
The physician in this case prescribed it for topical use,
Now
according to the
you're back to
prescription.
that argument. Totally different argument. That has nothing to do with whether or not it's a medicine.
I think the claimant has a requirement, Your Honor, to follow the prescription that the doctor...
But that doesn't make it not a medicine. You're saying there's a different flaw in this claim, a flaw that is separate and distinct from whether or not this is a medicine. But I mean, the overarching issue that we've been asked to look at is whether or not this is a medicine. Not if it's topically applied or if it's taken orally. A totally different issue. You may prevail on that, but I mean, what we're really here as a matter of statewide importance to address is whether or not the CBD oil is a medicine.
And Your Honor, an excellent point. And Your Honor, my response to that would be, as a court in Pennsylvania, the Supreme Court, I think there is an obligation on the Supreme Court to actually look at what, we're not bound by it, but to at least look at what the federal government is saying about this substance. And my brief is replete with examples of so many problems with this substance. To say that it's a medicine under the Workers' Compensation Act when it causes hallucinations, liver damage, and it causes problems with pregnant women taking it, male reproductive health.
But it's somewhat ironic, I suppose, that you want to parade these horribles with respect to a substance his physician ordered, ostensibly in order to avoid him going to unquestionably dangerous and addictive substances, opioids. So, is there a disconnect between the negatives that you're associating with a legal substance that his physician prescribed while not acknowledging the clear dangers of the substance his physician wanted him to avoid, which were opioids.
Your Honor, this substance is available in Pennsylvania without a prescription. CBD products can be purchased by anyone. So if this court were to say that CBD products falls under the coverage of the Workers' Compensation Act, you're going to have injured workers out there buying this without a doctor's
presuming a physician writes a prescription.
Makes it part of the treatment plan.
I wonder how that would work. I'm sorry.
Makes it part of the treatment plan. You don't need a prescription written on a pad with the prescription RX number. You don't need that. But if a doctor's, it's an oatmeal bath. Oatmeal bath. It's an oatmeal bath.
Yeah. So if I get
a different
address
example.
I don't know why oatmeal sounds like opioid.
I'm beginning to wonder whether Justice Brobson has a side contract with an oatmeal with Quake Roads.
I guess in response to Your Honor's issues, if the court approves it, people are going to buy it and use it for work-related injuries without a prescription, unless the court says.
No, you're missing a very important point. If a healthcare provider has made it part of the treatment plan for the work-related injury, you're acting like we're ignoring that. That's a very important fact.
It's key.
You're worried about injured workers going rogue and saying, I know my doctor wanted me to take OxyContin, but I'm going to go get CBD oil, and then I'm going to submit it to the workers' comp carrier for coverage. In that case, that would be denied, without a question, because it was not part of the treatment for the work-related injury.
And we know how to say that in an opinion, if that is our,
That it would be limited to a prescription only as part of the treatment plan.
could be, yes.
I think I do see part of your argument from this side of the bench, and it doesn't involve oatmeal, but isn't the gist of what you're saying here is you're concerned about the CBD oil because it's not a drug that's been, or a medicine that's been approved by the FDA. So in your scheme of horribles, what could transpire is Dr. Feelgood comes into town with his horse and cart and sells snake oil or lavender oil or whatever, and then you have some doctor who, without the FDA approval, says, oh, this stuff is great stuff. Let me write you a little prescription. Go down and see the vendor at the Dr. Feelgood snake oil stand and get a couple supplies of this on a monthly basis. And then we have a scenario where the Workmen's Compensation Act is supporting a medicine that is, who knows what it is, and is not approved by the FDA. I think the harder part of your argument is, well, is it a supply?
Your Honor, and I can address the supply issue, and that's an excellent point. The Commonwealth Court, when they tried to determine if this constituted a supply, looked at the medical definition of medical supplies, and I understand, Your Honor, you're concerned about the use of that phrase, but that's what they did. They didn't just look at the word supplies, or you can't really find a definition of medicines and supplies.
Yeah, once again, I have a lot of respect for my colleagues on the Commonwealth
Absolutely.
Court, but at this point in time, we get to look at it brand spanking new.
Absolutely. So the definition, Your Honor, that they use for medical supplies, they essentially took just the first part of it. They took the section that said any item that is essential for treating illness or injury, which is quite broad. But what they didn't put in their decision was medical supplies are usually understood to mean articles which are low cost, disposable, and used in high enough volume that the purchasing department has standing orders in place to ensure that the items of interest, for example, gloves, gauze, needles, and syringes, are never out of stock. I think, in getting back to Your Honor's position on using the correct language of the statute, medicines and supplies, calling CBD oil a supply essentially makes the phrase medicine and supplies useless.
Well, that doesn't carry the day for you per Judge Wallace's concurrence. We could certainly decide it's a medicine.
Absolutely. I was answering
Justice
Mundy's question about is it a supply. I think that's the supply argument that the Commonwealth Court set forth really didn't take into account the full definition of medical supplies. CBD oil is not it's not a supply. If we're going to separate out medicines and supplies, it's not a supply because hemp used to be a Schedule I drug. So if we're going to use, look at the language and apply import to all of the words of the statute, you have to give it its common, everyday, ordinary usage. And if you're going to say that CBD oil is a supply and supplies could be medicine, it renders that whole analysis
Counsel,
useless.
I'm going to drop oatmeal because apparently that's a problem. Aloe vera.
Aloe vera.
What if for burn, the treatment, a chemical burn, the doctor's treatment plan includes apply aloe vera topically, not orally, twice a day, and the claimant submits the aloe vera receipts for reimbursement. Is that a medication or a supply?
That would be a supply, Your Honor. And that would be reimbursed. As a matter of fact, in this case,
Why is it a supply?
aloe vera, no?
A supply.
You don't think it would be a supply? A medicine?
Just
Well, is
trying
it
to
a
discern
medicine
the
or it is
difference.
a
Yeah.
supply?
I mean, I don't know if aloe vera actually falls under the federal designation of an over-the-counter medication. I'm not an expert on aloe vera. I'm somewhat of an expert on CBD. But aloe vera, if it's considered an over-the-counter medication, which has a specific designation, Your Honors, under federal law, Tylenol, Advil, aspirin, all of those products that you go into CVS and Rite Aid and see on the shelf as pain relievers, Bengay.
Well, then if you're going to go down that road, then I'm going to get back to oatmeal. I mean, seriously, you said oatmeal was covered, so is oatmeal a medication or a supply?
Oatmeal would be a food product, and that's how the federal government looks at.
But you said it's reimbursable. Hey,
I think so. Well,
so is it a
you're-
medication or a supply?
Yeah, Your Honor, it's hard to look at these things in the abstract until you're actually faced with
No,
the
it's not.
specific facts in the case.
You're faced with arguing a statutory construction argument here.
Yeah.
And if you're prepared to argue a statutory construction argument, you got to be prepared to
Absolutely.
take it out to its logical
Absolutely,
extension.
Your Honor.
So you said oatmeal would be covered if it's an oatmeal bath for treatment. Is oatmeal a medication or a supply?
That would fall under the supplies. I think most adjusters would say that's a supply. Now, aloe vera, and I don't know, I'm not an expert on aloe vera, and I don't want to misspeak to the court. When you walk into CVS and Rite Aid and so forth, Tylenol, Advil, those are all over-the-counter medications.
And they're all covered.
Yeah, absolutely, Your Honor.
Okay.
That would be something. I can't see, an attorney Elias and I spoke about this issue many times. And in this case, when we picked up the case initially, we did a stipulation, and we covered some of the claimant's out-of-pocket costs. Just recently, just over the summer, there were some out-of-pocket costs that the claimant purchased. I think there was a back brace he purchased himself, and there was some other medications. I can't remember. And we covered them. That's fine. That's not a problem. That's what happens in workers' compensation. But CBD oil is so unique. CBD oil is, and that's why it's very hard to analogize and make analogies to other products, because it really doesn't match any other product that's out there. It doesn't match medical marijuana, that's for sure. It's similar to medical marijuana because they come from the same strain and they have the same effects on people. But CBD oil, I think if it's anything, the court would have to find, and we disagree with this, it falls under the medicine section and not the supplies, because that would just render that section, that language, medicines and supplies, completely useless at that point. There would be no meaning to those words.
What's the definition of medicine?
There is no definition of medicine in the Workers' Compensation Act.
Yeah, well, do we look to dictionary definitions? I mean, you seem to think there is, because you keep referring to federal designations that somehow render certain substances medicine. Where are you getting that from? I mean, the Act refers to medicine.
Right. Your Honor, when we're looking at a statute, I think you have to give it its plain and ordinary usage.
I would look to Webster's for that,
Well, I think when everyone uses the word
which says
medicine,
it's a substance or preparation used in treating disease. Isn't that what CBD oil is?
yeah, Your Honor, the Commonwealth Court used the dictionary definition of medicine as a substance or preparation used in treating disease, but they really focused more on.
That's Merriam-Webster. That's
I know.
not the Commonwealth Court. That's where I just read it from. I mean, they may have used that also, but what's wrong with that?
They focused more, well, I'm looking at the Commonwealth Court analysis because we're asking to reverse the Commonwealth Court.
Okay.
Then they looked at something that affects well-being. And they looked at a substance such as a drug or potion used to treat something other than disease. This is available without a prescription.
So
And it
what?
never had a
So what?
it
doesn't-
never-
So what? I mean, that, you keep saying that,
Mm-hmm.
except that you have a physician who made this part of a treatment plan. I mean, who are we, on what basis would we decide that that was inappropriate? I mean, we're going to weigh expert opinions, or do we take the word of the treating physician in the case?
Well, first thing, arguably, well, not arguably, factually, it was not part of the treatment plan. Oral ingestion of the substance was never part of the treatment plan in this
You keep getting
case.
back to that. Let's assume that he didn't orally ingest it. Let's assume that what he did is he topically applied it. Would you still be here saying that that's not compensable?
It's so hard, Your Honor, and I just have to be honest. It's so hard to determine what our response would have been to this case if it was just a topical application.
Well, then it's a medicine.
Your position is it's not a medicine.
Yes.
Positions
You keep defaulting to this argument about topical versus oral, but your position is it's not a medicine, and that seems to fly in the face of dictionary definitions and Dr. Murphy's testimony to the WCJ, which the WCJ credited.
And I might add, and to the fact that you apparently might not have a problem if he used this topically.
No, Your Honor, it's our position that CBD oil does not fall within under Section 306F.1.
So, counsel, if I may,
Yes.
we know the Workers' Compensation Act is remedial, and that it should be liberally construed to achieve its humanitarian purpose. You have a doctor giving a prescription as part of the medical treatment, CBD. It's your position that you would rather a doctor order OxyContin, despite its addictive nature, as opposed to CBD oil. Is that what you're telling us?
Given the facts of this case and what the federal government says in terms of this product, yes, Your Honor, that is what we're saying. This product should not be used to treat an opiate issue. CBD oil that can be purchased without a prescription by anyone isn't the way to treat an opiate addiction. There are other ways that a doctor...
And that answer is a utilization review question.
Well, I think it goes more, Your Honor, to whether this...
Well, just answer my question. Can that argument be raised in the utilization review process?
Could it be raised? Absolutely, Your
Okay.
Honor. Absolutely, yes.
Then
I
why
have to
should we
agree
do
with
it
you
here?
there. Because of the utilization review process, they might not see that issue. A utilization review organization reviewing the bland medical records and possibly a statement from the claimant might not see the issue that the claimant is using something off the shelf without a prescription. The utilization review organization might not see the issue that the claimant is not using it according to the prescription, unless there's...
Well, I'm sure you're able counsel, and you will point it out in the record, and there will be able to be an appeal up to the Commonwealth Court of the UR process and the UR determination, and maybe someday we get the question of whether a UR determination about this particular formulation of CBD oil, whatever it might be, assuming you create the record, is not reasonable and necessary.
Your Honor, that's something that, you know,
You've
again...
already done that.
Sorry?
You've already done that. Have you appealed the decision of the Utilization Review Committee?
At the time of the utilization review, it's my recollection that there was no use by claimant of that substance at that point in time.
Okay,
So-
you know what, Mr. Kennedy, we do understand this is a little bit of a tricky issue, but I assure you we're going to figure it out, and we're going to hear from Mr. Schmidt next.
Thank you, Your Honors.
Thank you, sir.
Thank you all.
May it please the court, I know this is a bit unusual, but I'm Mark Schmidt, counsel for Mark Schmidt.
There's a movie about Schmidt.
There is. Very ironic. To address Justice Brobson's argument about the utilization review, yes, there was a utilization review. There was an IME. There was a record review by Dr. Francillo. Everything that an insurance company can do to challenge whether or not the use of CBD oil is appropriate in this case was done by the defendant. The utilization review was after the CBD regimen started. An IME with Dr. Elia was after the regimen of CBD started. They tried every avenue that is available when an item is an FDA drug.
Oh, so there was a defense medical exam?
Yes, Dr. Elia.
That was, okay, and was there a challenge on ensuing then?
No.
on causation?
There was no petition based on Dr. Elia's exam. He was
Or the
fully
utilization
informed
review.
of the treatment plan. He did not address it in his report. Claimant's testimony, live in front of the judge, stated that he informed Dr. Elia everything that was going on, and the reason for trying CBD was specifically to avoid the dangers of increasing opioids, of having surgery and being out of work for an unknown period of time. The entire discussion was looking for alternatives that could be used in that stead and enable the claimant to continue working, which was successful. The result of any treatment plan shouldn't be determined by the result, because doctors don't have a crystal ball. They don't know if it's going to work. But if the doctor, in their experience and judgment, thinks it's a reasonable plan, the insurance company has a process to challenge that. They did every single one. If they wanted more records from the doctor, if they wanted more of an explanation, they could have asked. They didn't. They wrote back and said, this is not an FDA-approved drug. It's not a pharmaceutical. We're not paying for it. The argument at the time of denial was solely that it's not a drug. The petition that was in front of the judge was not a review petition to get the definition. It was a penalty petition. So the judge looked at whether or not it was part of the plan of treatment, and agreeably, it must be part of a plan of treatment. Claimants cannot be going to a gas station on the turnpike and saying, hey, this looks good, I'm going to give this a try. It was not a self-administered treatment plan. It was discussed with the doctor. When a doctor writes a prescription note, a single pad of paper smaller than this, they're not writing the entire conversation. They're writing what the person needs to get. And the prescription itself says CBD oil / topical. The conversation was try them, see what works best. The initial prescription that was submitted to the defendant, there was an oil and there was a topical. And claimant testified, and the judge credited that he tried each type in accordance with the packaging directions, found the oil to be more effective, and every receipt after that date was only for the oil, not the topical. So the whole argument about claimants doing their own treatment plan is false. That is not part of the record. The treatment must be in accordance with the plan. And if claimant is treating off plan, utilization review. That's not what this is. But there was a utilization review. They got one. The doctor specifically addressed CBD. They did appeal it. It went in front of a different judge who found the treatment reasonable and necessary. So one judge defined it as a supply. Another judge found the treatment plan was reasonable and necessary. The issue here is whether it's a medicine or a supply. I believe that the court got it correct. It fits under either definition.
Don't you think Judge Wallace had the better of it? Because, as she pointed out, they define supplies so broadly that it would devour, it would encompass the medicine as well. You just have medicine, the word medicine would just be mere surplusage. Why shouldn't we adopt Judge Wallace's view in concurrence that this was in fact a medicine, saving supplies for things like gauze, syringes, bandages that are in stock?
I absolutely agree, and that was my argument in front of the judge, and the judge instead defined it as a supply. She explained why it was a supply, but my argument from day one was that it's a medicine. It falls under that definition. Does supply encompass medicines? The way it's presented, it absolutely could. The General Assembly chose to use two broad words adjacent to each other, medicine and supply. Later in that same section of the Act, they used the word drug. And with drugs, they impose different conditions, rules, and requirements than they do for medicines. Rules of statutory construction, the General Assembly knows the difference between the two words when they used them in the same section of the Act and apply different rules to them. They knew what they were doing. The remedial intent of the Act, the General Assembly wanted injured workers to have available items that could address their symptoms, whether it's pain, whatever their injury might be, address their symptoms, improve their function, and hopefully reduce the duration of disability so that those injured workers can get back to work. And in the long run, that would actually save insurance companies money, because using the phrase off over-the-counter, not in the sense of a drug, but things that an injured worker can get without the need for a prescription, are generally going to be cheaper than what the pharmaceutical companies charge for the dangerous opioids. And if the concern is the danger of CBD, there's two ways to address that: legislation or utilization review. They did the utilization review route, and the General Assembly hasn't come in and said this is illegal. The fact that the argument that this can be purchased in gas stations shows that it is legal. You can get it anywhere. So if it's that dangerous, why didn't the General Assembly step in? Equating it to medical marijuana is a false analogy because marijuana was illegal. That's why they had to go through that whole process that they didn't need to do for CBD oil.
Counsel,
So-
can you address the Commonwealth Court's cost containment analysis that somehow your healthcare provider who made this part of the treatment plan is not obligated to document the efficacy of it?
He did, and that was...
That's not what I'm asking. The Commonwealth Court seem to take the position that because you purchased the CBD oil, you don't have, the cost containment regulations don't apply at all.
True. So you have to separate what the provider's duties were and what the injured worker's duties are. The provider did fully fulfill his duties. He presented his treatment records, his bills, his treatment plan to the insurer. They did the utilization...
As a precondition to payment?
Correct. Well, yes, because once you file the request for utilization review...
No. I think the statute actually requires it before they can deny payment. The provider has to... Right, so it's pre-utilization review.
Correct.
It's information that a provider provides to the insurer about the treatment plan so the insurer can decide whether to seek utilization review.
Correct.
Did your provider do that?
Yes, and that's why they filed the utilization...
So why did that's the second issue in this appeal, and the Commonwealth Court seemed to think that it wasn't required.
Because the utilization review petition was separate from the penalty petition. It was addressed in separate litigation. They didn't appeal that determination.
I read the Commonwealth Court's opinion as a little bit broader than that. They seem to suggest that because you purchased it and the doctor didn't give it to you, somehow, some way, you have no obligation to provide the cost, to comply with the cost containment regulations because you're not a provider, and ergo the doctor had no obligation either.
If that's the interpretation, I would disagree with that.
Okay, good.
Okay.
I was hoping you would say that.
Because I don't see that as the interpretation. I see the provider defined by Section 109 of the Act and the injured worker are separate entities with separate duties. The injured worker's duty, when they incur an out-of-pocket cost, is to supply prima facie documentation that the cost was incurred for something that is part of the plan of treatment. Injured workers are not just out there doing it on their own. That was the prescription and a report and claimant's testimony and the receipts. That prima facie documentation was presented to them to show it was part of the treatment plan. Claimant incurred the cost. Claimant submitted it to the defendant for reimbursement. The sole basis for denial, it's not an FDA pharmaceutical approved drug. That was the basis for denial, and that's why the petition was a penalty petition as opposed to a review, a modification, a prospective utilization review. It was because of the reason for denial that the type of petition was chosen.
Are there any other questions? All right, do you want to wrap up, sir?
Basically, the words of the Act are medicine and supplies. It is not drugs. The dangers associated with CBD require a legislative remedy or a utilization review. That's not what we're here for today. It does fit within the broad definition of medicine and supplies, as would an oatmeal bath or an aloe vera bath. They would all fit within that definition if it is part of the doctor's treatment plan, and the insurance companies have remedies to address that if they think they're not obligated to pay. Utilization review, IMEs, there are safeguards in the Act.
All right, thank you. Thank you
Thank you.
both. Mr. Minner, would you call the next case?
Jared Coleman versus Parkland School District, representing the school district, Mr. Timothy Gilbach, representing Mr. Coleman, and J. Chadwick Schmidt.
Good morning.
Good morning.
Under Section 709 of the Sunshine Act, prior to any scheduled meeting, an agency must post on the internet no later than 24 hours before the meeting an agenda listing every matter that will be deliberated at the meeting. If an agency does not provide such notice, Section 712.1 of the Act provides that the agency may not take official action on a matter of agency business except as provided in subsection B, relating to emergency business, C, relating to business arising within 24 hours before the meeting, D, relating to business arising during the meeting, or E, relating to agenda changes. In this appeal, we must determine whether subsections B through E constitute 4 standalone exceptions to the notice requirement, or whether subsection E is a separate provision which sets forth the procedure for amending the agenda only after one of the exceptions in subsection B through D is met. Please proceed.
Good morning, Your Honors. May it please the Court. My name is Timothy Edward Gilsbach, and I have the pleasure of representing the Parkland School District. The issue, as noted in this case, is whether or not there are 4 standalone exceptions to the 24-hour notice requirement.
Sir, could you pull the microphone up a little bit? I think you're a little bit taller than the last advocate.
There we go. Is that better, Your Honor?
Yes. Thank you.
Perfect. Okay.
And that way you don't have to slouch.
Understood. Thank you, Your Honors. And we believe that both the text of the statute, the structure of the statute, as well as the legislative history confirm 4 standalone exceptions. Let's start with the text of the statute. The text of the statute in provides that subsections, the exceptions are in B, C, D, or E. In traditional rules of statutory construction, the word "or" means if there's a list of items, any one of those will meet the requirement. And therefore, the only other way to interpret that, as has been proposed by both both the Commonwealth Court as well as Appellate, is to replace the word "or" with the word "and." And that could mean one of 2 things. On one hand, it could mean and all 4 of those need to be met. Clearly, that's not the case. Everybody agrees that any one of the other 3 by themselves is enough. But instead, what they have proposed is sort of reading it as a word "and," but more of a sort of, well, you can meet one of those 3 and you've got to meet this 3rd requirement. But the statute doesn't say anything like that. There's nothing in the statute that would remotely suggest that's the case. In addition to that, if you look at the structure of the statute, that confirms that understanding. Because while it might be rational to look at subsection E and say, well, wait a minute, that perhaps is a mechanism to apply these other 3 exceptions, subsection F very clearly is a mechanism by which you apply the exceptions. Subsection E and subsection F is not listed in subsection A. So what you have is, on the one hand, you have subsection F. Everybody agrees that's a procedural mechanism. On the other hand, you've got subsections B, C, and D. Those are clearly exceptions. Subsection E is treated in the same way as the exceptions, not the procedural requirements.
F specifically talks about items added to the agenda, and only E expressly talks about adding items to the agenda.
I'm sorry, Your Honor.
Subsection F.
Yes.
Talks about items added to the agenda, right?
Yes, at the meeting.
And only E speaks specifically to items added to the agenda.
I think, as I interpreted it, subsection F is what you have to do if an item is added to the agenda.
Right, but of the list of B through E,
yes,
only E speaks about adding an item to the agenda. There's nothing in B, C, and D that talks about altering the agenda.
I understand. Sure, I understand. I hear your question, Your Honor. And I think
and on top of that, F talks about in this section, adding an item to the agenda in this section.
Correct.
Right. But again, B, C, and D do not talk about altering the agenda. Only E talks about altering the agenda.
Correct. I understand. And I think that the reason that they do that is that subsections A, B, C, and D speak of various options of the types of items you can do, but subsection E provides a mechanism, and in fact it's the only mechanism with the board itself can amend its own agenda should it choose to do so at a meeting.
But you said E is independent.
We believe E is independent, yes.
I know, I'm trying to understand that because you went to F.
Yes,
And F speaks in terms of items added to the agenda.
correct.
B, C, and D do not require any alteration of the agenda.
Well, I don't know that the board, I think the board would have to amend its agenda. If you were going to take an action under B, C, or D.
Then what's the
essentially-
point, what's the point of E? What's the point of B, C, and D if E covers all of them?
No, it doesn't cover all of them.
That's a fair question, and our position is that ultimately that's an issue that should be sent to the state legislature. And
See, I'm going to push back on that for a
Go
minute.
ahead.
I do have problems with the Commonwealth courts wrestling with what or means.
Sure.
But in light of E and in light of F, I wonder whether there was a scrivener's error of some sort here in listing B through E. And maybe it should have been B through D, because B, C, and D are specific things, specific topics. E is not the type of thing we would expect to be in a list like that. E is a procedural device that would seem to cover the items that preceded in the list. And you started with the idea of when items are in a list and there's an or, they're all supposed to be treated independently. But that list has to be similar in kind and subject and standard. E does not look like B, C, or D.
Excuse me, Your Honor. I agree. E is clearly much broader than the other exceptions. But the issue, of course, you have is that the state legislature. This wasn't simply an issue of they made a mistake in drafting the statute, because subsection E is specifically listed in subsection 8. Subsection F is not, and I think that's.
That's what I'm saying. You're assuming that isn't a mistake. Why are you assuming that's not a mistake?
Because if the purpose of subsection E is a procedure, just as subsection F is a procedure, those are separate. That would not be included in the specific language that says you give 24 hours notice unless, and then there's this list of these subsections, and it includes all of those.
So if I could follow up then.
Sure.
In A, we read, except as provided in subsection B, C, D, or E. An agency may not. So why is it inconceivable that the General Assembly would have given us both substance and procedure in that litany? In other words, that B, C, and D spoke to substantive exceptions, right? And then E, except as provided, so E is providing a process for this.
Sure. Understood, but where you run into a problem with that is, first of all, that's not what the statute says. The way you're reading it that way, what you're really saying is, except as provided by subsection B and E, or C and E, or D and E. Essentially, what you're saying is they would have to meet both the requirement of B, C, or D, and meet the requirement of E. But that's not what the statute says. And certainly, and again, I think the appellee raises concerns about public policy and the like. That, if in fact the state legislature made a mistake, they can go back and fix it. And in fact, the plaintiff in this case is uniquely in a place to do that. He is a member of the state legislature. If he felt that the state legislature made a mistake, they can amend it and go back and fix it.
The question goes to the question of whether the statute is ambiguous as it is written. You look at the entire section, you don't look at the one word. You have to look at the section as a whole.
Sure.
And I'm having a difficult time, and Lord knows I don't find ambiguity too often in statutes, but this statute seems, there's at least a very good argument of different interpretations of this statute, given how it is set forth, given how F is worded, given how E is not worded the same way as B, C, and D. Just looking at the entirety of the statute, why is it not reasonable to say that it's ambiguous and we apply the principles of statutory construction to determine what the legislature's true intent was?
Sure, and if you go to that point, and
so your primary argument is it's not ambiguous.
I do not believe it is ambiguous simply because.
Well, then, if it's not ambiguous, what was the purpose of having B, C, and D? You didn't need them. You just have E, and that devours everything, right? If you're right, and there's no ambiguity, then why would you need B, C, and D?
Well, I think the short answer is, I think certainly the legislature may have said, look, these are the things we anticipate this will occur under. These are the kinds of circumstances, but also leaving the reality that there may be circumstances outside of those three ranges.
But a majority could, pardon me, but what am I missing? So if you're right, and I was thinking when I was reading Judge McCullough's dissent, I was thinking this, if you're right, and E is doing what you're talking about here, would I be correct that you don't need B, C, or D at all? It would be like saying, except as provided in, well, I'm not coming up with a hypothetical, but they've sketched out these three scenarios, B, C, and D. And then the or is this other category, E, which is everything. A majority can do whatever it wants anytime.
Correct. I understand your concern, Your Honor, and sure, that is a concern. The one subsection does talk about concerns raised by the public. Presumably, that's something that the state legislature had concerns about. And I think too, if you move to the phrase of it's ambiguous, we start to look at the legislative history. The only reference anywhere in the legislative history about the number of exceptions is when this was reported out of committee, and they said 4 exceptions. That is, there is conversations about in general terms that there's exceptions, but the only specific reference anywhere in the legislative history about the number of exceptions is when this was reported out of the committee. I believe it was in the House, in which they said 4
Let me just try one more time
committees.
and then I'll stop on this.
Go ahead.
So, under your reading, and tell me if I'm wrong about your reading, under your reading and the dissent's reading, under the rubric of E, the board could, by a simple majority, change the agenda in any way it deemed appropriate, and period. And therefore, the pains to which the General Assembly went in enumerating B, C, and D were a complete waste of time and essentially entirely meaningless.
Well, if you read the text of the statute, that's absolutely 100% correct. I think what you're hearing, counsel, is individuals on this court who are textualists who say we don't want to look at the General Assembly's intent, we want to look just at the text. Yet the clear intent of this particular statute was for notice to be given to the public. What Justice Weck is pointing out, that if we accept what your version of this particular incident is, or your reading is, E eats the entire statute because it circumvents A, B, C, and D. Correct? And your position is that probably, it's textually speaking, that's 100% correct, but the General Assembly should fix this because it's their screw-up.
Fair enough, Your Honor. Yeah, that is essentially the position I'm taking. Yes,
So
I do.
Before you take that position.
I'm sorry.
Before you take that position, could you look at it from a different perspective, that even if you are a textualist and you're reading this exactly as written, that E does not really mean that the items in A through D would ever have to be included in an agenda, but rather would be covered under the situations that arise on A, B, C, and D, and then reflected in the minutes post-meeting rather than ever being added to the agenda. Is that a plausible reading?
I believe you could read it that way, yes, in the sense of, excuse me. Yeah, I believe you could read it that way, that E is sort of, we're changing the agenda, the other things may come up, they may do something with them. Maybe
and don't necessarily need to be part of an amended agenda. They're just handled during the meeting to be reflected later in the minutes. Is that reasonable?
Sure, and especially with respect to subsection D, and having sat at numerous school board meetings, the public raises a concern. It very clearly says the board can direct an administrator to go do something. Sure, that would not be an amendment to the agenda.
Well, and if that's the case, then maybe there's no Scrivener's error and maybe there's no ambiguity.
Well, except you have to deal with F.
Well, I was only getting to E.
I mean, I think that's a fair reading, except for F. The problem with F is it makes it look like everything in B through E is is an amendment to the agenda.
Yeah, I believe, Your Honor, that would be, well, it says if action is taken, and I guess the question becomes
Yeah,
is...
but it specifically says added to the agenda.
Yes, it says the minutes shall reflect it, but it also says added to the agenda.
Right.
But it also talks about...
Under this section.
Sure. But I also say, but it also the other component comes up as if action, and I guess the other component that comes up with that too is specifically when I'm looking at subsection D, there may not be a formal board action. It might more be go do something to the administration, I think. So that's, my interpretation of it is, I don't believe it's ambiguous. I think that they use the term or, and that means or. That means anything in that list is appropriate. And the cases that are cited both by the Commonwealth Court and by Appellate that talk about sort of using the word or to mean and are not in this context in which we're in a list of exceptions. It's instead when we're in a context in which the specific case were potential penalties that could be applied, and I apologize, I forget the name of the case, but there were specific penalties, and the court basically said, okay, yeah, you can put one or all of these. In that context, that's a different context. In this context, we're talking about exceptions to a general rule, and when you use the language or, the statute's very clear. In terms of statutory interpretation, that means or. Any one of those four would meet the requirement. And to the extent that there are concerns that sort of that exception interpreted that way would sort of eat up the rest of it, I think that's a legislative issue that goes back to the legislature and says, well, okay, you've done this. If it's not working, or if there are these parade of terribles that some of the amicus pointed out that might happen if boards can do this sort of thing, then the way to fix that is go to the state legislature. Lastly, I would note, especially in the context of school boards, these are elected officials. At the end of the day, if they start doing all kinds of crazy things at board meetings and adding things without people showing up, they're subject to the electorate. And prior to 2021, there was no limits on the ability to do anything. There was no requirement to provide notice prior to 2021. So the state legislature created a clear general rule, but clearly created exceptions. And I believe that subsection E creates an exception that permits for the very real reality that there are times things will come up that aren't considered in the other exceptions.
All right, any other questions?
Thank you, Your Honors.
All right, thank you. Let's hear from opposing counsel, Mr. Schmidt.
Thank you, Justice. I'm going to lower this because I'm much shorter. My name is Jay Chadwick-Schnee. I'm here on behalf of Appellate Senator Jerry Coleman. And I noticed that Chief Justice Todd mentioned justices in the courtroom and some portraits outside. I wanted to reference a different justice, Justice Brandeis, who once said that sunlight is said to be the best of disinfectants and the electric light the best policeman. And this is what this case is about here today. It's about open meeting requirements and the Pennsylvania Sunshine Act.
You just won over Justice Wex simply by quoting Justice Brandeis.
That's a good rule of thumb. Do you know that when Brandeis was at Harvard Law School, speaking of light, that the lighting was so bad that his eyesight was damaged, and until he recovered, he had to have another student, a friend, read books to him. And he still collected the highest GPA ever there.
That's impressive.
But it's only Harvard, so, you know.
Counsel, if you can weave in a quote from Oliver Wendell Holmes, I think you can just walk out the door and drop the mic.
Unfortunately, I don't have any in my back pocket, Your Honor. I apologize.
You can submit a post-argument.
Well, fair enough. And I think the issue here today is what Justice Brobson and Justice Wecht and others mentioned, is that appellant's argument really renders subsections B through D of the Sunshine Act.
Well, that's not really true, because E requires majority vote of all the individuals present, and section B and C and D do not have that requirement.
Right, and actually subsections B, C, and D have no requirement or no procedure and no process about how an agenda is amended. Only subsection E does. And so subsection E requires that the reasons for amending an agenda be announced.
No, I don't read it that way. I read it that B gives you a special exception to amend your agenda when you have an emergency meeting on a matter of agency business relating to, and the Act specifies very clearly in subparagraph B. C allows you to add business within 24 hours before the meeting, as specified in section C. And D allows you to add business arising during the meeting if you meet the requirements of subsection D. But only E requires upon majority vote of the individuals present. So whether or not E may include the items included in B, C, or D or not, it's contingent on you getting a majority vote of the members present.
Well, and Justice Mundy, I would respectfully submit that all agencies can only act through a majority vote of a quorum of its governing body.
Well,
So-
absolutely, but you could have less than a majority vote saying we don't want to hear it.
Well, right, but in order for emergency business to be conducted under subsection B, a majority of the board has to say, we want to take this action. In order for any action to be taken under subsection C, a majority vote of the members present have to take action on it. Same thing with subsection D. And I think subsection C really highlights, in this particular factual scenario, the problems with appellant's interpretation. So subsection C, as Justice Mundy pointed out, provides that for business that arises within that 24-hour period between when the agenda is posted publicly and when the meeting occurs, an agency can't take any official action on that item unless it's de minimis in nature, it doesn't involve a contract or an agreement, and it doesn't involve the expenditure of agency funds. In this particular case, the record before this court, reproduced record page 79A, provides that the reason why the collective bargaining agreement at issue here wasn't on the agenda was because that day the teachers union had voted to approve it. And so it arose in that 24-hour period. So if subsection C prevented the district from taking any action on this collective bargaining agreement because one, it's a contract, two, it does involve the expenditure of funds because there's a 2.9% pay increase in there, and three, it's certainly not de minimis in nature because it involves the terms and conditions of employment for hundreds of district employees, the district could not take any action under subsection C. So to Justice Weck's point, subsection E would swallow the whole. You know, it would render completely this prohibition under subsection C meaningless.
So why isn't that an issue for the General Assembly to take up, since they were the ones that drafted it, and they basically drafted a statute that provides for one subsection to swallow the rest of the entirety of the whole? In other words, why are we being asked to fix their mistake?
Well, Your Honor, I think the problem is that's what this court is designed to do, unfortunately, to a certain extent.
Yeah, but there's nothing, we can only do so if we find an ambiguity in the text of the statute. The statute's pretty clear.
Well, I think every member of the Commonwealth Court below found that it was ambiguous in some way. So the majority certainly found it was. Even the dissent, Judge McCullough's dissent, noted that there were clearly some irregularities.
Tell me what you find ambiguous.
Well, I think the problem is is how do you interpret subsection E while giving any effect to subsections B, C, or D?
Yeah, but that's not an ambiguity. I mean, that leads to an absurd result.
Right, and under the rules of statutory construction, we certainly can't have an absurd result. That's not what the General Assembly intended.
Actually, under the rules of statutory construction, you can have an absurd result. As long as the General Assembly passed an absurd statute, you can have an absurd result.
Fair enough, Your Honor.
I mean, you don't get to the, let me be careful, you don't get to the statutory construction presumption of absurdity against absurdity unless you apply the rules of statutory construction. You don't apply the rules of statutory construction unless the statute is ambiguous.
Correct, Your Honor. And what I would say to that is under the rules of statutory construction, the way you interpret the plain language of a statute is within its surrounding context. And so going back to subsection A of 712.1, it doesn't make the surrounding context doesn't make any sense. The entirety of section 712.1 provides reasons for amending an agenda and a process for amending an agenda.
Yeah, I want to ask you about the agenda thing. Who creates the agenda for the school board?
So I think that very likely differs between each individual district. I would suggest.
Well, I'm thinking about this school board. Who creates the agenda?
I don't know the answer to that, but I would suggest it's probably a combination of the superintendent and the school board president.
Right. It's not the board itself. So if that's true, maybe E is a standalone because the board doesn't create the agenda. The board meets, it confers, it deals with business. So maybe the statute B, C, and D is sans agenda, has nothing to do with the agenda. It just allows the board to take action off agenda. under certain circumstances. And if those circumstances aren't present, it has to go to E and actually formally amend the agenda, a document that they didn't create in the first place.
Well, I think that respectfully ignores some of the realities when it comes to school boards. You're dealing with elected public officials that are working for no pay, that are really deferring their functions in a lot of ways to the superintendent and sometimes the board president. So if subsection E is its own separate standalone exemption, there's no reason to have a separate subsection for emergency business, for example. There's no in subsection D, if a resident or taxpayer, which could include a member of the governing body, for example, raises an issue to the board during a public meeting, the agency still can't take any official action other than to refer it to staff unless it's de minimis, doesn't involve a contract, and doesn't involve the expenditure of funds.
In other words, just a similar question I asked opposing counsel. Is it your view that if appellant is correct, if the dissent is correct, then all the work done by all the work done by B, C, and D could be done by E?
Correct. There's no other way to read that, because if, as I said here, with the collective bargaining agreement at issue here, it arose in that 24-hour period. They could not operate under subsection C. It was a prohibition. But then they're arguing here today that subsection E allowed them to do whatever they wanted for any reason. You know, and I think what's important to know too is that Appellate didn't identify what reasons they had to list, right? So it could be any reason.
Yeah, but
so
counsel, they're making that argument because the statute says they can do it. I think that's the problem we run into. I mean, I'm the newest member of this court, and I'm struggling with text versus intent. I mean, we often have people come in here on both sides and read the same exact intent or statute and tell us it means completely different things. In this particular case, we had an amicus brief, I believe, by the Republican Senate, where the Republican legislature said, no, we didn't mean what we said. We meant something else. Our intent was something else. So what are we to do with that particular argument?
Well, I would say, actually, Your Honor, I would point you to subsection E, subsection 1, which talks about the reasons for changes to the agenda shall be announced at the meeting before any vote is conducted. Those reasons are contained within B, C, and D. So in terms of the Republican caucus's argument, I think they did a very nice job of talking about the legislative history.
Sure,
intent. I'm honor-bound to say that.
When the text says something else? That's what we're struggling with. I think what you're seeing here is, twisting yourself into a pretzel to figure out. We know what the intent was. The intent was clearly, as you just pointed out at the outset, the quote from Justice Brandeis. The intent was to let the public know what's on the agenda so they could come to the meeting and have a voice and be heard on those particular subjects. Subsection E basically allows the board to do whatever they want to do and not let the public know and then tell them afterwards what we did, which, technically speaking, violates both the spirit and the intent, but not the text.
I would agree with you, except for your last point about the text. I think it does violate the text because the only way to read Section 712.1 together, giving effect to all of its statutory provisions as the rules of statutory construction require, is to read it as B through D give the reasons, subsection E gives the process. And the reasons that...
Then why didn't the General Assembly say that?
Sometimes the General Assembly is not the model of clarity, Your Honor.
Sometimes.
Counsel, I guess the problem I have with this is you're not asking us to interpret this statute. You're asking us to rewrite this statute. You're asking us to read or E out of this, and frankly, I don't know how you get beyond it. I mean, I understand all the arguments that we're hearing about they couldn't possibly have intended that. Well, if we say we're interpreting this statute as written, it seems to me to be an easy fix for the legislature to go in and take out or E and change it to B, C, or D, and then it's over. I mean, but we have to rewrite this. And if you're arguing it's ambiguous, and we start looking at legislative history, maybe yes, maybe no, legislative history refers to 4 exceptions. So are we supposed to ignore the fact that it refers to 4 exceptions when there are 4 exceptions? You see what I'm saying? I mean, if this is an obvious an error, as you suggest it is, to me, the only way to fix it is for the legislature to fix it.
I would say two things. One, on the legislative history front, those were remarks made by a House staffer, not by a member of the General Assembly. So I'm not necessarily sure how much weight it holds.
Right.
And then
Not a whole heck of a lot.
Well, but our law also doesn't give a lot of weight to the statement of a single legislator either.
Correct.
Legislative history is amendments. You know, what amendments were made at this point, what did the bill look like, what changes were made. Statements of a single legislator are not legislative history.
I agree, Your Honor. I take that point. And I think the Republican caucus does a nice job of spelling out the legislative history here. But the other thing I would point out to Justice Donohue's question is what the Commonwealth found in page 11 of their opinion, which noted that the conjunction or must ordinarily be given disjunctive meaning unless such construction would lead to an absurd result. And that's exactly why we're here today, because it does lead to an absurd result. So even though it uses the word or, and even though that's not a model of necessarily clarity, in this case, because it leads to an absurd result, because E would swallow the whole, E eats everything, that's our argument here today. And the only other comment, if I could, Chief Justice, is the other aspect, the other problem with this is that it really prevents the public from having the ability to really meaningfully or offer any kind of public comment whatsoever. Because if the public has no notice of what items are going to or may be before a government agency, they may choose not to attend. And if they choose not to attend and an item is added, they have not witnessed the deliberations of the agency, borrowing from the language from Section 702 subsection A. And if a person shows up at a meeting, that person is likely going to be completely unprepared to offer any kind of meaningful or robust public comment on whatever item is added to the agenda, because that person had absolutely no prior notice that the item would be at issue during that meeting.
And that argument would be germane if we find this ambiguous, which it pretty clearly is ambiguous, and we are probing for the purpose of the statute, right?
I agree with that, Your Honor.
All right, thank you very much,
Thank
both
you.
of you. Mr. Minner, would you call the next case?
Simone versus Mohammed Zakiul, representing Ms. Simone, Ms. Zakiul Morgan, representing Mr. Zakiul, Mr. Martin Durden.
No, I'm good. Thanks.
Good morning.
Good morning.
Appellant initiated a negligence action against her landlord after she was injured when she slipped and fell on an icy patch at the bottom of her rental unit stairs. In this discretionary appeal, we must determine whether appellant's lawsuit was properly dismissed for the failure to join an indispensable party, specifically the landlord's brother, with whom the landlord owns the property as tenants in common, even though the brother does not have possession or control over the property. Please proceed.
Thank you. May it please the court, and good morning. Jacqueline Morgan for the appellant, Nicole Simone. A tenant in common who doesn't exercise possession or control, essentially an owner out of possession, bears no liability whatsoever under Pennsylvania law.
Can I stop you there?
Sure.
What's your authority for that statement?
The restatement.
And when did
of
we
torts.
adopt the restatement?
In 1965.
And what was the case?
The case that adopted it?
Yes.
I don't have that authority. I'm sorry, it was originally published in 1965. I have...
no, I'm asking...
I've cited the cases that...
I know when the restatement was published. I'm asking, when did this court adopt the restatement, second, that you're referring to here? I know the Superior Court has talked about it on a couple of occasions. When did this court adopt that?
Yeah, I don't know the exact year, but it was certainly adopted at the time of this case, and my citations in my brief address that. In any event, the black letter law in Pennsylvania is that in order to have liability in a premises case, liability is not based on ownership. It's based on possession. you must be a possessor of land as defined within the restatement.
But wouldn't a bright line rule for our common law be more clear than the state of affairs that brings us here today? If we said that tenants in common were per se indispensable, I mean, first of all, I think we should dispense with the notion that we're bound in any way by any of the reason we're here. It's a first impression matter.
Yes.
So if we want clarity, predictability, and fairness all around, wouldn't a bright line rule making them indispensable the best avenue toward justice, whatever that may be in a case?
It certainly would, because there are no other cases on this issue outside of Minner, which isn't the same issue, and I'll get to that. But ordinarily what happens in a premises liability case when you name multiple parties and all the dust settles, you let out those that aren't in possession. And an owner out of possession is a defense to a premises liability claim. And
I've never seen a premises liability case tried that way. I mean, that's what I'm struggling with here. It's sort of independent of the question of who an indispensable party is. This notion that an owner of a property has no liability for personal injuries that occur on that property is foreign to me. It's just foreign to me. I mean, it's based on some notion that you can off-put your ownership responsibilities. And that's why I'm asking you the question, where does that come from? I mean, the times in which appellate courts in Pennsylvania have talked about liability of possessors of property generally deal with situations where the possessor is not an owner. And so therefore you can be liable for what happens on the property. But I'm troubled by this broad proposition that your entire case is based on. And I'll say it again, I'm not so sure it goes to who is an indispensable party. I'm just saying that you are starting with a premise and asking this court to write from a premise that I'm unfamiliar with. I just don't know of the case that would establish that ownership of property does not have attendant to it responsibility for what happens on the property.
Well, again, it is black letter law, or jury instructions are based on the restatement, and the jury instructions and restatement specifically state that to be liable, one must be a possessor of land. And those various sections of the restatement are in my brief.
Yeah, but counsel, I think the question though is not every possessor is an owner.
Correct.
But isn't every owner a possessor?
Correct.
No.
Where's that principle come from? I think that's the question Justice Donahue was asking you is, I understand what the restatement says, because a possessor is liable because the possessor has to be shown to either have had knowledge of the dangerous condition or should have had knowledge of the dangerous condition. And liability can attach to, a possessor, meaning someone who's renting the property or something like, I don't know, but in addition to the owner.
Exactly.
But where's your principle that an owner is not a possessor?
There are plenty of situations where an owner rents out their entire house and does not retain any responsibility regarding maintenance, snow removal, etc., and relinquishes complete control to their tenant. In that case, they're an owner out of possession, and if somebody slips on the sidewalk and the tenant didn't shovel the snow, the owner is not responsible.
Why is it better for our common law? Why is it better for our common law going forward that we consign all these matters to extensive discovery along those lines, rather than a bright line rule that would say the deeded owner is presumptively indispensable to the adjudication because he or she has an interest, as an ownership interest in the property?
Well, a bright line rule would certainly clarify things, and I think this court could certainly clarify the Minner case. And one of the points I want to make is that even though the restatement wasn't adopted in the Minner case, which was decided in 1949, that court did state that exclusive possession and control is essential to liability. So back in 1949, even though the restatement wasn't in existence, the Supreme Court at that time applied the very same legal principles that are in the restatement today. And if you allow me to do the analysis in conjunction with the restatement, you'll see that that is the case. The lower courts in this case latched onto the one statement in Minner where the court said, having grown out of liability, having grown out of ownership, requires all the brothers in that case, the tenants in common, to be joined. The only reason ownership became an issue in Minner was because we had 3 brothers who were devised a property from their uncle who had passed. And lo and behold, at some point, someone fell on the property. The brothers had not taken possession of the property. They tried to escape liability by saying, oh no, we didn't accept ownership of this property, so we don't need to be a party to this lawsuit. Well, the Supreme Court quickly dismissed that argument and said, no, you never renounced ownership, so therefore you are owners. And
but you can't renounce ownership. I mean, there are deeds to property through which one traces the ownership of the property. It may be in certain situations that an owner hires someone else to care for the property. And if something happens on the property when someone else is managing it for them and in possession of it, the owner may be indemnified by the person who is managing the property, but the owner is an off-putting responsibility for the property. I mean, that's sort of I mean, and I'll say it again, and maybe, you know, because we took this as an indispensable party case, and you know, obviously that's the issue, and I could never get over the legal principles upon which this argument was based. Now, it may very well be that you don't have to sue each owner of the property in order to bring a claim for personal injuries that occur on the property. But that doesn't mean that each owner isn't responsible for what happens on that property.
the point isn't whether somebody can renounce ownership. Clearly, if you have a devise according to a will, you can refuse that and allow it in the estate. The brothers didn't do that here. But the point that I wanted to make was, if the Minner Court meant to say that liability and indispensability is based on, or should be based solely on ownership, then the opinion could have stopped right there. But it didn't. The court went on to examine possession and control, and they stated that exclusive possession and control is essential to impose liability.
Regardless of what was said there. Under your scenario, because we're not just deciding this case about these two brothers, Zakiul and Zakiul, right? This is going to be a decision that's going to affect Pennsylvania's common law for all these situations, right? So if you prevail, how are the interests of the deeded owners who are not there on the spot protected? How do they protect their rights? Their hostage, their interests, their ownership interests, and potential prejudice and catastrophic losses to their interests, preclusive losses to their interests, are at the whim of the tenant in common, because they don't even have to get notice. A whole lawsuit could proceed to verdict without them ever even knowing. They're not all going to be brothers.
the tenants in common have a divisible interest, and if there is a judgment, then a partition action is filed. They are protected.
That's small solace. If I'm gonna have a
That's
massive,
a prejudice.
Yeah, massive verdict entered against me. I own this property. This schnook I own it with doesn't tell me, and I wasn't required to be joined, and blows the case. And now I'm out millions of dollars, and my solace is there's going to be a partition, and maybe I'll get a check down the line.
But if there's
If
there's no liability against the owner out of possession, then that's a disingenuous lawsuit.
Maybe I would have wanted to hire a decent lawyer. Maybe I would have wanted to take a different litigation strategy. Maybe I would have wanted to advise settlement. I mean, we call these things due process, the opportunity to participate in litigation affecting my interests.
Well, I think the distinction you were kind of missing here is on tenants in common. If Justice Weck and I buy a piece of property and I'm the schnook, in this situation anyway, if I'm the schnook and you name me, and without naming Justice Weck, if the judgment's entered, it's entered against my interest in the property, not Justice Weck's. It doesn't affect him. So in other words, if we own a piece of property that's worth $1 million, there's a $500,000 judgment against me. It doesn't affect Justice Weck's interest in the property. It affects mine. That's your argument, right?
Exactly.
Yeah, but the whole is greater than the sum of its parts. And again, this partition action is not a cure-all for a lucrative property, right?
And a partition action also affects would affect Justice Weck's interest in the property as well, because it would be a for sale. Then he would have to go into business with somebody else or liquidate his particular interest in the property so you could execute on your judgment. So it would affect.
We're jumping a little forward. Can you help educate? Can you help educate me for a second? Because I thought we were talking about indispensable parties for purposes of getting not an in rem judgment, an in personam judgment. We've kind of jumped the shark to execution of the judgment.
And that's why I said I wasn't. That's the point that I made earlier about I'm not certain about the indispensable party issue. I'm more concerned about the general principle of law that you're suggesting exists in the Commonwealth of Pennsylvania, that an owner of property, by mere ownership of the property, has no liability for personal injuries that occur on that property. That, I'm saying, I do not believe is the law of the Commonwealth of Pennsylvania.
Yeah, and let me just help you with that, because again, I'm looking at this I'm not looking at it as an in rem judgment. There's no in rem judgment here. This is an in personam judgment that is being pursued against the person who the plaintiff determines to be the one most responsible for the condition of the property. Sued them, argue they had notice of the condition, it was their responsibility to remedy it, they're responsible. Now, that schnook could, I assume, file bring in the other owners and seek to have them as additional defendants.
I don't think he's the schnook in that scenario.
Well, he unschnooked himself by bringing in the other owners.
Well,
I mean, we're going to all these permutations of what can happen, but and this kind of, I think, goes to Justice Donahue's point, is there may be many other people who have liability. All the owners may have liability. But the question is whether they're indispensable to the in personam judgment against one of the owners. Which
is a different issue, but and that's why I keep saying that. My disagreement with you and your brief is the general principle of law that you're stating, that mere ownership of property does not have attendant to it any liability for injuries that occur on it. I don't think that's the law in the Commonwealth of Pennsylvania. For reasons totally unclear to me, your client chose not to sue all the owners of the property. Generally speaking, in a premises liability case, the first thing that anybody does is goes to the deed and see who is on the deed, and spends a lot of time running around before the statute of limitation runs to make sure that you're suing everybody who is on the deed. For reasons unclear to me, that didn't happen here, which is why I think this is an issue maybe of first impression, because nobody does what your client did here, which is not sue all of the owners on the deed. Maybe that's okay for indispensable party purposes. Maybe that's okay, but we cannot start writing an opinion on this case based upon a premise that mere ownership of property carries with it no responsibilities for liability that occurs on that property. I mean, that's just not, that to me is, A, I don't think it's ever been the law, and B, I think it's terrible policy.
The liability comes from possession and control, and the negligence alleged, it arises out of the maintenance and inactions and actions in maintaining this property. The absent owner had nothing to do with that. He wasn't the landlord. The defendant in the action was a landlord. And again, there's no cases on point because typically owners out of possession are let out. But there is one very persuasive case that has adopted the restatement as well, and that's the Washington Supreme Court case where the management company of a mall was the named defendant and the owner was not. And the court said that the test isn't who is the true owner, it's who is the possessor. The test is who the possessor of land is. And that is consistent with Minner because, as I said, Minner then went to look at whether these brothers were in possession and control. If ownership alone was enough for them to decide that these brothers were indispensable parties, then the court would not have gone through the analysis of possession and control.
Wouldn't a better rule?
But they did.
Wouldn't a better common law rule be that the owners are indispensable, and that rather than having this fact-intensive morass of possession or not possession on the front end, you allow motion practice later by which the out-of-possession landowner could seek to get out of the case by reason of being out of possession?
Wow.
Because the reason I ask that is that would at least protect the process rights, the property interest, right, of the owner who allegedly is out of possession. Your approach, it seems to me, would have no recognition of the deprivation that he or she faces.
I don't know that that would be a better approach. I think you then risk flooding the court system and always having to drag in owners every time.
Owners are always sued. I mean, you're talking about this as though what we're discussing is the outside of the boundaries situation. I mean, you look at a deed before you bring a lawsuit based upon regarding property that's owned by someone. I mean, as I said, I don't know why that didn't happen here, and it may be this is why we never have actually looked at this issue before. But what we're talking about here is not an oddity that you sue the owners of property. I mean, your client was apparently in a situation where they knew who was managing the property. Correct?
Exactly.
Didn't bother to look at the deed.
But what you seem
There
to
was
be...
a problem with the deed, with getting the deed.
There you go. That's what happened here. And that's why we're here on this argument. Because the first thing you did was you tried to look at the deed.
What was the problem looking at the deed?
There was a problem getting it because there was a conflict in the address, and it didn't come back with the owners that were reflected, and I wasn't involved in that part of the case.
There's only one letter difference in the two owners' names, so that didn't have anything to do with it.
Yeah, I know. Well, that was confusing. Yeah. I mean, that was confusing,
well, as between the burden on a plaintiff to, and like Justice Donahue suggested, that the rarity of this is because, 99% of plaintiffs want to grab as many defendants as they can, right?
0.99999.
Right. So, in your scenario, shouldn't the burden be on the plaintiff to do his or her homework and mine the deeds and figure out rather than allow this shortcut, which again has, I think, constitutional implications?
Go ahead and answer that.
So ordinarily, as I said, being an owner out of possession is a defense, and typically once the dust settles and you figure out who's managing and who's responsible, who bears the responsibility, who's in possession of control, we stipulate the others out, or they often are entitled to get out a motion for summary judgment, or it's a defense in the case. That's why the black letter law, the restatement, is written as it is. If this case is allowed to stand, then the restatement is going to have to be written.
Well, we don't care about the restatement. It's a bunch of, I'm a member of ALI. It's a bunch of people, used to be Henry Friendly and, a lot of smart people, but it's still just a group of people who makes recommendations.
Wait a minute, I'm a member of ALI. It is a bunch of smart people.
But they're making recommendations to us. We're not making recommendations to them.
And I don't think this court has ever adopted the restatement that you're referencing. I mean, I did a search prior to this because I find this to be an intriguing argument. And the Superior Court has cited to the restatement second. But I don't think this court has ever adopted it. Should we not? I'm not sure that's part of the issue on this indispensable party point. But the premise that you're starting from here is really, I think, startling to most people.
Well, we're gonna figure that out for sure. But I just want to try to understand your approach here was that it didn't really matter if you brought in the second brother, because ultimately, as an owner out of possession, he was going to have no liability. That was your theory, right?
And he had no liability, and his brother exonerated him from it and said he absolutely had nothing to do with this property other than he contributed to financing. So if I help my brother out because he can't afford to buy a property, I don't want to be drug into a lawsuit. And usually, I don't know any owners out of possession who are jumping, on board asking to be sued. But the court in Minner clearly stated that and evaluated this case again under the principles of the restatement, which, even though it didn't exist, we can look to Minner for that guidance. And the only reason that ownership, or that the court said liability grew out of ownership, was because that ownership created possession and control, because they were all deemed in possession and control. This was a multi-tenant unit with one tenant, so that one tenant could not have taken control and nobody else took control. So the court said, because you are owners and you are entitled to occupation, as the definition in the restatement of tort says, that is what makes you liable. And that's what renders you in possession and control. And if you look at the definition of a possessor of land, a possessor is somebody who was either is in or was in with the intent to control the property. And if you're not either of those, which none of the brothers were in that case, then the court, item C, is a person who is entitled to immediate occupation. And who's entitled to immediate occupation but an owner? But if that alone makes them a possessor, then again, the restatement would have stopped right there, but it doesn't. And it says a person who is entitled if no other person is in possession. And in Minner, no one else was in possession. But in this case, Zakiul was in possession. And
the tenants were also in possession.
Tenants are not in possession. Possession is essentially equated with control. They weren't in possession. They didn't control.
They were in possession of their unit, but they weren't in possession of the common areas.
Right, exactly.
Okay, I think we understand your argument. We have a few things to figure out here, but we appreciate your position, and let's hear from your opposing counsel.
Thank you.
Madam Chief Justice, distinguished justices of this court, Attorney Morgan, my name is Martin Durkin, and I represent the appellee in this matter. What the appellant is asking this court to do is to set aside a rule that was promulgated by this court 84 years ago. Rule 2227A mandates that persons having only a joint interest in the subject matter of an action must be joined on either side as plaintiffs or defendants. This rule does not state anything about possession or control. The appellant in this case is asking this honorable court to set aside or to ignore the precedent from 1949 in the Minner case that specifically adopted Rule 2227A, and the issue regarding possession and control that counsel persuasively is arguing to the court that she says is stated in the Minner case and that should convince you to add that to the case, only had to deal with additional defendants who were mortgagees.
Counsel, let me ask you a similar question. Why can't justice be done in the absence of your client? I mean, bearing in mind what Justice Brobson raised, that this is in personam, not in rem. So, supposing a verdict is entered against mix-ups of fool and Zakiul, against the possessor, how does that impair your client's rights?
It doesn't impair it potentially impairs my client's rights because let's say that that the appellant prevails at trial and that there's a judgment against my client. That judgment ultimately, if my client cannot...
No, it's not against your client's...
He's the actual named defendant, I think.
Yeah, I'm the named defendant.
He's not the brother. The brother's never been here.
You're the named defendant.
Right.
A judgment is entered against you.
How does that affect the brother?
Yeah.
That's accurate. So if there's a judgment entered against my client, which could be the case,
yeah.
Then, and my client cannot satisfy that judgment, then ultimately, and it's not likely in this case because of other factors, but potentially, and this is my public policy argument, the property could be liened, and therein that affects the interest
No,
of the
that's only his interest can be liened.
Only his interest can be liened.
Only his interest can be liened. Only his interest can be liened. I mean, there's case law in Pennsylvania that stands for that proposition.
Yeah. Understand.
Could lead to a partition scenario.
Correct.
That's correct.
But counsel,
when
that
the
can
property's
happen.
sold.
That can happen in any negligence action.
Right.
Your client could get involved in a car accident and be named as a defendant and owe a crap ton of money. And if doesn't pay, their interest could be subject to execution through a partition action. A lien could be put on their interest. So does that mean that anytime a defendant who happens to own property as a tenant in common is sued in a civil action, any joint or tenants in common have to be notified and made indispensable parties?
Well, yes, we're arguing that is the case under Rule 2227.
So you jump past the in personam part and you fast forward to potential execution. And if you go through, that's how we're going to determine who indispensable parties are, if there's any assets that could potentially be at issue.
I don't think so, Your Honor.
What's 2278? Read 2278.
227A states, persons having only a joint interest in the subject matter of an action must be joined as either.
This is not
on
a
either
joint
side.
interest. This is not a joint interest. These are tenants in common. This is not a joint tenancy. This is not a joint tenancy with right of survivorship. And a joint interest means you own one half of the whole.
It's
Co-tenants.
several.
This is several. These co-tenants have a several interest, not a joint interest.
Your Honor, the Minner Court, the Moorhead Court, the Enright Court, these are cases from 49 1949, 1982, and 2003. The facts in the Minner case are strikingly similar to this case, and they were all, in that case, tenants in common with a joint interest. So this court...
What is a joint interest?
A joint interest, Your Honor, is an interest that all owners have in the property.
But this isn't an in rem action. It's not a quiet title action. It's not a dispute over the sale or property. It's not even an action relating to a municipal lien. This is negligence. It's like a car accident.
That's correct, Your Honor, and that's the same in Minner. Minner was not a quiet.
I understand Minner's.
Right.
Minner's your best argument. Just stick with Minner and we're done. To Justice Weck's point, is probably the easiest legal principle that you could possibly apply.
Right, and that is our argument.
I'm trying to understand why, in an in personam action, all owners of potentially executable property, for purposes of satisfying a judgment that has never been entered, an in personam judgment, are indispensable parties in every case. Because that's to Justice Weck's point. You're asking us to adopt a legal principle that I think would change common law in the Commonwealth of Pennsylvania. You're going to have to do discovery and aid of execution before you even file the complaint to determine what property you could potentially get to. And if there are joint owners, in your view, of potentially executable property, you have to name all of them as defendants because they're indispensable.
And it's our position, Your Honor, respectfully, that that's what 2227A says. That's what Minner says. And when you have an action against personal injuries, you've got to pull the deed. You've got to do your due diligence.
But the deed's almost irrelevant.
The reason you do that is to get as many defendants as possible, because there is liability that flows from ownership. I mean, this case could have been pleaded that the co-tenant was negligent in allowing your client to operate the property because of various X, Y, and Z reasons.
That's accurate.
He could have been sued. He just wasn't. We're here to answer the question: did he have to be joined? It's a whole different issue. Whole different issue.
Understand. It's our position that the rule, and that Minner adopting that rule, again going back 80 years, this is, counsel used the term black letter law, this is as black letter law as you can possibly get. All of the deeded owners of the property in an action stemming in personal injury have to be named as defendants. Otherwise, the court loses.
I'm thinking of Justice Brobson's point about pre-discovery native execution or anticipatory discovery, or call it what you will. Do you foresee a problem if your rule were adopted by this court with a not uncommon scenario where in the commercial space or residential for that matter, there are like obscure holding companies that have ownership interest and might be somewhat opaque somehow for the plaintiff? Would imposing this rule as a requirement rather than as a common course be burdensome on some personal injury plaintiffs? Is that a clear question?
It's kind of clear, Judge, but I would say that, in fact, that's exactly why this court in 1940 adopted Rule 2278 to take out all of those uncertainties. So if you're going to have a personal injury action that you're commencing in the court, you've got to name all of the owners, all of those folks who have a joint interest in the property. And certainly
you keep going to property, and that's
in the subject matter of the action.
Your principle is beyond that, though. Your principle is oh my gosh, it's like if a doctor performs medical negligence, right, and you sue the doctor for medical negligence, you do discovery to find out every potentially executable property that doctor could have. And if he or she jointly owns any property, maybe it's a car, maybe it's a second home, maybe it's stock, maybe it's any number of things. Your rule that you're saying here is you have to name every single person with that physician has some sort of joint property interest as a named defendant, even though they have absolutely nothing to do with the medical negligence.
Of course, Your Honor, that's not what we're suggesting. We're suggesting that we focus on the rule which says, which is the subject matter of the action. The subject matter of this action was the premises that was jointly owned.
No, the subject matter of
by
the action was
brothers.
the negligence.
That's correct, which is stemming from an incident occurring at my client's jointly owned property with his brother. That's our position.
Okay.
And that's true. That's true. But the only, if a judgment is entered and later execution takes place, or even before execution, a judgment is entered and a lien is placed, the lien would be placed only on your client's share of the property.
That is correct.
So if the property is sold, the plaintiff in this case would be paid out of the sale of the property to the extent of your client's interest. The other co-tenant's interest would not be affected. The co-tenant would receive his share of the sale of the property. That's why I think this whole issue of indispensable party really does have to come down to whether or not that co-tenant's interest is somehow affected by this lawsuit. And the answer is, I don't see how it is. I don't know how that is, just based upon the manner in which executions, and you might never get to the property. I mean, your client may own a piece of property on his own, and a lien could be placed on that other piece of property, and that would be the end of the story, and the co-tenant in this situation wouldn't be impacted at all.
That's accurate, Judge.
Collecting the judgment has nothing to do with who has to be sued in this case.
That's potentially accurate, Justice, but we don't know what the interests are vis-a-vis the joint owners of the property, of any property, when a lawsuit is commenced. So it's my client's position that 2227A protects the non-sued party's interest, because there could be all kinds of machinations that could exist with respect to the ownership of the property. And if there's a judgment that results in a lien on the property, it may be that the property could be sold and everybody goes the merry way, but that's just one scenario. There are many potential other scenarios where the non-sued party's interest could be encumbered, could be prejudiced by their not being able to participate in the litigation,
But if they don't
assert.
participate, don't they have a right to kind of seek to void the judgment against them?
Potentially, but that's expensive too, Justice. And that goes also to this issue of you're a non-party and there you are going along with your life merrily.
It's still 6 and 1/2 dozen the other, because if I'm an out-of-possession landlord, if I'm owner, and I didn't have anything to do with the ownership the maintenance of the property, and I get named, that means I have to go out, retain counsel, and either engage in pre-complaint discovery or file preliminary objections. It's still going to cost me money no matter how you look at it. In the scenario you just gave, doesn't the plaintiff file the lawsuit against the defendant at their own risk? If they don't name somebody that's potentially liable, they can't execute or enter judgment against that person because their due process rights are implicated.
That's right, but getting back, I understand what Your Honor is saying, but again, it's our position that the intent of 2227A, adopted by Minner, is that the non-sued party's rights also have to be protected, and that's
because the subject matter of the action is the liability associated with the premises. In order for you to prevail, must the subject matter of the action be a liability claim relating to the premises? Because if the subject matter of the action is a tort action, then thinking of Justice Robson's doctor, right? So you lose under that, because then say a physician owns a property and he or she is a tenant in common with some other person, right?
May I respond?
I'm just trying to walk through this because then you've got his car accident scenario.
Right.
How should we come down on this?
So it is different. So it's different than the Justice's oatmeal manufacturer claim. If we have one of those, it's different than the automobile. It's different than the doctor because the case law specifically states that in an action pertaining to personal injuries related to a premises. That's what Minner's all about. That's what Moorhead was about, and that's what Enright was about. Now, Moorhead and Enright, those dealt with a husband and wife situation, but all of those cases dealt specifically with personal injury actions pertaining to premises liability. So it is different.
But that's because they had liability for what happened on the property. Correct?
That's accurate.
Okay. I mean, it doesn't have to do with anything else. And your opposing counsel decided or didn't have any other choice but to only sue the tenant in possession of the property, therefore willing to forego any claim against the other co-tenants who may have liability, might have liability, but she just decided not to sue them. Why isn't that all right?
Well, Justice, I do need to respond that in the appellant's brief, the appellant states that my client never disclosed that the property was jointly owned with his brother before the statute of limitations had expired. However, the record in this case, 32F, I believe it is, or B, specifically has contained in there 4 interrogatory answers that my client gave before the statute of limitations had expired, saying, I own the property jointly with my brother, Mohammed Zakiul Alam. So it kind of gets to those issues as well, that the appellant did have notice prior to the expiration of the statute of limitations and chose for whatever reason, strategic or what perhaps other reasons, but Rule 2227A, get back to it, is designed to protect the non-sued joint owner. That's our position.
Okay, I think we understand both of your arguments. Thank you very much.
May we be excused?
Please.
Don't either of you slip and fall.
I did not mean to be sarcastic, sir. All right. Mr. Minner, would you adjourn for lunch? We'll resume at 1 o'clock.
We're in recess until 1 o'clock.
Good afternoon, everyone. The crowd is thinning, I see. Would you call the next case, Mr. Minner?
Commonwealth of Pennsylvania versus Harold Walker. Presenting Mr. Walker, Ms. Jamie Schmidt. Representing Commonwealth, Mr. Daniel Burnett.
In this case involving a minor's allegations of sexual assault, the trial court granted the Commonwealth's request to ask prospective jurors during voir dire whether they would be able to follow the legal principle that the testimony of the alleged victim standing alone, if believed, is sufficient proof upon which to find the defendant guilty of sexual assault beyond a reasonable doubt. The Superior Court affirmed, holding that the proposed voir dire question, which was based on Section 3106 of the Crimes Code, was not improper, as it accurately reflected the law and was designed to secure an impartial jury by exposing potential jurors' fixed opinions which were inconsistent with the statute. We granted review to examine the propriety of the Superior Court's ruling and to determine whether permitting the requested voir dire question denied appellant his right to a fair and impartial jury. You may proceed.
Thank you. Good afternoon, Your Honors. May it please the Court. My name is Jamie Schuman from the Allegheny County Office of the Public Defender. I represent the appellant, Mr. Harold Walker. And our argument is that the voir dire question at issue here is impermissible as a matter of law. The law states that voir dire must not be used to impanel jurors sympathetic to the positions of one party or to disclose what a juror's opinion would be under facts that were to be developed at trial. And that's what this question sought to do.
Counsel, why would it not be just to indicate somebody's bias, like the normal question? Do you have a member of your family who's law enforcement? Do you believe the testimony of a police officer more than you would an average citizen? They're asked all the time, correct?
Those questions are part of the standard form, yes.
So why can't the other side ask?
So this is different, Your Honor. What it's doing is giving the Commonwealth the tools to impanel people who agree that you can convict on little to no corroborating evidence. If people express doubt about the ability to convict on little to no corroborating evidence, it gives the Commonwealth the tools to strike them. It's especially problematic because a lack of evidence is a legitimate basis to acquit. The standard jury instructions for reasonable doubt state this. They state that the lack of evidence.
But isn't there a jury instruction at the end saying that what a lawyer says or questions is not evidence, it's the responses from the witnesses? And two, was there an inappropriate jury instruction that was not provided that would in fact make this a harmless error analysis?
So this question, if I'm getting you right, this voir dire question is based on a jury instruction that was given in this case as well.
You're saying that this is an inappropriate question.
Correct.
Matter of law, I don't know about that. But let's say the fact is it's eliciting bias or favoritism, whatever it may be.
Well, isn't it also just reflective of a principle of law? The question that's being asked, isn't that a true statement of the legal principle that the testimony of an alleged victim standing alone, if believed, is sufficient proof?
That's what I was getting at. But the appropriate jury instruction is similar,
right,
which in essence makes it harmless.
So I believe this is a structural error analysis, but before getting into that, this is it's an inaccurate version of a legal principle.
In what way?
So it doesn't include the requirement that you need to prove every element beyond a reasonable doubt. So the question says, if believed by you, the testimony of the alleged victim standing alone is sufficient proof upon which to find the defendant guilty in a sexual assault case. But it's missing that you need to find every element. So if you take this...
But isn't that part of the final charge?
Pardon me?
Isn't that final, that's part of the final charge. So under the totality of the circumstances, when a judge says at the end of the case, the defendant's been charged with these particular crimes, he then instructs the jury that they have to find each and every element of the crime charged, even if they don't do it in voir dire.
So it is part of the final charge, Your Honor, but it is out of context and misleading and inaccurate to have it in
How so?
voir dire, because if you take this question as it's written, if someone is charged with rape of a child, and 5 different charges, which often happens in these types of cases, if there isn't evidence of rape of a child, but the alleged victim's testimony shows evidence of the others, taking this at face value, you can convict across the board, and I don't think we can expect a layperson juror who is not a lawyer to be able to understand that you need to prove every element. So if someone is charged with aggravated indecent assault and indecent assault, and everything is proven but penetration, under the plain text of this question, it's okay to convict across the board. So this question contains a legal error, and I think that it's an error to give the question.
Share with us. It says, thus, you may find the defendant guilty if the testimony of the alleged victim convinces you beyond a reasonable doubt that the defendant is guilty. Would you be able to follow that principle of law? And obviously, as Justice McCaffrey just said, there's going to be instructions as to what the law is.
Right. So
what that question is saying is, if the witness testifies and meets the elements, that is sufficient. There need not be the missing gun or the smoking gun or the law and order, where's the DNA?
So even though there were jury instructions that provide more context, this is certainly misleading and confusing because it's out of context, but I think it's the wrong analysis to look at the end of the trial, because this question affects the composition of the jury, and it gets rid of the presumption that we have a jury that is fair and impartial.
How is that any different than saying, do you believe a cop more than a person?
A lay person.
Yeah, or an expert witness more than a lay person.
How is it any different?
Sure. Well, I think those types of questions that are, from the standard form, the cop, that's more about probing, fixed opinions.
But that's what this is.
So I think it would be useful to compare to the Commonwealth in this case also requested questions. Do you have you ever been an alleged victim or been accused of unwanted sexual misconduct? And I think those questions more go to a person's qualifications, whether they can be fair in general, whether they can listen impartially to the evidence, deliberate impartially, and impartially follow the trial court's instructions, because they go to someone's life experiences if they have bias. But I think, yeah.
When you ask if you believe a police officer more than a lay witness, you're trying to determine whether there is a bias in favor of police officers.
Exactly, and this is different.
This is asking jurors if they can follow the law.
So this,
or an inability to follow the law. I mean, or an inability to follow the law.
It's not just the general, can you follow the court's recitation of the law, which is part of the standard instructions.
Yeah, but
so
the particular jury, the particular voir dire question you're asking about are given after the general instructions. In other words, a panel comes into your room, right? You've been through jury selection. A panel comes into your room with 40 people. You give the general instructions. If they've raised their hand to a particular one, you mark down that they answered to a particular question, and then you do individual voir dire. This particular question that you're complaining about is given in the context of individual voir dire, and then you ask them whether or not you explain them to the law. If somebody says, well, yeah, I don't know if I can follow that. You explain them what the law is, and then you say to them, that's the law, that's how I will instruct you. My job is to instruct you in the law, your job is to follow the law. can you follow that instruction? And if they say no, they're stricken for cause. So there's a chance to rehabilitate them if they say they can't answer this or they can't follow this instruction.
But, Your Honor, I think the problem with this question is it's outside of the scope of voir dire to begin with, because it's not trying to expose whether you are that threshold question of whether you have bias such that you can't listen to all of the evidence and instructions.
Isn't it designed to dispel impressions that the public may have, this legal principle that it's okay to, the legal principle that says testimony of the victim alone, if believed, is sufficient proof to convict beyond a reasonable doubt. Isn't that legal principle itself a reaction to society today and all the, television programming on DNA and evidence, whereas there's this supposed impression in the public that individual testimony by a victim is not enough. You have to have all this other forensic evidence. So there is some logic behind trying to find out if a juror can follow this principle of law.
So, Your Honor, that wasn't the rationale that the DA gave at trial. This is a question that in Allegheny County, in this particular courtroom, it's routine practice to ask these questions in child sexual assault cases. And my point of view is that it's outside the scope of voir dire because it's not gauging qualifications. It's trying to find out the juror's viewpoint on a specific legal principle and trying to find people who are favorable to the Commonwealth's viewpoint that you can convict.
But it's not favorable to the Commonwealth's viewpoint. It's favorable to following the law. I think that's a reasonable question to ask if a juror, a proposed juror, is going to be able to follow a principle of law, which this is. Now, if this were not a principle of law, I'd agree with you. No, they shouldn't be asked this question, but I just guess I'm struggling to find the harm in asking the question whether a juror can follow this particular principle of law.
Your Honor, the harm is that it is designed to expose people who have leanings to one side or the other, and that's not the purpose of voir dire. The case law says that voir dire is to find people who are, fair and general, impartial, to listen to the court's instructions. Another problem with this is there is, a line of cases, a rule that says that questions in the nature of jury instructions are outside the scope of voir dire. Questions involving the definition of a legal principle, that's the scope of the trial court to give those instructions after the evidence.
Can I ask you about those instructions? Is it your view that the instructions that were given on reasonable doubt and the burden on the Commonwealth to establish every element of every crime charged did not cure the incomplete nature of the voir dire question?
Yes, that's my view.
And why is that? Given the small, my understanding of the incompletions, and tell me if I'm wrong, is the absence of the words beyond a reasonable doubt after the clause if believed by you in line 2. That's one thing. And then in the penultimate line, after the word victim, testimony of the alleged victim, it should have said establishes each element of the crime. Am I right? Those are the two?
Yeah, really each element is the main.
Beyond a reasonable doubt is in there.
Well, yeah, Chief, but it's not there up top if believed by you. Beyond a reasonable doubt, which is consistent with the jury charge, right?
The question is consistent with the jury charge, and I have an issue with the jury charge too, but I know that's not before Your Honor.
So my question is, given that the voir dire is to get an impartial jury pool,
right?
Why the charge, the latter charge, before the jury was sent out, couldn't cure those two incompletions, which are ostensibly pretty minor.
So, Your Honor, the charge doesn't cure the completions because the damage has already been done, because the problem is that this affects the composition of the jury. And to step back, my issue with the question is not just that it's inaccurate, and I think an incomplete question statement is inaccurate, but also, that it is outside the scope of voir dire because it, tries to give the Commonwealth the tools to weed out jurors who were less inclined.
So it's a selection bias argument. It's not. So your argument isn't so much that the E.D.A. was allowed to suggest a direction to the jury here. It was that it was actually affecting the composition of the pool.
Exactly. So it previews what the Commonwealth's state of evidence and strategy is, and it tries to find jurors who will agree with that. And I cite in my brief to a lot of analogous cases. I point to Moon, and there this court found improper a question that defined the insanity defense and asked jurors if they'd be able to find someone guilty if he can't distinguish right from wrong. The reason this question was improper was because its purpose was to have jurors indicate in advance how they decide under a certain state of evidence and to commit them to a definitive view. The question here is no different. It provides a legal principle that is germane to the case and tries to find out how jurors would decide.
How would you compare this question to the questions asked to death qualify a jury about could they apply the death penalty if the facts and the law called for it?
Well, the case law shows that there's an exception for death penalty cases where there is a bit more broad probing is allowed, just because of the nature of those cases. Like the case law says, the cases of widespread public concern. But even in the case Bomar that I cite in my brief, a question that was trying to probe how jurors would react to have a favorable view of the mitigating evidence, that was not allowed for the same reasons that I'm saying here, that it's a one-sided way to find out how people decide. Did I hear you say
that the death penalty questions are different because of a widespread
the case law seems to indicate there's kind of a general rule that these questions that are in the nature of jury instruction are not allowed, that pertain to legal principles, but when it's an issue of widespread public concern and
isn't the sexual abuse of children an issue of widespread public concern?
I think that the death penalty cases are kind of singled out as really different. The Commonwealth made no showing first that this was a.
Can I just interject?
Yeah, of course.
Tell me if I'm wrong. I thought that the law regarding death penalty cases, which is different, is because there was a showing that there was a widespread concern that a jury would not be able to impose a death penalty. So there was a showing in those early cases that was indeed the widespread concern.
Here there was no showing, and I don't think that we can't just say, hey, this is widespread public concern, because then any murder case, any crime of violence.
But this is the law in every case. That's what I'm grappling with here. This notion that you can convict on uncorroborated evidence is law in every case. Correct? Forget about sexual assault cases.
Yeah. So the Commonwealth, when it advanced this question, said it is an accurate portrayal of Section 3106, and then the Superior Court, said it reflects that as well. But the question actually, that provision has three prongs to it, and it only picked out one, and by singling out that in sex offense cases, there is this, the alleged victim's testimony standing alone is enough. By singling that out, it suggests that there is a special standard, and that's exactly, ironically, what Section 3106 tries or wants to prevent, because the three requirements of 3106 are: 1, the credibility of the complainant in a sex offense case shall be determined by the same standard as other cases, as for other crimes. 2, the testimony of the complainant in a sex offense case need not be corroborated. And 3, no instruction shall be given cautioning the jury to view the complainant's testimony in sex offense cases differently than in other cases. So this question ignores requirements 1 and 3, but it only says the testimony in the sex offense cases need not be corroborated, and the act of singling out sex offense cases but not explaining that these cases should be viewed by the same standard as others actually suggests that a special standard exists. There's a Supreme Court case, Richardson, that kind of used that rationale for, there's a question about whether racial prejudice, can you ask a prospective juror about racial prejudice? And in that case, the defendant was black and the alleged victim was white, but they said there was no showing here that this was like an explosive, highly racially sensitive case, and just by asking that question, it like creates extra importance and creates an issue where there might not have, where there wasn't one in the eyes of the jurors. And my argument is that by singling this out, it suggests that sex offense cases should be treated differently, but the law says clearly that
counsel,
they shouldn't.
Share with me, because maybe I'm not getting it. Share with me how you distinguish the voir dire question with standard jury instruction 4.13b.
I'm sorry, can you repeat that?
Share with me how you can distinguish the jury instruction that was, the voir dire question that was asked with the standard criminal jury instruction 4.13b.
Sure. I agree that they use similar language. The difference is the jury.
Tell me what's different.
So the difference, Your Honor, is that for the jury instruction, there's other instructions that provide context and say, you have to look at all of the instructions, you have to consider every element. But again, it's not. The problem is that looking at the jury instructions focuses on the end of the trial. And I'm saying by asking this question at the beginning when it's outside the scope of voir dire, because voir dire, the law says that you can't ask questions that probe one side's trial strategy or try to get information, get at in advance how the jurors will decide based on the facts of the case. Those types of questions simply are not allowed. Counsel, and when you're asking this, yes.
I completely get your point, which is you can't charge on part of the law.
Right.
You can't voir dire on part of the law and remedy it by charging on all of it. I think that's your point, right? I'm trying to understand, where is this line in our jurisprudence because what you're basically saying is if they voir dire on that question, you should be entitled to voir dire on every jury instruction that could possibly be given to the jury. And is that what our law says? Is the purpose of voir dire is to, or voir dire, depending on where you're, my cousin Vinny?
It depends on what part of the state you're from.
Yeah. Probably.
I'm probably pronouncing it wrong, but
no, you're right, because you're from Allegheny County.
If what I'm trying to understand is what is an appropriate jury question that incorporates a charge, and what is an inappropriate jury question that incorporates a charge? Or should the law simply be you can't pre-charge a juror that isn't yet impaneled?
So, Your Honor, I think the appropriate question is the one in the standard form that asks, are you able to follow the court's instructions on the law? Because that's what you're just trying to find people who are fair in general, not to kind of sneak ahead and find out how they're going to decide. And there's case law from the Supreme Court that shows this in Calhoun. the court found that you can't ask a voir dire question that defines the insanity defense and ask about jurors' ability to apply that principle. It says, the court said, counsel may not examine a proposed juror about his understanding of the law. One may be asked the broad question of whether he would accept and act upon the law as stated to him by the court, and this is as far as the examination on the voir dire may properly proceed.
So why isn't that the principle that should apply here, and why isn't that the principle that the trial court applied here? The only question you can ask with regard to your ability to follow the law is a general question. If I charge you that the law is X, will you be able to follow it? Why shouldn't that be the limit of a charge?
I agree with you. I mean, I do concede that on the standard form there are these very broad questions, about constitutional principles that are relevant in every case. Do you agree with the legal principle that the defendant is presumed guilty? Oh, excuse me, innocent.
If someone
is arrested.
So this kind of goes to the Chief Justice's question. So there's a general rule that you can't pre-charge on the law.
Yes.
Other than to ask, will you follow the charge? There is, will you follow the law that I charge you? There are exceptions. One, when a constitutional protection is particularly implicated, you get to charge on the proof beyond a reasonable doubt, presumption of innocence. You can charge on you can inquire on that.
Well, there are the exceptions in the standard form that are these very broad that are applicable to every case, but this is very.
But those are to preserve the constitutional structure of the criminal trial, correct?
Yeah, I would agree with that.
And then there's this exception for death penalty cases.
Correct.
Okay. And you're saying that this charge, which relates to a substantive legal principle, does not fall within the constitutional or the death penalty, and therefore should just be barred by our precedent that says you can't pre-charge a jury on law.
Barred, yes, Your Honor, barred by that precedent and all.
So you finish. I'm sorry.
Yeah, and also by the precedent that says that you can't use voir dire to impanel jurors sympathetic to the positions of one party or to disclose in advance what a juror's opinions are to be on the facts of a case.
But again, your argument, but your argument there is again, to my prior question on this, is not that it was pre-charging the jury, as it were, but rather slanting the composition of the jury, right?
I'd say both, but the huge problem with it slanting the composition, and I believe it. I think.
Okay, and then the answers you've given to a couple of my colleagues' questions suggest that you, in your reply brief, also indicates there was Judge Rangos held a pretrial hearing, and
yes,
but you're still picking the jury down in the assembly room. You're still not. In these sex crime cases, the DA's office is now asking for this instruction in every case of child sex abuse, and you had an opportunity to contest it in a hearing, but you still did the selection down in the assembly room. Correct. Without Judge Rangos being there, right? You come up to the table for individual, individual.
Correct.
Yeah. So this one went to the whole panel before the individuals came up to the table.
I'm not sure. Can you repeat this question?
This voir dire question was read to the whole veneer prior to individual veneer persons coming up to the table, right?
So, Your Honor, we don't have a transcript, from the voir dire. It doesn't exist. But we do know from both the defense closing and the Commonwealth closing that this question was asked to everyone. This was, they decided, the DA highlighted the fact that it was asked in its closing.
Were there any responses that we were aware of, or you're aware of now, from the panel to the question?
Sure, Your Honor, we don't have that information, but what we do have, we know that the question was asked. The record made that clear, and just the fact that this improper question was asked, is harm.
I
was just going to say, you'd agree it's our review on this question is abuse of discretion from the trial court.
The court below, Your Honor, used abuse of discretion, but I actually think that the correct review is de novo, so I am looking for, Your Honor's guidance on that. Because our argument is that this question is impermissible as a matter of law. It's an issue of the question's legality. It's a question of law, and that it's.
But you're challenging. I don't know. There may be some debate among my colleagues whether it's a de novo review, but an abuse of discretion. But it puts us certainly in a difficult position to determine that if we. And I appreciate the fact this is a good question to bring before the court, but it's disappointing that we don't have a transcript to show whether there was any reaction, favorable or unfavorable, to the question, because the Commonwealth has raised a harmless error argument here too.
Your Honor,
that's all I have.
Sure. A couple points. One, even if this was an abuse of discretion standard, it's an abuse of discretion if the law is misapplied. And our argument is that it was misapplied here. But two, we need to look at this under the structural error framework.
So counsel, if you're going that direction, and if I was you, I'd be going that direction too, on a structural error.
Yes.
I want to tease this out. What's the difference between this and a capital death penalty qualified jury? I mean, you have to ask people whether or not they can impose a death penalty for a death penalty case, right? Aren't you, in effect, arguing that if you're asking this particular question in a sex crimes case, it's a structural error, that if you ask somebody if they can impose the death penalty, wouldn't that also be a structural error?
Your Honor, I can't say that I have expertise on the death penalty cases, but I do know from the research I've done that the law shows that the death penalty cases are an exception, that it's treated differently. But back to this question
it's treated differently because of the nature of what you're asking the jury to do. The jury's got to impose the death penalty.
Right.
In this particular case, the reason this particular question is asked on voir dire and then ultimately given later as the part of the charge is because in sex crimes cases, often the only thing you have because of the nature of the sex crime is the testimony of one victim and one defendant. So if you have a juror who's going to say, I can't find somebody guilty beyond a reasonable doubt based upon one person's testimony without anything else, you need to know that going in. That's why this question's asked in sex crime cases, and that's why it's charged in every other case. I think that's what the DA is arguing in this particular case. So what would be the difference between this? If we found this to be structural error as a constitutional imperative, we would be forced to strike down any kind of question regarding death penalty, capital representation of capital juries.
I would just say that, based on my reading, that the death penalty cases are cited as an exception.
Why? What's the rationale behind an exception for the death penalty, but not here?
The rationale that was given was that it was like a proven and demonstrated showing of widespread public concern about people's ability to fairly apply, the law about imposing or not imposing it. And I don't think, and that showing isn't present here. Yeah.
Could we get back to the standard of review here? You said you were unsure whether it is abuse of discretion. I believe our cases, well, at least going back to 2022 in Holt, we said that the scope of voir dire rests within the sound discretion of the trial court, and it won't be disturbed absent culpable error.
So all of the cases that I found when I was researching this issue involved a question that was rejected, that wasn't allowed, and it was about the challenge to the judge's discretion to reject a question. This is different. This was a question that was admitted, and I'm saying that it was impermissible as a matter of law, and looking for, and I believe it's a de novo standard of review, but even under the abuse of discretion, that occurs when the law is misapplied. Yeah.
Counsel, you said a couple of times that this question is asked in every case in Allegheny County that involves a sex crime involving
the child. It's routinely asked.
Okay.
Yes.
Well, is it routinely asked, or is it only when the Commonwealth doesn't have corroborating evidence? Because I think your argument here is They're testing their evidence.
It's routinely asked in these cases where
There is
the
no
he
corroborating
said, she
evidence.
said case.
Okay,
Yeah,
but
yes.
if there's a sister or a cousin or someone in the room who can testify that the act occurred, then there's corroborating evidence, and this question is not asked of the juror.
I don't know.
Okay, because your whole point is they're testing their evidence.
Exactly.
They're
exactly.
testing
Yes.
their evidence in this case.
Correct.
That's
And they're
your
trying
point.
to find people who
And
are
that's why
like,
you're
okay
saying
with
that
it.
this is improper voir
Correct.
dire because they are testing their evidence, they're testing their trial strategy.
Correct.
And that is not the appropriate purpose for voir dire.
Yes.
But in fairness, the DA going into voir dire may not know, unless there have been motion in limine rulings already, may not know if he has other evidence, which other evidence is going to be admitted or not. So it would make sense if the Commonwealth is requesting this voir dire question, it would be requesting the question in all child sex assault cases.
That could be the case. Yes, I want to go back to the structural error
Well,
issue.
before you do that, because I'm confused, did you just say to Justice Donohue's question that this question is only asked when there's a singular Commonwealth witness and it's only going to be a he said, she said?
No, I'm saying that it's commonly asked in the courtroom in Allegheny County when it's a child sex case.
So it's really not challenging the evidence because I gathered from Justice Donohue's question to you that purpose of this question is to determine or bias the potential juror because it's going to be he said, she said.
Correct.
But that's not what you're saying. You're saying this is a routine question asked in all sexual assault cases out of voir dire.
No, I think that is not exactly what I'm saying. My impression, I'm not a trial attorney here, I'm an appellate attorney. My impression is that it's asked in these cases where it's a he said, she said. There's actually been, I can count 2 or 3 other Superior Court appeals from Allegheny County on this same question, and it's he said, she said cases where there's no forensic evidence, no eyewitness testimony.
But you don't know.
Okay.
You don't know if it's asked in other cases.
I can't say one way or the other.
But that's your whole theory, isn't it?
Yeah.
Your whole theory is your base objection to this question is that the Commonwealth is testing their evidence in the case that this jury is going to hear.
Yes, and the purpose of voir dire, as I've said before, is to find people who are fair and impartial in general, who can deliberate with others, who can listen to the court's instructions and render a fair verdict. And this goes.
Let me follow up on that one. So what are the facts of the case that this question revealed as per Justice Donohue's question? That she's bringing it, saying you're questioning the evidence.
I'm referring to her brief. Their brief is based upon the notion that this is an attempt to test the evidence.
It's an attempt.
I know what I'm saying is, where is the evidence?
It's an attempt. Sure, Your Honor. My argument is it's an attempt to find jurors who, are amenable to convicting on thin evidence, who are amenable to convicting when there's little. But the law is also that. But the law is also that lack of evidence is a legitimate basis to acquit, but also the scope of voir dire is that you can't go into finding exactly how people will decide on the law.
But I'm looking at Section 3106B of the Crimes Code, which says it pertains specifically to sexual assault cases, and it provides that the credibility of a complainant shall be determined by the same standard applicable to complainants of other crimes and need not be corroborated.
But the question doesn't say that. It says that it just singles out sex offense cases and suggests that it suggests that it's different. And I'm saying even if you were using that first prong from 3106, it would be improper because of the line of cases that says that questions about legal principles are improper, and also, the cases that say that you can't disclose in advance what the leanings of a juror is going to be.
I understand. I do understand. your
Okay.
argument. Yeah.
And just quickly on the structural error, there's a line of cases that show that structural error occurs when the jury has been selected upon improper criteria, as it calls into question the objectivity of those deciding guilt. There are also cases that say when the situation gives rise to the risk of the fact finder's bias, that's structural error.
So, counsel, if that's true, why don't we have Batson challenges? Why aren't they just thrown out of structural error? Because the court found that there was a racial discriminatory purpose. So if I followed your lead, we shouldn't have Batson because it's structural error. Why do we have it? The answer is because it's not structural error. Otherwise, Batson would not result in replacing or resitting the juror. It would be the case dismissed because there's a finding of racial bias on the selection.
So I'd point to the cases, Shepard versus Maxwell.
Yeah, but we have Batson. That's a classic bias case. A judge found that the prosecutor was racially motivated in selecting jurors. And the response and the remedy is to have that juror seated. If we follow your logic in this case, that these facts are structural error, that's structural error, on Cody. So tell me, you can't have it both ways. You can't have Batson challenges and say this issue is a structural error. Which one is the Allegheny County Public Defender's Office saying should be paramount for this court? For us to strike down Batson?
I'm not sure how.
That's a strike.
How that would.
That's trying to bias the potential jurors. That's what you just said. Structural error. Well, I don't see it any more obvious a structural error, if we follow your logic, than a prosecutor discriminating based upon the race.
So the case when there is a jury selected upon racial discrimination, that's been found to be structural error.
Some cases you often just reseat the juror.
It's also structural error when the situation gives rise to the risk of bias. So the exposure to pretrial publicity, we don't know. We're not inside the minds of the jurors in that Shepard versus Maxwell case, but it was reversible error because there was a risk of bias. In Williams versus Pennsylvania, the Chief Justice failed to recuse himself. He had earlier been the prosecutor, but he didn't cast the deciding vote in the appellate court. But because there is the risk of bias, there is structural error.
That's so distinguishable. That's an individual who signed a death warrant and then sat on the case as a jurist.
The rationales for structural error is that
as a judge.
Yeah, I say
when the right at issue is fundamental, and when the effect of the error is too hard to measure, these are what occurred here.
I understand your argument.
Okay.
I don't agree with it.
Okay.
Are there other questions? All right, we do understand your argument. Let's hear from the Commonwealth.
Good afternoon. May it please the Court. I am Daniel Vernaccio from the Allegheny County District Attorney's Office on behalf of the Commonwealth as Appellate. The bottom line is the law is clear that the testimony of a victim standing alone is enough to convict a defendant so long as it convinces the jurors of the defendant's guilt beyond a reasonable doubt. The Commonwealth asks this jury, this voir dire question during jury selection in order to uncover any jurors who may hold fixed beliefs that conflict with the law, namely that any jurors who would insist on corroborating evidence or who could never convict on a pure he said, she said case.
Counsel, can you draw the line for me on what jury charge questions, legal charge from a judge, are appropriate and in bounds when picking the jury?
Sure. I disagree with appellant here that there is a bright line rule saying that questions in the nature of a voir dire questions in the nature of a jury instruction. I will probably mix up those two repeatedly in this argument. The supposed bright line rule that you can't do that. I don't agree that that exists. Under this court's and the Superior Court's standard of review for abuse of discretion, if you read the cases in detail, these are all cases in which a particular question is sought to be asked, and the trial judge says, well, I'm going to charge you on that later, so no, I'm not going to let you do that. And then the appellate court says, yeah, that was within the trial court's discretion to say that. I don't agree that that creates a bright line rule.
But I guess my question is, should there be a bright line rule? I mean,
no,
why should the lawyers, or in the context of picking a jury, be able to explore specific legal principle by legal principle whether a jury will follow the law as charged, versus just asking the general question, I'm the judge, I will instruct you on the law, I expect you to follow it. Correct. The law presumes you will follow it. Does anybody have a problem with that? Why isn't that adequate?
I think that if a trial court were to insist that its voir dire be constructed in that way, it would not be an abuse of discretion. I think it's fair for the Commonwealth. I'll get to your question in a second.
So it depends on which judge you pull.
I think that's the nature of an abuse of discretion standard of review, is in light of the facts of this case, of the particular case in front of it, the judge will be asked by the parties, can we ask this particular question?
But you're getting an advanced, so if one question is good, then all of them should be good. Right. If one question, I mean, what we're going to do is, if that's per se okay, meaning we don't reverse it, but then if you, as the prosecutor, want to ask about one principle, I, as the defense counsel, am going to say, well, if we're opening that box, I want you to pre-charge all the jurors now, the whole jury pool now, because I want to find out if there's any legal principle specifically that they're not going to be able to follow.
I think that if a defense attorney wants to ask a voir dire question like that, I think they are within their rights to ask the trial court for permission to do so. And again, it comes back to the court's discretion of, well, what legal principles are we concerned about in this case, what aren't we? I don't have a problem, as a per se problem, with a defense attorney asking a corresponding but opposite voir dire question, whatever that may be, so long as that voir dire question is an accurate statement of the law and is something that is relevant to the case and may...
Well, I presume all the legal charges are relevant to the case.
Fair enough.
But this is interesting because I take your point that there's a large quantum of discretion here with the trial judge based upon the type of case that she or he is dealing with. Hence, question about believing police officers, for example, might be in play in one case or another. And death case, could you impose it, that sort of thing. But here, the discretion allegedly, tell me if I'm wrong, it's exercised in a categorical way with respect to all sex assault cases involving a child. Is that correct in Allegheny County right now?
I can't say for sure. I did represent in my brief, and it is my understanding that it is routinely asked. I can't represent that it is asked in every case. I don't know if it is asked, like, what specific amounts of evidence the Commonwealth has in its possession before it chooses to, or if it in fact does choose to ask this question in a given case.
Okay, so we don't necessarily know, but we have the representation from the defense that it's a categorical thing. So just working from that premise right now, sure. How do we as a court assess whether something, I saw in the papers something about a matter of widespread public concern. I mean, so the obviously sexual assault on children, matter of widespread public concern. How do we decide that's a matter of widespread public concern and this isn't over here? Or is that an unsatisfactory litmus test for reviewing trial judges' decisions on whether or not to allow a question?
I can't give you a standard as to what is and is not a significant public concern. Of course, both death penalty cases and cases such as this one are, I don't think there's any dispute that they are, significant public concern.
But perhaps that's a misplaced like hermeneutical device. Maybe we should dispense with this widespread public concern, because we're not taking opinion polls on which cases are more important than others, but we need to assess whether the trial judge abused his or her discretion in, well, did they misstate the law? That's not really, and that's just a marginal claim here, I take it. But did they abuse their discretion by structuring the jury in an improper way through the question at the voir dire stage? Isn't that it?
Well,
I don't want to...
Can I get an answer first? Can I get an answer?
To be clear, the Commonwealth's position here is not that it's a matter of widespread public concern and therefore we can ask this question. It is a matter of concern to the prosecutors in the Allegheny County DA's office that there is a misconception among the public that corroborating evidence is required, or that there are people, I don't know what percentage, I will fully admit I don't have, these studies might exist, but I don't have studies to say how widespread these misconceptions in society are, but I don't have them for me, in my brief or with me here. But that is based on our experience as prosecutors, that is our good faith belief that there is some percentage of the population that won't convict without corroborating evidence or in a pure he said, she said case. And so that's why we seek to ask that question, just to make sure that potential jurors know what the law is.
Well, and that must be in part why the General Assembly enacted Section 3106B, which likens sexual assault cases to any other credibility case by saying that one victim's testimony, if believed, is sufficient.
I would imagine so, yes. So, Chief
Counsel,
Justice.
can I follow up on this widespread public concern issue?
Yes.
Because that's not what my understanding of the death penalty case law is based upon. And let me just start with my understanding, and then
Sure.
you correct me if I'm wrong. There is a general rule that it is sufficient to determine with a general question to the jury, can you follow the law? I'm going to instruct you on the law. Will you follow the law? General rule. Death penalty cases, there was an exception made that the specific question could be asked, can you impose a sentence of death? And the reason that that question is allowed is because there was a determination that there was a widespread public perception that jurors could not impose a sentence of death. And so the exception was made for asking the question, can you impose the death sentence? So this isn't just a question, are sex crimes against children heinous or against anyone heinous? Is this of public concern? The public concern is that a juror cannot follow the law based upon a showing that there's a widespread public concern that they can't follow the law. Here, we don't have that. We don't have a showing of a widespread public concern that jurors will not believe uncorroborated evidence. Is that fair?
That is fair that in this appeal, I don't have, there may be such, studies that have surveyed the public and taken their opinions on this. The only thing I could push back on is, I think everyone has heard the term the CSI effect, and that is sort of the, although I don't, that's obviously not, the greatest evidence, but I think when I say those words, everybody in this room knows what I mean, that because of, whether it's because of mass media or whatever
Sure.
perception, that it has its own name in common usage, and that
People
has...
want more evidence, but that's true in every case. That's not only true in sexual assaults on children, which is why the General Assembly said that they weren't to be treated with special care. They had the same quantum of proof necessary as in any other case in this Commonwealth.
That's correct.
And the CSI effect would be in effect in every single case in this Commonwealth, not only cases involving sexual abuse of children.
I mean, I guess that's fair enough that jurors may always want more evidence, but in the nature of these sex assault cases, there often isn't. And it's, again, the Commonwealth asks this question just to make sure that we're all clear on what the law is and to just pre-screen jurors.
If you're correct, this question can be asked of every juror in every criminal case in this Commonwealth because it is precisely the same principle of law that applies. You can convict based upon uncorroborated evidence if believed. That's true in any criminal case.
So long as the evidence establishes all of the elements and things like that.
But that brings you to her point, because that's not what the jurors were asked at the outset.
Let me follow up, because that's exactly where I was going.
Sure.
In every single case, this is why we use for trial judges, unless I missed something, 31 years of trying juries. Every single case you go into, the prosecution, the defense know what the evidence is.
Yes.
So if you've got a one-witness case with no corroborating evidence, you're expected to propose or give proposed voir dire. The judge looks at the proposed voir dire, and that's why we give it up to the judge for an abuse of discretion standard. You know going in whether or not you've got a one-witness case with no corroborating evidence. That's why that question's asked. And Justice Donahue was 100% correct. If I have a robbery case where I have one witness on an identification, no corroborating evidence, that question is going to be asked at the voir dire stage of a robbery case, or any other case for that matter, where you've only got one witness. This is not just a specific voir dire question that is specific to sex abuse cases, although in a sex abuse case it's almost always asked. It's applicable to any other claim where you've got one witness with no corroborating evidence. Is that correct?
I think that you could voir dire the jury on that, yes. I will have to say that I believe Section 3106 of the Crimes Code does specifically reference sex assault victims, sex assault cases.
Yeah, but it doesn't limit this type of voir dire question to only sex abuse cases.
Voir dire is left to the discretion of the trial judge. If the trial judge in any given case believes that this particular question is appropriate, given what the judge knows about the case under the circumstances, that is the kind of judgment call that the case law permits a judge to make.
And it is also, I think, commonly accepted that in a sexual assault case, particularly sexual assault of a child, there isn't likely to be other corroborating evidence other than the testimony of the child and the testimony, if he chooses to give it, of the perpetrator.
No, there's often physical evidence, Chief.
There's often not. There's often no physical evidence at all in a sexual assault of a child. And you're left simply with the he said, she said. So it makes abundant sense to me that the legislature would have adopted Section 3106B to clarify that sex assault cases are to be treated the same as other cases where the testimony of a witness is sufficient if believed beyond a reasonable doubt.
Yeah. Yes, sir.
Counsel, are you of the view that you can actually ask a juror a question specific to the evidence that you're going to be presenting?
No, no, Your Honor. The voir dire question cannot probe as to a juror's reaction to specific facts.
Isn't that precisely what this is, though? If it's a he said, she said case.
By the seashore.
Aren't you? By the seashore.
By the seashore. By the seashore, yes.
Isn't that exactly what you're doing? Will you convict even though I don't have any corroborating evidence?
No. The question, the call of the question is, can you follow this principle of law? That's what, and I think that's a material distinction.
But why not just ask that question? Back to what Justice Robson said many minutes ago. If you start with that proposition, you ask the juror, the panel, that question. I'm going to instruct you on the law. Will you be able to follow my instruction? If anybody hems and haws, that juror is going to be going. And then you're not going to get to individual voir dire. It doesn't have to be specific to, will you follow the law that even though I have uncooperated evidence, you can still convict?
True.
How does that get you farther?
I think, well, first thing I would say is, again, this is just because there is the discretion to permit this question, there is also the discretion not to permit this question. But beyond that, my main initial reaction to your question is a juror may, in good faith, believe, yeah, I can, I'll follow the law when instructed, but doesn't know the specifics of what all that answer actually entails until they get into the jury box and are instructed and realize that here we are, all I've heard is the uncorroborated testimony of the victim, and now I'm being instructed.
But that could apply to multiple jury instructions. I mean, you can apply that to every. Well, that sounds like a stupid legal principle. I'm not going to apply that.
This reasonable doubt.
Yeah, this reasonable doubt stuff really is really bad. So your principle earlier that I thought you said was the reason why the DAs asked for this question is because of a concern that a potential juror might insist on corroborating evidence. Is that
yes?
Okay. So let's apply that principle, that firmament for you and your office. Let's say in this case the defense counsel wanted to ask the jurors, particularly in light of your question, whether the jurors might be more inclined to believe a child victim of sexual assault under the belief that children typically wouldn't lie about something like that. Based on your concern in your office, would you object to that instruction?
I think I would, because I think that's a different kind of instruction. I think you're asking that question that you just posed is asking jurors for their opinions of the evidence. This question in this case is asking if they can follow the law.
Based on the evidence?
Yes.
It will eventually be presented at trial, sure,
so
but
you're
it's still
giving them an advanced look at the evidence?
No, I don't agree. I think the case that I would point to here.
I would like to agree with you. I would like to agree with you that it's different. Tell me why it's different, though. It's just to me. I hear wording. The questions are worded differently, but it's still a question about how do you feel about uncorroborated child testimony in a child sex abuse case.
I will agree with you. It's a subtle distinction. I think it's a material distinction, though. And what I would point to you, Justice Brobson, is this Court's decision in Voir, which both Appellant and I cite in our briefs. And I discuss at length. I have it up here. I think it speaks exactly to your concern, because in Voir, the judge talked about, the defense counsel basically wanted to ask questions. Would the potential jurors consider certain types of evidence, like the defendant's character, the defendant's record, such and such? This court considered those to be improper, but notably, the trial court didn't permit the defense attorney to ask those questions, but restated them into there will be mitigating circumstances that are presented. If I instruct you that the law requires that you consider that, would you follow that law? And this court put its stamp of approval on that restatement of that question. And so it is a subtle distinction. We're both still talking about what mitigating evidence might be presented at trial, but one asks the potential juror if, would you consider this, or what's your opinion? What would your opinion be of this evidence? What would you think about this evidence? While the other is, I'm going to instruct you. You must consider this. Would you follow that?
Mr. Vernaccio, I suspect we could discuss this case all day because we all have a lot of
Let's not.
opinions.
We have.
We may have already taken up a lot of the day, but if you would give your closing remarks, if you have
Sure,
some,
of course.
and I think we've probably covered it other than that.
Yes, Your Honor, of course. The Commonwealth's bottom line argument is that this is an accurate statement of the law, at least what is included. I understand there's concerns about what is omitted, although I must briefly say to Justice Weck's point, because I'm just remembering this now, the omissions, as they were from the voir dire question, are also omitted from the jury instruction. They are included in other jury instruction, but I believe the voir dire question here is designed to scrupulously adhere to jury instruction 4.13b. So to continue with my closing, it is an accurate statement of the law. Furthermore, at trial, the trial court accurately instructed the jury. Jurors are presumed to follow the court's instructions, so any insinuation of prejudice or anything like that is unfounded, and I would ask this court to affirm.
Okay, thank you. You
Thank
both
you.
did an excellent job presenting
Thank
the
you.
case. Thank you very much. Would you call the next case, Mr. Minner?
Commonwealth of Pennsylvania versus James Smith, representing Mr. Smith, Ms. Robert Forrest, representing Commonwealth, Mr. Sean Alton.
Oh, we've just lost half the bench.
You can, this, thank you.
Good afternoon.
Good afternoon.
In this discretionary appeal, we will examine whether the trial court abused its discretion by denying the defendant's request. Is this is, yes.
Yeah.
About whether they had a fixed belief that children would not lie about being sexually abused. The trial court refused to ask that question, but it instructed the potential jurors how to evaluate witness credibility, directed them to use the same credibility standard for every witness, and asked if any of the prospective jurors had been victims of sexual assault or child abuse, and if so, whether that would prevent them from being fair and impartial jurors. The Superior Court affirmed, finding that the trial court did not abuse its discretion because the proposed question impermissibly sought to gauge potential jurors' receptiveness to possible defense strategies, and the trial court's instructions and inquiries adequately addressed any concerns about potential juror impartiality. Finally, the court found no authority establishing that child sexual abuse victims belong to a particular category of witnesses which would be more believable, therefore requiring a specific voir dire inquiry. Before us, the defendant challenges each of these rulings. Please proceed.
Thank you, Your Honor. May it please the court, my name is Robin Forrest. I represent the appellant James Smith. Your Honors, obviously this case is related to the Howard Walker case that you just heard. But
Well, I think your case is a lot weaker.
Yeah.
Because when I first read this proposed question, I had no idea where it was coming from. I mean, it's almost counterintuitive. And certainly the opposite could be just as true. What was it that you presented to the trial judge which would support the necessity for giving such a voir dire question?
Your Honor, nothing was presented to the trial judge in support of this question, but I would argue that the trial judge had reason to believe that this kind of predisposition exists in broad parts.
Where does that come from? I would think it would be just as likely that they would believe a child could lie. Children being prone to misapprehensions or confusion or fear or
Understood, Your
all
Honor.
manner of things. The question to me strikes I don't know, having been a trial judge, if I had seen this question, I frankly don't think I would have spent a whole lot of time even considering it.
Well,
It seems outlandish. Can you tell me why I'm wrong?
Yes. First of all, Your Honor, there are studies. They were not presented to the trial judge, but I would refer Your Honors to pages 18 to 20 of my brief, where I discuss some of these studies that have shown what I think already trial judges would have reason to believe. And that is that jurors that sit in child sex assault cases are more likely to believe young complainants than older complainants. One of those studies, for example, compared the testimony of a 6-year-old child versus a 15-year-old child. And what the studies show is that the 6-year-old had higher, quote-unquote, credibility ratings that translated into more guilty verdicts. And jurors explained that the reason that they convicted in those cases because they thought that the young child was too sexually naive, unsophisticated, lacking of knowledge and life experience, and I believe the way the study put it was they lacked the cognitive capacity to even fabricate a charge of a sexual nature. And that's why, Justice Wecht, when you ask about, everybody knows that children, might lie, could lie. Maybe if you have a child, you're even more inclined to think that. I'm not advocating that this kind of question be asked in every case where there is a child witness, although I don't think that would necessarily be a wrong conclusion by this court. The key here is that when we're talking about sexual assault charges and allegations of this particular nature, there is reason, not just reason to think, but reason to think that the veneer would think that a young child just doesn't have the capacity to fabricate that type of charge. They wouldn't, unlike, for example, a 15-year-old complainant who might want her mother's boyfriend kicked out of the house and knows that fabricating this type of charge could actually produce that kind of result. When we're talking about a 6-7-year-old child, they don't have, first of all, the biologically, developmentally, the understanding of even what's happening to their body. I don't claim that that's a fact, although I believe it is a fact. Again, we're talking about people in the community and what their perception is.
Well,
that people
with
would believe
respect to people in the community council, many of your jurors probably are parents and have common sense one way or another, a variety of different thoughts about children, and why between the common sense of a 12-person jury and any expert testimony that prosecution and defense might have had, wouldn't those things combined do the work rather than trying to put a question that is on one side of a ledger of an area that is not at all, about which there's not at all conclusive scientific proof?
Well, Your Honor, I don't think there needs to be conclusive scientific proof, and courts have never held that, including the United States Supreme Court, which itself said that the standard that they like to apply is the reasonable possibility standard. Is there a reasonable possibility, now I'm quoting from Rosales-Lopez v. United States, excuse me, which is not in my brief, but the site is 451 U.S. 182, the year 1981. That was dealing with the case of ethnicity. Now, the issue there wasn't specifically about a categorical credibility bias, but it did have to do with a bias of whether something was a proper voir dire question or not, as far as detecting bias in the jury. And the court said that such a question is required on voir dire if there's, quote, a reasonable possibility that a particular type of prejudice might influence the jury. This court in Commonwealth v. Futch applied the exact same analysis. In that case, which was, I believe, 1976, the court was dealing with, there was a prison stabbing, and the Commonwealth witnesses were prison guards and the defense witnesses were prisoners. And defense counsel in that case asked the trial court to propose on voir dire these two questions. Are you more likely to believe the testimony of a prison guard? Are you less likely to believe the testimony of a prisoner? And the court first addressed the issue of the prison guards and said that is a form of law enforcement or analogous to law enforcement. And yes, there's good reason to think, because we know as society there is good reason to think that the fact that someone is a law enforcement officer will stir all sorts of predispositions and prejudice and biases in people one way or the other. So yes, you may ask that the trial court abused its discretion and should have allowed that question about would you believe a prison guard. Then when they went to address the issue of does this question apply to the credibility of prisoner witnesses. And they said, okay, we don't know of any authority on point about prisoners and credibility. But there's no distinction, there's no reason why the same analysis wouldn't apply. Both categories are capable of arousing, I believe the language this court used was, arouses feelings capable of interfering with the jury's ability to render a fair and impartial verdict. Now, the Commonwealth takes the position, which I think is untenable in its brief, that, okay, these types of questions are limited to the universe of police officers, prison guards, and prisoners, and that's it. And I think that just defies common sense, and it really defies the law, because courts have been, in analyzing whether certain questions about bias must be asked on voir dire or not, courts have been applying this common sense reasonableness standard throughout. An example I would give, the Ferry, which is an en banc Superior Court case that I cite in my brief. This is an interesting case. It was back in 2006, and it was a medical malpractice case. But believe it or not, back then, the issue of tort reform was actually a hot-button issue. If you try to remind yourselves of the election of 2004, you could Google it. You actually would jog your memory that tort reform and litigation explosion was a real hot-button issue in the election that year. And this case, in Ferry, the defense wanted to pose questions on voir dire to see if any of the members of the veneer might be biased by all of the media coverage around tort reform. And the trial court disallowed the question. And the en banc panel, after discussing what a hot-button issue tort reform was at that time, said common sense dictates that all of the media coverage created a climate that would affect the average person. What I'm saying is, whether we're talking about there's a reasonable possibility that a juror's veneer members might be prejudiced, common sense dictates it, or as in this case, where there is good reason to think that a 6 or 7 year old child doesn't have the cognitive capacity to fabricate these kinds of charges. Because, first of all, because they just probably don't understand exactly what is even happening to their body, but also because they wouldn't have the mental development and capability to have a motive to even fabricate. So it's not the type of rationale that would apply to children in all cases. If there was a child who was an eyewitness to a car theft, I don't believe that this type of question would be appropriate. But when we have a young child testifying to sexual abuse, not to mention uncorroborated testimony. I mean, the prosecution's entire case rose and fell on the jury's evaluation of the credibility of the child, or two children. But corroboration, unlike the last case, Harold Walker, corroboration isn't even really at issue here. Even if there were corroboration, this question would be required because it gets to the heart of whether or not a veneer member is predisposed to believe a victim, here, a young child alleging sexual abuse, just before the victim even opens their mouth, just because of the category, we would say.
Counsel, I'll jump in so you can take a breath real quick.
Yes.
That point you just made, under that principle, why wouldn't an appropriate veneer question be, are you predisposed to believing a victim? Based on the idea that no one in their right mind would just fabricate some kind of heinous sexual assault.
Oh, a victim in a sexual assault case.
Yes. What is it about saying it's a child versus a victim? I mean, your principle is that a child couldn't possibly fabricate this, wouldn't do this, wouldn't do this. Why couldn't that principle be extended to all victims of sexual assault?
Well, I think an adult victim, the rationale that I was saying, what was discussed in the studies and what I think judges have reason to know, would not apply to an adult. Just as I said,
I don't spend my time reading academic studies.
No,
so I'm not
Your Honor,
sure, I'm not sure that Justice Weck does. I do not.
But I think the studies just illustrate what we have reason to think people believe
anyway.
If you
would have, in this case, I think if you would have put those studies in front of the judge, or some evidence in front of the judge, or some record in front of the judge to establish this principle that you're establishing, your case, I'm not saying your case would win, but it would at least be a little bit stronger, wouldn't it?
Well, Your Honor, I think when you ask about the distinction between why wouldn't the question apply to any victim of a sexual assault case, I was actually going to make the point before you even asked that question that if there were an adult eyewitness, for example, in a child sexual assault case, not a child on the witness stand, an adult who, perhaps allegedly walked in the middle of the act or something like that, I would say this question wouldn't be required. Precisely because it is an adult, because we know that an adult certainly could have a motive, the cognitive capacity, all the reasons why we think a 6-year-old wouldn't really be able to fabricate a charge like this. Of course,
but you're assuming that the trial court has the same perspective on that type of evidence as you're arguing.
Well,
and I don't discount the studies that you're referencing, and maybe if the trial court had those studies, the trial judge would have been persuaded otherwise. But she obviously had a different view of child witnesses.
Well,
why was she wrong by just following what her perspective was, absent evidence to the contrary?
Your Honor, I'd say that it's the judge's obligation when exercising the discretion to not apply their own perspective. And I'm not saying this is my personal perspective, although it may be. And it's not a question of whether the trial judge's personal opinion about whether a 6-year-old would lie about being sexually abused, is more accurate than my personal opinion. The issue that the judge has to decide when determining whether a question must be posed on voir dire or not is there a reasonable possibility that this kind of prejudice, and now I'm quoting the Supreme Court of the United States again, that this kind of prejudice might influence the jury?
But how do you evaluate that? I
think that same way, Justice.
Is it reasonable simply because a learned and experienced defense counsel told the judge that it is a reasonable thing?
No.
Is that enough?
No, Your Honor, and I don't think it's reasonable just because there are studies that show that. But I think, as I said before, that the studies show what I believe. There's reason to think that most people in the community would have a predisposition to believe.
Could it be, counsel, that the question was so inartful or so suggestive that the trial judge said no? It has the answer in the question. Because you do not believe a child could lie about sexual. It might well have been a good use of the trial judge's discretion, but not a mandatory one. If she had elected to say, you know what, I'm not going to ask that, but I'm going to ask them if they have fixed beliefs one way or another about the credibility of child victims or alleged child victims, or something along those lines. But the way that you presented, I mean you personally,
yes,
the way that defense counsel presented this question to the court, as I said earlier, struck me as problematic. But I just wonder whether there's an overshooting here by defense counsel in so directly putting the answer in the question when it might have been phrased in a way that achieves greater neutrality and nonetheless ferrets out bias on the part of the veneer people, which is what it's all about, isn't it?
Which is what it's all about, Your Honor. And I was going to make that point first, and I'm glad you said that because I want to answer your question, but I do want to say one thing. That you notice in the standard jury questionnaire where we ask the questions about are you more inclined to believe a police officer, and the second question, are you less inclined to believe a police officer? It's not meant to be neutral. The question doesn't say, do you think you could fairly evaluate the testimony of a police officer? Because that's not going to elicit the bias that we're looking for. That kind of undermines the purpose of voir dire. We want to be direct. We want the juror to be attuned to the prejudice that we're trying to detect. So, yes, I think it's important to not reword the question and say, could you be fair when you're listening to the testimony of a child who is alleging they're sexually abused? But now, on top of that point, though, I want to say that absolutely, if the wording of the question is the obstacle, and I don't think that was the problem for this trial judge, but I don't know. But the nature of the question is is required, which I think it was, because we are probing about a bias that would cause a juror to be predisposed to believe someone. They would not be. They would have a presumption of guilt. They wouldn't be able to keep an open mind, and they should be disqualified. But then, if the question needs, if the inquiry needs to be made, but the wording is not right, then it is incumbent, and this is not me saying this, this court has said it, it is incumbent on the trial judge to rephrase, reword, remold the question in a way that still would be effective as far as eliciting the disqualifying mindset, but what the judge does not have discretion to do is to completely cut off that line of inquiry. In this case, I believe one of the counsel...
Unless she thinks less is more. Unless she feels that the standard voir dire, along with whatever supplemental things have already been approved, is going to adequately cover the waterfront. Well, sometimes less is more.
Well, Your Honor, this court in Futch actually held just the opposite, and I think this is a very interesting point. In Futch, which is the prison guard prisoner case, the trial court, interestingly, did allow this question to be posed to the veneer. And I am paraphrasing. Do any of you know someone who works in a prison or for a prison? And if so, would that prejudice you? Okay, that's a fairly focused question. It's not that broad and vague. And even though that question was asked of the veneer, this court still found an abuse of discretion and granted a new trial because the trial court disallowed this question. Would you give more credence to the testimony of a prison guard than you would to the testimony of a prisoner? It's not enough just to ask, Justice Weck, when you say maybe less is more. No, less is not more, less is less. And the jurors, the questions need to be explicit. Even, I would quote a different case by the United States Supreme Court on this precise point, that you've got to clue in the jurors as to what you're trying to elicit. It must be a focused question. Questions asking about, can you follow our general fairness aren't adequate to detect that kind of prejudice. This is the quote from Morgan v. Illinois, a United States Supreme Court case, which I do cite in my brief. Quote, jurors could in all truth and candor respond affirmatively, meaning, yes, I could be fair, personally confident that their dogmatic views are fair and impartial while leaving the specific concern unprobed. And I say that is exactly what happened in this case. It wasn't enough. Yes, the judge did ask in this case, oh, this is a case about someone who's alleged to have sexually abused a 6 and a 7-year-old child. Can you be fair? Okay, that's an important question. It needed to be asked. It's not a substitute for the question that Mr. Smith was asking. Jurors, like all of us, we like to think we're fair-minded. We don't recognize all of our prejudice and biases. And okay, when the judge posed that question, there were a handful, I don't remember how many, of members of the veneer that said, okay, I can't be fair just hearing about the nature of the charges, and they left, okay. But there's a very good chance that some, maybe even most of the people who didn't raise their hand and stayed in the veneer and maybe ended up on this jury are people who were thinking, okay, I think this is an abhorrent, despicable crime. It makes my blood boil just to think about it, but I can be fair. The juror hasn't been attuned to the precise prejudice that you are trying to elicit, and that is what voir dire is about. Voir dire speak the truth. We're not trying to phrase neutral questions and try to get all the veneer members past the finish line so they could be on the jury. The idea is to elicit, to uncover hidden prejudices, maybe some that the juror doesn't even know that they harbor. And this question was designed to do exactly that. I also think the fact that the judge told the jury, now you need to judge everybody's credibility the same. Again, it's an important thing to tell everybody on the veneer. But in no way could that possibly be a cure-all. We're talking about, to use language that Your Honors used in the last case, an issue of widespread public concern, child sex abuse, inflammatory, emotionally charged issue. People have very strong feelings about it. Simply being told by the judge to leave that at the door is unrealistic and defies human nature. So on voir dire, not only, it's two parts. I mean, not only are we asking the jurors, do you have a fixed opinion about this specific issue, but then we need to know, can you put it aside realistically and follow the judge's instructions. Okay, so the judge told you how to judge the credibility, but can you really put that aside? Or is it unshakable belief? If it's an unshakable bias, then the juror is not qualified to sit and must be stricken for cause. Which leads me to one other point. If Mr. Smith had been allowed to pose it, I am not suggesting that if a juror answered yes, I'm more likely to believe a child in a sexual assault case like this. I'm not suggesting then that juror should be stricken for cause. What it does is flags the juror. There needs to be follow-up questioning, maybe only one question, 2, 3, whatever it takes. And then the trial judge will determine whether that juror actually was sort of rehabilitated, whether they realize they actually could sit fairly, or whether it is an unshakable belief, in which case the juror would have to be stricken for cause. Mr. Smith didn't even get to those questions because he never got out of the starting gate. He wasn't allowed to ask that baseline core question. Do you have a fixed opinion already before you even get in the door about a young kid who testifies or sexually abused? Or can you keep an open mind and listen to all of the evidence and judge it and judge it fairly? I've been doing a lot of talking. I don't know if Your Honors have any questions, but I do want to say that
I thought you were going to say you didn't know whether we were listening.
We wore ourselves out. We wore ourselves out in the last.
No, I'm just surprised my voice is holding up. I also want to say that I think the Commonwealth's position that this is limited to a universe of 3, police officers, prison guards, and prisoners, which as I said, I think is completely unfounded. I also think that it would be a limited universe. I don't think there's some kind of Pandora's box that we're opening. I don't think it's a big slippery slope, because we're not just talking about biases about certain categories of people. I mean, a Nazi could take the stand and testify in some case. There would be all sorts of prejudices and biases, but do they relate to presumptions about the trustworthiness? Is that Nazi witness a truth
So to go back to my question,
yes,
you could ask this question about any sexual assault victim.
About any sexual assault victim I think as a child. You could ask the question about any sexual assault victim, but I don't think that there would be the same widespread predisposition to believe an adult witness.
Why isn't there? I mean, there's advertisements and widespread reports and things that we must believe the victims, right? We must believe the victims. Yep. And so why doesn't your principle apply to every victim of sexual assault?
I think it could apply to every victim of sexual assault.
I'm not sure that's a great answer, but I think that that's at least consistent with your principle.
Well, I think that's a very interesting point, Justice Brobson, because I don't know if you're referring now to sort of what we would say is the Me Too movement. I mean,
I'm not necessarily citing
okay,
that.
but I do think the pendulum, as this was discussed a little bit in the previous case, Harold Walker, 3106 was enacted back in the 70s when society was in a very different place as far as the prevailing view of the credibility of rape victims. And now I'm speaking of adult rape victims only. There was, I think, widespread skepticism on the part of people to disbelieve an adult sexual assault victim where there was no corroboration. And the legislature enacted 3106 to try to prevent that from happening, to sort of level the playing field, so to say. Now, we're about 50 years later. I know there's a school of thought that thinks 3106 is unnecessary in today's world. We're in a sort of post-Me Too world where people might be more inclined to believe a victim, an adult complainant in a sexual assault case, because society now has heard so much about how women coming out from the dark corners and speaking their truth and need to be believed. But I think there's a big distinction between child victims for the reason that I was expressing before.
And there may be, and I don't want to belabor the point, but there may be. But you've just thrown out a bunch of facts that aren't really in the record. And they're really more your opinion than anything. That, oh, well, in the last 30 years, we've come a long way, and now society generally believes all victims of sexual assault, or gives them super credibility, or decides not to necessarily I mean, this is all very interesting, but this wasn't really what was in front of the trial court judge.
Well, Your Honor, I do not maintain that it is incumbent on the counsel, whichever side, to necessarily present and make a proffer in support of this kind of voir dire question, because.
But then, on what basis can we or should we say that it's an abuse of discretion for the trial court judge to say, yeah, no, I'm not going to allow this. I don't believe this general perception. I'm not adopting it, and I'm done. Do the Superior Court and this court then become the perception police?
Your Honor, I believe that there is a reasonable basis for a judge to conclude that a majority or the average juror might be predisposed to believe a young child making these allegations for the reasons that I said before. You don't need to read those studies to hold that position. I'm not saying it's accurate. That's not for the trial judge to determine. The trial judge needs to have their finger on the pulse of society, so to say. You know, when the court in Coppa Ferry said, well, common sense would dictate this, or I have what I think is an interesting quote. This was a Second Circuit case last year called Nieves, which I cite in my brief. It was about credibility of a former gang member who was now turned state's witness and was testifying and wanted to pose questions about would you or would you not believe a gang member. The trial judge refused to pose the question. And the Second Circuit, talking about this, like how do you know whether a judge is supposed to think that it's reasonable that most people would be predisposed to think a certain way? Just as an example, they didn't have studies. Here's an example where the Second Circuit said it would have been obvious to anyone living in New York City area at the time that there was a serious risk that jurors tasked with impassively assessing the credibility of the gang member would have some difficulty maintaining an open mind while doing so. Okay, now this is obviously not the same case, but yes, we ask judges to make these sorts of determinations all the time. And, you know, they have to exercise their discretion within the bounds of the law. But it's incumbent on judges, whether because of something that happens to be a hot-button issue at the time, or because of cultural mores that we know from society that most people would be predisposed to feel a certain way. I will give you another example. It has nothing to do with media coverage or being a hot-button issue. I tried hard, because I do think this is a limited universe, to think of another category of witness where people your average person might have a predisposition to believe the witness or disbelieve. Religious leaders was a possible example of something that I could think of. Why do we say that? I don't have any study to show that. Well, we know in this country, most people are religious, they practice a religion, most of them consider their religious leader to be a moral, ethical, trustworthy, truth-telling kind of person. So if a religious leader is testifying in a case, particularly if it's central to the case, I would think a question like this would be required, because it's reasonable to assume. Now, it's reasonable, I'll complete my sentence, reasonable to assume that your average juror is going to be predisposed, in that case, to believe, or maybe disbelieve, if you were very skeptical about religion.
Well, that's the rub. But the question didn't have that. Yeah, exactly. The question was slanted. And again, I understand your point about you have to be probing. You can't just be up here with generalities. Yes. But granted that you have to be in the weeds a little bit to really ferret out bias, you shouldn't meet the bias risk with bias of your own. Maybe you should present a question that is less presumptive in its conclusion, because you do not believe a child can lie. It's just as likely that the veneer person would think the opposite about child witnesses. I mean, so I suppose I keep getting hung up on your challenge to the discretionary call made by the judge, who might well have felt, you know what, this is just advocacy, and I'm not going to have advocacy in voir dire.
Well, Your Honor, I think you make a good point, and maybe that's, I assume, precisely why the our standard jury questionnaire with regard to law enforcement officers contains both sides of the question. Are you more likely to believe? Are you less likely to believe? And if that may have been a very sensible resolution to this issue. The trial judge could have posed both. Are you more likely to believe a child witness in alleging sexual assault? Are you less likely to believe? Again, if it's the wording of the question, the formation of the question, once it's asked by counsel, it's incumbent on the trial judge then to reformulate.
See, I'm not sure that's right as a blanket proposition. Maybe it's best practice to do so, but to generalize that in every case the trial judge is required to clean up counsel's mess, I'm not sure that I think the circumstances of some cases could rise to the level where the question needs to be reconfigured by the judge, but I don't think you can make that blanket assertion. Sometimes the lawyer has to live with his or her own mess.
I understand, Your Honor, and I would never say that applies to every case. Only in a case where we're saying that the underlying inquiry was required, that this type of bias, that this is a type of bias that there was reason to think might exist, maybe going either way. Who knows, maybe I personally would find this hard to believe. Maybe the majority of the voir venir walked into the courtroom and heard it was a case alleging a sexual abuse of a 6- and 7-year-old and thought, liar, or the mother must have put them up to it. I wouldn't, maybe there was a presumption going that way. To me, that seems unless you're intimately familiar with the criminal justice world, as we are, I don't think your average member of the community is coming in with that kind of predisposition. But perhaps, and maybe if so, then the question, just like we do with police officers in the standard questionnaire, maybe dual questions should have been posed. But I'm not saying that it's incumbent on a trial judge in every case to reword and rephrase. I mean, of course, counsel needs to do their job. But if counsel has requested a question and it's an inquiry that needs to be made in order to detect this kind of disqualifying prejudice, then it is incumbent. And that's not my opinion. This court has said so. In Richardson, even I think in Bomar, a case that was just recently discussed in the last in the Harold Walker case. Also, Your Honors, just a fundamental point. This is a very modest, minor request. This question. I mean, there's no good reason, really, why this simple question couldn't have been posed, and the harm that could have potentially and perhaps did flow from not posing that question is so large. I mean, we'll never know how many people, it could have been just one, it could have been half the jury in Mr. Smith's case, may have come into this case just presuming guilt, because there's no way they're going to think a little kid's going to be able to fabricate this kind of thing. We'll never know that. One question might have resolved the issue. So it's a modest request. It's a required one, and it's not there's not an imposition on the trial court, and there would not be a slippery slope, Pandora's box that we're opening. As I said, there's a limited number of types of witnesses where you would think people categorically believe they lie or they tell the truth. Do Your Honors have any additional questions that I could answer?
No, I think you've been very thorough. Thank you so much. We'll hear from the Commonwealth.
Thank you.
Mr. Baldwin.
Good afternoon. May it please the court. I feel like a lot of my thunder may have been stolen because the same topic's been up for the last 3 attorneys. But I would just say that the rules, Pennsylvania Rules of Criminal Procedure, Rule 631E, specifically gives the trial court the discretion to determine what questions should be allowed and which questions should not. And I think that they actually acted well within their discretion. And it wasn't a case in which the biases weren't probed at all. The trial court, when the voir dire was still wide, there were 2 full rooms outside of the courtroom of prospective jury members, and the first thing the court said was, They listed every single charge that was against the defendant and said that this involves allegations against a 6-year-old and an 8-year-old. Is there anyone who would be unable to be fair and impartial and follow the trial court's instructions? And it wasn't a handful of people that left. It was 25 jurors that stood up for that, and all of them were sent. And, you know, in my mind, that's just that's evidence that the system works. The judge used
Or that a lot of people wanted out of jury duty.
It could be, but, you know, there were other questions, such as, do you know these people? No, you know, only one person stood up for that. If there were any lingering people wanting to get out of jury duty, that could have been their thing. But I think, I think generally the court's discretion is kind of one of the things that's consistent through a lot of this court and the U.S. Supreme Court's case law. There are those exceptions for, I won't say it's limited to 3 things of police officers and inmates. I think there's other exceptions that have been made, particularly I know the Superior Court in one case made an exception for a sexual preference. And, you know, whether or not I think that's valid or not, I think the key thing to look at is whether or not the trial court abused its discretion. And I don't think that defendant on appeal, appellant, has made out a case that the court in this case did abuse that discretion.
Could I ask you, counsel, your opponent had suggested that if the trial judge had found, as she apparently did, this question inappropriate, what opposing counsel had suggested that it was incumbent on the trial judge to realize that the credibility of the child victims was in play here necessarily, and that therefore the veneer should have been asked if they had any fixed views one way or another about the credibility of child victims in these kinds of cases. How would you respond to that argument?
Well, I disagree that the trial court actually has that responsibility to do. In fact, if we're looking through context, I think the trial court saw this question for what it was, which was an attempt to throw a little bit of the closing argument in to the prospective jurors before any evidence was presented. And the context in this is that there were 9 questions proposed in total by the defense. They included questions such as, how do you feel about the Me Too movement? Have you ever been accused of something you haven't done? And I think in context, when you add all the, what type of social media platforms do you regularly use? And I think when you look at all of those types of questions in context, it kind of paints the picture that a defendant's not looking for, they're not asking these questions to try to determine whether or not there's a fair and impartial trial. That's part of it. You know, I will concede to that. It may be a part of it, but it's not the bigger concern. The bigger concern is to try to impart in the minds of the jury the end of that question. A child could lie. Me Too movement, because those do tend to bring out strong feelings in people. But there were ulterior motives, and I think the judge realized that. And while the judge did, I don't think it's required, but the judge did actually reword, you know, in a more neutral context, the question of credibility. In fact, the specific question that was at case in the previous case, Walker, the judge actually asked that question to every individualized juror after the main point came in there. Every individual one. And specifically one prospective juror came out and said, you know what, I have a young niece. I don't know that I could be fair and impartial, and that person was struck.
How are we going to harmonize this with the prison cases, the gang member cases, the police officer cases? What is it about this particular instruction that is different from those cases where either we or another court have said it's an abuse of discretion to not allow the exploration of that bias?
I mean, I think they are very, very limited exceptions to the abuse of discretion.
Well, every exception is limited because it's an exception. So, I mean, I guess the question is, what is it about those exceptions that makes this exception that they're putting in front of us not a proper exception?
I think those exceptions are about the credibility of a class, you know, and I think as the court said, an official or semi-official status. So police officers Service members, they have a reputation of being unbiased and serving the public. Inmates have a reputation of you've been convicted for a crime. Gang members have a reputation of you're a gang member, you do bad things. Children can lie or not lie the same as anybody else. I don't think that there's anybody out there who believes that a child cannot lie, and whether they're 6 years old or 15.
But you believe that there is a perception that police officers can or cannot lie. There's that police officers are always believed.
There may be. I don't know that there's that perception either. And to be honest, I think that the instructions should be across the board, whether it be police officers. But
yeah, you want to know the answer to that question too, right? You want to know if a potential juror is going to just disbelieve a police officer or disbelieve a prison guard.
Absolutely. But I think
you don't necessarily want to know if a jury is going to disbelieve a child victim witness.
Yes, but as a prosecutor, I'm not a party without an interest. I would say the judge, and this is where you would draw that line, has that discretion because they are a disinterested party in which they can make that determination, and that's something that that this court, in an opinion, can draw across the line that goes, through all types of different fact patterns.
Counsel, let me ask you, do you think it's relevant to know whether or not a juror has a fixed belief about the trustworthiness of the testimony of a child victim? A fixed belief, one way or another.
I think it's relevant, but I don't think the manner in which it was asked in this case.
Well, that's a different question. That's a different point. I'm asking you a much broader question.
Yes,
let's assume that this was appropriately framed, and I agree. I don't think it was appropriately framed. But let's assume it was appropriately framed, and the question was, do you have a fixed belief one way or another as to the trustworthiness of the testimony of a child victim? Should the judge have allowed that question, and would it have been an abuse of discretion not to allow that question?
As the Commonwealth, I would still object to that question for the same grounds. However, I don't think I would appeal it if the judge, in their discretion, allowed it.
What would be the grounds that you would have argued that that was not an appropriate question to the jury to determine whether or not they had a fixed belief that would be disqualifying?
I think even in the more neutral way that you worded it, I still think that it has sort of a slant, as you will, of saying, a credibility is in question. And I think that that's something that could come out in argument. I think it's something that can come out in trial, but I don't think it's as relevant, or at least more relevant than any other type of witness or victim, that it requires its own voir dire question. I think that the broader question of, here are the facts, I'm the judge, I'm going to tell you and instruct you on the law. Can you follow that instructions? Can you be fair and impartial? I think is more than sufficient. However, to the second part of your question, if the judge then did grant the question, it's not something I think the Commonwealth would appeal, because it falls, much as these questions, within the trial court's discretion.
Counsel, so for example, if this question was asked, first of all, let's understand that our decision today will have a real practical effect every day in trial. So for an attorney to ask that question through voir dire, the purpose, as we know, is that you want to find out who you don't want on your jury. That's our purpose as an attorney, the trial attorney. You ask that question to elicit a biasness. The remedy is you ask for that juror to be struck for cause. Doesn't that remedy your error such that we meet the need and the purpose of voir dire, challenging or eliciting biases, such that we now have a fundamental basis for a strike for cause or a parental?
I mean, if the question was asked hypothetically, then yes, but I don't think we actually get to that issue here, partially because the question wasn't allowed to be asked.
But see, that was an excellent question, because if your answer to his question is that would be a strike for cause, then it was a question that should have been asked. If that's a strike for cause, then that's a question that should have been asked. If it still falls into the category of it's a peremptory, then you're in that discretionary area. But if you get a response to this question one way or another that there's a fixed bias, that would be a strike for cause, wouldn't it?
It would be, and I'm not disagreeing with that. What I'm saying is that the actual facts of this case is that a significantly similar enough question was in fact asked, and it did in fact lead to, more than 20 plus strikes for causes.
Yeah, but why wouldn't that be construed as an abuse of discretion? Because now the judge has prohibited the inquiry in the basis, violate the basis of voir dire. That's to try to find out the jurors we don't want, implicit bias, things of that nature.
I believe if the question would have been rejected and the similar question to gather out those biases had not been asked, then maybe this court would have grounds to say that, hey, the court didn't go into this particular topic well enough and that an abuse of discretion occurred. However, the facts of this case are that while the particularly badly worded question wasn't given, a question designed to gather out those same biases.
What was that question again, counsel?
The question, it was specifically, the court listed off every single charge that the defendant was facing and explained that the allegations against the defendant were against a 6 and an 8-year-old, and then it asked, given the nature of those charges, could each prospective juror be fair and impartial and follow the instructions of the trial court?
That doesn't probe bias of a witness. Because you could potentially have a child sex prosecution that doesn't have the child testify.
Right.
You could, but
Throw that 10 years doctrine in there.
Perhaps. I'm sorry, I'm not quite understanding your question, Justice Robson.
I'm saying, you're saying that was a question that encompasses eliciting the bias. My point is that question only talks about the charges. It doesn't get to the question of witness, a bias in favor of a particular witness's credibility, because you could have that case, that charge, without a child witness testifying.
You could.
The prosecution could have plenty of other evidence and not have to put the child, necessarily on the stand in the middle of it or something like that.
They could, but I don't believe that a question designed just to get a specific witness's credibility is a proper.
No, it goes back to my point. And again, it's why we're here, right? We have a slew of cases that say it's actual error for a judge to refuse to allow a question during voir dire about police officers, prisoners, gang members. Those are all proper subjects for voir dire. You're saying this class, or you would argue it's not a class, but that this is different. Children testifying about being victims of child abuse is not a mandatory, allowable area of inquiry. And I'm trying to understand what is the unifying principle. I understand discretion. I don't think this case is about a discretion. I think the judge exercised the discretion and the judge exercised it. The question is, does this fall into those class of cases where courts have said, no, this has to be allowed if it's asked for?
Okay. No, I do not believe it falls under that category.
And the question is why?
If I were to name that young children as a class, I would say they're a class of victims. And when you talked about the police officers, the correction officers, they're not a class of victims. They are a class that is defined by a particular status, which has credibility kind of interwoven in there.
What if the police officer was the victim?
Well, then that question, which, as you said, is already allowable, I think it would still be allowable. And it would be allowable, again, because police officers, as a class, have a certain amount of reliability, or at least a belief that there's a reliability, into their official status. Children don't have that.
But your counsel just came up here and argued the exact opposite. That's what I'm trying to understand. What is the mooring? What is the? I mean, if we just say everything's an abuse of discretion, then there's never an abuse of discretion. I mean, it's a very high standard to meet, and I understand that. But the fact of the matter is, there's case law out there that says it is not just an abuse of discretion, but a violation of constitutional rights to not allow a defendant to probe certain biases. And what is it about this potential area of bias that is different from those areas where courts have said that? And all you're telling me is, I don't personally believe that children victims have any credibility higher or lower in the community. Your counsel just said the opposite.
I disagree with counsel, respectfully. Our position is, and I'm sorry, I'm not intending to make light, Justice Browson, but I am saying that the particularly official status of police officers, correctional officers, versus a particular reputation for gang members, for inmates, it's pretty universally held. Inmates bad, they've done bad things, they've committed crimes, police officers are the good guys, that's the general thing. Children can go one way or the other. There is a child out there that is the most sweet, honest child out there. There's another child with a face full of crumbs saying, I didn't eat the cookies. And I think that, trying to make them a particular class and say that, they have some sort of inherent reliability or inherent disreliability, I think is just incorrect.
Well, I think in addition to that point, every child's circumstance is different. Is there someone that could be coaching the child? Is the child a child that has been saying this consistently for 3 years and no one's listened? There are so many circumstances that could influence whether the child is believable or not that I think supports your position that they can't be just put into some specific class of more or less credible.
I agree with that, Your Honor. And I think, in particular in this case, the judge actually gave, further instructions or I guess questions to the voir dire persons explaining about how credibility will be determined. I believe the court's words were regardless of status and regardless of what one does for a living, and based on what they were able to see. And, but the specifics of whether or not that credibility can be challenged, that can absolutely be challenged at trial. But when we're talking about voir dire, the purpose there is to determine whether or not generally, the impaneled jurors can be fair, impartial, competent, and unprejudicial and follow the court's instructions. And I think that was sufficiently done here and the court didn't abuse its discretion.
Any other questions? Both counsel, outstanding arguments. Thank you very much.
Thank you.
Would you call the next case, Mr. Minner?
In the interest of E.D.A. third et al., appeal of E.D.A. junior father and TMA mother, representing E.D.A. father Thomas Gregory Jr., representing mother Miss Andrea Fitzsimmons, representing E.J.A. Representing R.N.A. Miss Peter representing E.J.A. Miss Rachel Coates, and representing Ellie's Mr. Martin.
Good afternoon.
Good afternoon.
In this appeal by allowance, the trial court terminated the parental rights of mother and father to their 5 minor children, and the Superior Court affirmed. The question before us is whether the trial court abused its discretion in concluding that clear and convincing evidence existed to support termination, where the trial court based its decision upon the testimony of one witness without acknowledging the competent testimony of multiple other witnesses who contradicted that one witness's testimony. Before you begin, please tell me how many of you plan to argue.
Your Honor, I would just note that I'm going to argue on behalf of Mom. Attorney Fitzsimmons is going to argue, and both attorneys Forey and Hoke are going to argue on behalf of the legal counsel that they are for. I believe, I'm not sure on which side.
I'll let them speak for themselves as to who on this side of the room is planning to argue.
Myself, Your Honor, Martin
Okay. All right, primary or only?
We'll say
Oh, I like that, okay.
Lorraine Adelaide wants to add something, but I think
To answer questions, all right, thank you. We will proceed then, but let me just caution you that since we have multiple advocates, we don't want to hear repetitive arguments. Okay, please proceed.
Thank you. May it please the court, good afternoon, your honors. As I stated, my name is Tom Gregory. I am here on behalf of the father of the 5 children.
And you're going to have to lift the microphone a little bit. Thank you.
And sometimes, unfortunately, my voice goes in and out, so I apologize for that. Attorney Fitzsimmons is here, and she represents the mother of the children. Attorney Forey is legal counsel for RMA, one of the children. And Attorney Brandy Hoke is a legal counsel for one of the children, E.D.A. Based on the way that the court outlined this issue, I'm going to address clear and convincing evidence and abuse of discretion. Attorney Fitzsimmons is going to address credibility with respect to the witnesses, and Attorneys Hoke and Forey are going to deal with policy ramifications. To answer the question that the court outlined here, no, clear and convincing evidence did not exist in this case to terminate parental rights. Clear and convincing evidence, as we all know, is the highest standard of proof we have in a civil proceeding. So what did the court consider in this case? As outlined by the issue with this court, it appears that the court considered the testimony of one witness. I say appears because throughout the court's 1925 opinion, it never even addresses the other witnesses. I would note also that when the hearing ended on the termination, the court granted it, I asked the court with respect to what subsections they were going to terminate. The court said whatever the agency filed under. So the lower court has never really addressed what it considered other than the one witness.
So wait a minute, counsel, if I may, sir. It sounds like you're making a sort of a weight argument then. I thought you had a legal premise that you insist that one witness's testimony alone cannot, as a matter of law, provide clear and convincing evidence. Is that your position?
I do not. Well, my argument is not, and I can't cite you case law that says that the court only considered one witness. My argument is that under clear and convincing evidence, if you look at that one witness and you look at the testimony, again, it's not mentioned, but there were 9 other witnesses who testified. Understand that this is not a situation whoever puts the most witnesses up win. I am not saying that. It is an evidence. What you do is you look at clear and convincing. Can the court look at one witness and determine that that's clear and convincing evidence? That's up based on the facts? Yeah, that's possible that that could happen. In this situation, again, understanding that when you deal with an abuse of discretion, I understand what that is, and I understand that this court and the appellate courts do not want to look at every single case. That's not what they're supposed to do. My position here, though, is, as I think Justice Robson said earlier about abuse of discretion, we have to look for that, because in this situation, what the judge did was the judge looked at one witness. Now, having said that, when you look at the issues that he had to address, for example, there was one witness who said that she spent between 200 and 400 hours with the family and the children. She saw no safety issues, and they testified that when the case began, mother actually did more of the parenting, but over the course of time and dealing with the team, the father became more active and did a very good job. 200 to 400 hours. The witness that the court accepted testified that based upon her schedule, she had approximately 6 hours that she spent over the course of time with these children. So going back in, had she been the only witness? Yes, but when you look at, as this court outlined, the contradictory testimony of the other witnesses. Another example is at this hearing, or the termination hearings, there were 3 witnesses who were actually, I believe, called by children and youth. It was a Jasmine Monroe, It was a Janelle Wiley Kelly and Nicole Lamb who testified as to progress that these parents made with respect to drug and alcohol. You also heard testimony that the parents had not tested positive for no illegal drug for 18 or 19 months leading up to this. Instead, again, if you look at the court's decision, I assume they listened to what the caseworker who said she still had concerns. But again, going back to what I said with respect to abuse of discretion, you have to look at this and say, was it manifestly reasonable to do this? And when you look at this, we do not have a situation where we just rubber stamp. Obviously, in children and youth petitions to terminate parental rights, you have a situation where they file a petition, there's a verification sign. Usually this is a caseworker. If we're going to have a situation that just because the agency says it happens, then there's a problem. We don't do that because what we do is we hope that the court listens to the testimony and will decide clear and convincing evidence considering all that. I can't stand here and tell you what the lower court thought of the 9 other witnesses who, in essence, testified on behalf of the parents.
Can I follow up briefly on that? Because it seems as if, I understand your client is disappointed that the trial court chose to indicate that Ms. Marshall's testimony, I think I have the name right, was most compelling. But the trial judge also talked about Luciano's testimony, and is it Longnecker and somebody else in here. I guess your client feels that the judge neglected the other, was it 8 or 9 people you're talking about? But it's apparent he wasn't just phoning this in. He wrote a 30-page opinion, and I guess given the question, the issue presented for us, as I was preparing for this case, I was wondering whether you're asking us to articulate a standard of law which would be cited in future cases as some mathematical proposition that is going to require. We already require our dependency and our family court juvenile judges to do a lot of work and jump through a lot of hoops. And I'm worried that the hoop you're proposing would suggest to them they have some mathematical requirement to tally up how many witnesses are on one side or the other, and then recite by name all the witnesses who they did not choose to credit. And I'm not aware we do that in any area of law.
Well, I would tell you that dealing with only your county, please understand that we do have at least one judge who at the end, giving a decision, will address and name each of the witnesses that were called, and will sometimes say whether he determines that they're credible. I understand not every judge wants to do that. But here, at the end of this hearing, the judge didn't address anybody. And in the 1925, what I'm going to say, again, and if I'm wrong, I stand corrected, but what the judge did in the lower court in the 1925 is he did address other people in hearings leading up to the termination hearing. Having said that, in the Superior Court decision here in the dissent outlined each of the prior hearings and actually refuted what the lower court judge said with respect to those witnesses. So when it came to the actual 1925, he may have spent close to 30 pages. He didn't address the testimony of any of the drug and alcohol people who testified as to the parents. He didn't address anybody, other than what he mentioned for the past. Here, as I say, this, to go back to also what he said, this is not just a disappointment. We deal with this all the time where you go in, we may not agree with the decision, but it is what it is. And again, that is why the appellate standard of review is as high as it is. You're not supposed to go in and second guess every case. It is my argument based upon the evidence that was presented here. This is not a close call. I'm not asking the court to say, substitute your judgment for what they did. This is not a close call. Also, what wasn't mentioned, and I think it has to be mentioned here when you deal with abuse of discretion, is there were a number of witnesses who testified not only contradicting Kristen Marshall, but also saying horribly inappropriate things that were being said, such as, I know these parents are still using, I think they're dealing, I got to be able, I'm not sure how I can prove that. These are horrible things being said. There was a case of somebody who works for children and youth who basically came forward and said, she's saying derogatory things.
Counsel, I apologize, but I have to bring back the question Justice Weck asked. It sounds as if you're asking us to do error review. What is it that you're asking us to do?
What I'm asking to do is, as I said, there's a reason we have an abuse of discretion standard, and I think that applies here, because when you look at the totality of the case, the decision entered by the lower court, it can't be supported. Again, this is...
But it was a credibility call by the trial judge.
Obviously, as I think I mentioned before, Attorney Fitzsimmons is going to deal with credibility, so I don't want to step on her toes. But credibility, I agree that there's case law that says the fact finder is the determiner of credibility. But the rest of that phrase is if supported by the record. And my position here is just because a caseworker or a witness says something doesn't make it so. And just because the lower court...
It does if the judge believes it.
And that's why we have appellate courts.
I got it.
So...
Counsel, can I get back to, so the standard is clear and convincing evidence, right?
At that level, yes.
So highly substantially more likely to be true.
It's the highest standard we have, yeah.
Okay. So to Justice Weck's line of questioning, there are a couple of instances that I am aware of where we do require judges or jurists or quasi-judicial officers to give more meaning to a review or explanation for their rulings. So in the workers' comp sense, workers' comp judges have to issue reasoned decisions. So to give a reasoned decision, they actually have to go through the evidence and explain the evidence. There's also a principle called capricious disregard of evidence, which is where there's uncontradicted evidence of the record, that is it's uncontradicted, and it goes to a matter decided by the judge, and the judge reaches a decision contrary to the uncontradicted testimony. The judge is required to explain why the judge ignored the uncontradictory evidence or didn't give it. So there's principles like that. Your request doesn't fall into any of those. Your request seems to be that if you put all the other witnesses aside, the witnesses that were favorable to your client, could you say that the trial court judge here, that the judge abused the discretion by relying on the testimony of one witness?
The only reason I'm hesitating to answer that is because that's taking it in a vacuum. If you only have one witness, then the judge doesn't have anybody to compare that witness to. The judge is going to hear that and make a credibility.
It's the comparison thing that I'm struggling with, because in other than the context that I've just laid out, I am not aware of any context, and it seems like the precedent is pretty uniformly across the board, that we do not require our judges to cite the evidence that they didn't follow. We require them to cite the evidence that they did rely on, right?
Yes.
So I'm trying to find out now. I've given you a couple of exceptions. Tell me why in this case we should add this additional exception that you're talking about in this context.
Well, I will say that obviously, one, because that's the way this court phrased the question to me when it says about contradictory testimony. I think that it just goes for appellate reasons, as I say. Otherwise, to be honest, it said in the dissent that possibly there would not have been a dissent had the lower court acknowledged the other witnesses. I think based upon, as I say, the judge didn't have to, when he entered the decision, say anything. But when you do a 1925 statement or opinion, and you outline, but you don't even do it. I can't stand here and tell you if the judge gave any consideration at all to those 9 witnesses.
We sort of presume in the cases in the general rule that a judge looks at all the evidence, renders a decision, and then must explain the evidence that the judge relied on in reaching the decision they reached. In that paradigm, we don't also then require the judge to also explain why they didn't rely on the other contradictory evidence. It's sort of assumed that if you adopted one story, you rejected the other. And I'm asking, why is that not enough here? What is it about the nature of this proceeding that suggests we should jump out of the normal paradigm into the capricious disregard paradigm, the reasoned decision paradigm? What is it about this type of proceeding that suggests we should do that?
I would argue that it is because of the facts of this individual case and the 9 other witnesses, and the fact that, again, it was contradictory. So if we wanted to just assume that the judge accepted what the judge accepted, again, then I don't understand what appellate review is and manifest unreasonableness is. When the judge basically, whether the judge had, to be honest with you, despite what the dissent had said, I would probably still be here arguing that even if he had addressed the other witnesses in his opinion, based upon the clear and convincing evidence, it was an abuse of discretion.
Well, that goes to Justice Weck's concern about all you're doing is figuring out who has more witnesses on their side.
But it's not. I think the question is the clear and convincing, and when you listen to and you consider all of those witnesses' testimony, again, could it have been 2? Could it have been 3? This is not a sporting event where you have more. You look at the substance of the testimony. And again, it's just the simplest and one to go back to is, are you going to listen and take the accept that I saw 6 hours? Or are you going to say I saw between 200 and 400 hours? I can't give you a more blatant example of why this is not a situation where it should be okay to say I believed one thing and didn't listen, and don't cite or refer to anything else.
Counsel, let me ask you just a couple of more specific questions, because you stated earlier that there has to be evidence of record to support the Orphans Court's findings. So the Orphans Court found, for example, that the parents didn't provide CYF with sufficient documentation verifying their employment.
It says that, but again, if you look at the dissent, it says they provided to the team.
Don't look at the dissent, look at the record. I mean,
that is a record.
Wasn't the evidence of record that CYF asked for information regarding income, and CYF was given information regarding income, and if CYF wanted information regarding expenses, all they had to do was ask for it? Wasn't that the testimony of record in this case?
There's testimony of record that the agency asked for information. There's also evidence of record where the parents provided information to the team, who then provided information. Now, it does say, I think, in the record, I don't want to misstate this, I apologize, but certain things that they did not feel were necessary were blacked out. The parents...
There was information regarding expenses, and I'm just relying on the testimony of the team, who the parents were told to work with, and then provided information through the team to CYF.
And I think that's what they did. And I said, I think, for the example, usually you want to know expenses. Again, and this is referenced in the dissent, so I apologize I keep going back to that, but we had a situation here where the parents had the same housing from, I believe it was like October of 2020. So this isn't, I understand they want to know the expenses, but the parents were in the same house. There was, with respect to income, yes, father had changed jobs, I think if you look at the record, a number of times. But what was consistent is father was employed consistently. So I understand the agency wanting this information. I believe, and again, I don't want to misstate this, I believe the agency presented this, if maybe just to the team, who then presented information. So I don't want to misstate that. But I believe that this information was provided. That's really all I have to say.
Well, I guess the stumbling, well, I keep coming back to your statement of question presented, which I thought was making some assertion. I thought a difficult one to make, but nonetheless a legal assertion about the amount of testimony required as compared to a lack of acknowledgement of competent testimony on the other side, and how we were going to deal with that. But consistent with my fear, this just, it boils down to a review of how this juvenile court judge exercised his discretion. And I mean, there are multiple review hearings. There's been, this family's been under under care since 2019. The trial judge made the findings he made. There's a thing Justice Doherty and I saw many times where there's an acrimonious relationship between the parents and the caseworker, and I don't know why this case is militating for a new legal standard from this court. What is it about this case that is so remarkably different from our TPR cases globally?
I would argue that, again, it is the individual facts of this case, and we don't have a system where a lower court judge just rubber stamps what the caseworker says. We had information here contradicting. Again, it wasn't just a little bit different, it was contradicting. So this is different than, as I say, we've all been involved in many termination of parental rights cases, and I don't, as a representing parents usually, I don't have to agree with it, but I understand what it is. This is a situation where it was so blatant that the testimony presented by the agency was not clear and convincing when you consider the entire record.
Counsel, share with me in this, from a factual basis. When I read the judge's order, he had his child, who was now around 12 or 13 when she was 2 years of age. So are we talking about CYD involvement in this family over a decade, and you're saying that there's not sufficient information to justify by clear and convincing evidence that a termination is required?
I would say, I'm sorry.
The first question, is it a matter of record that this family, this mother, has been involved with CYD for at least 10 years or more?
And I have to say to you, I don't know, because I represent the father, and he's not the father of that child. So whether or not...
So you don't know the history of this case?
I know the history of this case, and there's the 5 children involved in this.
You don't think it's relevant to the fact that your client mated with this woman, knowing she's been in custody?
Whether or not...
And that we're not to take into consideration his parental responsibilities?
No.
Okay.
Because if the mother had given custody to a family member, that is the decision that father was not involved in, and I can't tell you what he thought of it at the time. What I can tell you is here, the agency became involved with respect to my client's children. They put a team in, he was cooperative, he made progress, and I have no idea if the court considered that. I would argue that the court did not. And the failure, and even if the court had considered it based upon their totality, again, I would argue that it's an abuse of discretion.
And since there appears to be fathers, was it your client that OD'd, was placed on a respirator for drug addiction? Overdosing fentanyl, was that it?
That is correct.
And he used Narcan?
I believe that back when the case...
And when did that happen?
That happened right as the case began. So again, I apologize for not having everything right in front of me. But when the case began, because what happened, obviously, we're not disputing that the children were adjudicated dependent with just cause. That's not the issue. I can tell you that from, I believe it was, and I apologize if I misstate this, October of 2020, father did not test positive for another illegal drug. So yes, the agency had every right to be involved with. Understand, at that point, there was only 4 children. There wasn't the 5th.
I don't want to get into a factual dispute, but the father was in a drug treatment program, was he not?
He was in the methadone treatment, and I think it was in November of 2021 that he actually completed it because he weaned off of it.
November 8th, I believe, because the hearing was November 10th.
Yes, sir. So, so again, when you look, again, under the sections and you look at the conditions which resulted in the placement, when you look at the specific, like A5, obviously the children came into care, 4 of the 5, because of the drug situation. The reason I say 4 of the 5, obviously, is that the one wasn't born until the following July. So you look at the facts of that situation, and what did Dad do with respect to his drug issue? There was testimony that no agency person can dispute that. Now, the agency could say, and I referenced this, well, he tested positive for alcohol on 2 occasions. Off the top of my head, I can't tell you the date, but I think the judge had looked at whether or not if you are on methadone while you're drinking, but we all know, as you just noted, he was off methadone. So you look at the individual situation like that, he had addressed the drug and alcohol issue. You look at one of the issues that he mentioned was parenting and forms of discipline, because there was a finding of abuse in this case. But as I've argued before in the briefs, the agency knew that when the case started. Had they wanted to put in any classes, they would have done that, and a team saw the father with the children 200 to 400 hours. So, again, going back to what was said over here, is I think when you look at the facts of the case, and again, you don't have to accept the trial court's conclusions or inferences, the facts did not support, and not only didn't they support, I would argue that it was manifestly unreasonable.
May I ask you, are the children all in kinship care presently?
I believe so. As I said, obviously, unfortunately, this case has gone on for so long because we filed the appeal, I believe, in May of 2022, and the Superior Court didn't enter a decision until December 14th, 2023. So I know your county is required to continue having hearings. I'm assuming that they're still in kinship care, but we're not included in the hearings after termination, so I have not been present for any of those.
All right, thank you.
Thank you.
Ms. Fitzsimmons?
Good afternoon, and may it please the court. My name is Andrea Fitzsimmons, and I represent the mother, TWA. I apologize in advance for my nerves. This is my first time before this court.
You represent the mother, not the defunct airline.
I represent the mother, correct.
You're too young to remember TWA.
As a preliminary matter, could you just answer my question that I asked father's attorney? Are the children still in kinship care?
I have the same sentiment as Attorney Gregory before me. Unfortunately, we're not involved in the case after the TPR as parents' counsel. I believe that children and youth would have that answer. I do not have that. My understanding is that they are still.
Fine. Go ahead.
Okay. So at this time, I would echo the sentiments of Attorney Gregory, who argued before me. As he stated, I would be focusing on the determination of credibility and the weight of the evidence that it's assigned. It's well established that the trial court is the fact finder for credibility and weight. In TB versus LRM, with this court, it was decided that a trial court holds an evidentiary hearing. It must weigh the evidence and make credibility determinations to resolve any conflicts in the testimony.
So I guess you're the one I asked the question to.
Sure.
Is it a fact that this record reveals that your client has been involved with children and youth over a decade?
I actually would indicate that what came out in the evidence and the testimony was that they were involved in 2019 going forward. I believe that was the first. That was.
I'm asking about, because we're talking credibility in the evidence. Is it a fact in this case that your client lost a...
To tell you specifically, but I don't believe CYF was involved. According to the family service plans that were provided, CYF only began involvement with this family beginning in 2019.
But we have to take into consideration, was the purpose of the transfer of custody mother's addiction issues and substance abuse issues?
Had I not been, I was not necessarily her counsel then, so I can't say specifically, but I...
You don't think that's relevant for the purposes of this current dependency matter?
Well, because that child is not the one that was necessarily placed into care, Your Honor, I don't necessarily...
Under the 2511 factors, particularly the A factors, we need to look at the history to determine if there's a prior history of parental neglect and abuse, whether it's that child or not, such that an aggravating factor could have been considered. True?
I would note that she is having ongoing custody and had contact with that child ongoing with Ms. Vanek in a shared custody arrangement. So I don't necessarily know that it was just as though she has neglected or left that child and, you know, moved on with her life. She was still having ongoing custody and contact with that child throughout our case.
And it's your opinion before this court that because you can't articulate those facts, that a judge abused his discretion in assuming some of that basis of the reports that were submitted into evidence that he met clear and convincing evidence that your client violated a 2511A factor and then found out through a bonding concern that B was met as well, such that termination was correct?
Well, I wouldn't know what the trial court weighed in it, determining its evidence, because the court didn't tell us that. And I think that that is part of the concern. If I knew what they had decided to weigh and what either occurred at the orphans court level or prior to it, then maybe I would be able to make that and articulate that argument. But I don't think that the trial court told us that, and I think that that is the issue at hand.
That is it. That is a matter of interest in the case, and I'm sure it's part of what brings us here. I guess it brings up we have to try to wrestle with legal questions here. So is it, how much detail do you think a trial court has to provide to justify its credibility determinations? You know, because again, as I said to your co-counsel, generally in our law, we don't demand that trial judges enumerate every single witness and compare and contrast the relative quantum of credibility with each of them. Here we have a 29 or 30 page opinion, and obviously credited Marshall. Obviously there's acrimony between your clients and Marshall, which is fine. And I guess I'm just not aware of any authority which would support the proposition that the judge has to allay your disappointment, your understandable disappointment, by saying why in each instance Marshall struck him as more compelling than mother and father and these other witnesses. Because generally when a judge gives us an opinion and tells us what he or she credited, we can infer that things not mentioned were not as compelling. No?
So I can understand your point to an extent, Justice Weck, but I think the issue here is really the outstanding way in which the judge, the trial court judge, had decided to follow just the one witness versus multiple other professional witnesses who were seeing these parents specifically at a much more intense scope. So you're talking about professional drug and alcohol counselors who both boasted about how well the parents had been doing, father weaning off of methadone and mother being consistently negative and maintaining and following and doing actual additional classes than what was expected of her. We're talking about yet another a whole in-home team, all of which we're seeing the additional hours and the extra time. And so they're seeing it under a much more intense scope than this broad scope that Ms. Marshall was viewing this case. And so when the facts are so specific that they completely contradict, I think that the court has to address why on some level. I'm not saying go through every single case and say this person was not credible, this person was not credible, this is why.
Counsel, if I could, first of all, I can't tell that you're nervous. You're doing great. I think I understand your argument. I get it. You're basically saying it's this case. There's just so much here. It's irreconcilable. It's irrational almost for the trial court judge would have just listened to Marshall and not explained all that. It's just overwhelmingly they're arguably absolutely impartial. You know, they're professionals. I understand what you're saying, but to Justice Weck's point, what is the articulable legal standard? You know, when does that kick in? So take your facts in this case and tell me what is the standard that we can tell trial court judges in this setting that you can't just put an opinion down that tells us the evidence that you relied on. Under X circumstances, you must also tell us why you didn't rely on other evidence. What's the articulable legal standard?
It's an excellent question, and I feel if I was a judge, maybe I might have a much better answer. I think in looking at it, I think from my perspective, I would argue that we have, in fact, children and youth contracted teams specifically that had not just at the termination of parental rights but also at prior hearings, complete contradictory evidence. So we've built up that case. So I'm not sure, I mean, I don't know, I can't say it's a 2-to-1 or, 3 witnesses testify and then automatically, we start looking at credibility. I think it has to be a totality of the circumstances, and arguing that, when there's, especially in a case like this where there's so much, you have to say why you weren't willing to listen to, I guess, or look at the entire forest and just pay attention to the one tree. That's the issue that we have before us. I don't necessarily know that I have an answer that can say when you need to do that, because it's not like these parents brought in a courtroom full of best friends and they brought up each witness and said, hey, tell everybody I'm a good parent and I should have my kids back. These were professionals. These were people that did intense amount of hours with the team.
They were arguably disinterested, impartial professionals.
Correct, and like I indicated, professionals that were contracted by children and youth, some of them at least, to be working with this family and doing these areas. Previous to even the termination, one of the in-home teams that was working specific to housing indicated we're closing successfully. All of the goals have been met. And children and youth didn't necessarily object to that. They were like, okay, that team's closing. But then when we get to termination, oh, it's an issue, the housing was not appropriate anymore. Even though then we brought in before day 2, another professional to go look out at the house within that same week. Tell me if the house is appropriate. So,
it just sounds like, if I could just interrupt, I appreciate your response to Justice Props, and just the more I listen to you and your co-counsel, the more I wonder why we granted review of this case, because you have an excellent Superior Court argument, you got an excellent and thorough dissent from Justice McCaffrey, and I think the case could have gone either way. But we're not here to review the evidence the way they did on Superior Court. We're supposed to be here on big legal questions, and I'm not hearing. It's obviously a huge question for your clients. I understand that, I respect that. But I'm not discerning the big legal question.
So I would disagree, because unfortunately, this is setting a precedent for all families that are involved with children and youth. And I think that is the biggest part. We have, nerves. Take
your time.
You're doing really well. You really are.
Thank you.
And if you didn't keep saying you're nervous, I wouldn't even know you were nervous. So.
I think we're looking at this through obviously one family, because that's the case that's before you. But we're not looking at how this impacts families. Ultimately, I would argue if you're only going to listen to the children and youth case, the caseworker herself, why have a hearing? Because ultimately I can just, stamp orders all day that the judge says, okay, the caseworker told me that this family can reunify, this one can't reunify.
So is that your concern? Because I think that's an interesting concern. It was an issue that I saw in the case that didn't seem to come to the fore, which was the judge here, at least in the proceeding, seemed to actually show some level of favoritism toward a witness that the judge should have been treating as any other witness on sort of even footing.
Correct.
In fact, the comment from the bench, I thought at least seemed to me to be somewhat inappropriate.
It was stunning, the defense of her.
Shocking that the judge would do that. And if that were kind of the case you were presenting to me, I'd been like, yeah, I think there might be something there. And that seems to be where your passion is. Your passion is we just don't have a chance. If CYS professionals, at least in this courtroom, are given this advanced standing, like police officers and prison guards and things like that. And is that the crux of your argument?
It absolutely is, because representing, and I do both sides, independency, representing children as well as parents, because I think that gives you a broad view. But sometimes it's extremely defeating when you get up there and you can bring in all the professionals who have all the great things to say, and it's still no. And sometimes, sure, the credibility determination is there. It makes sense ultimately as an attorney. But in a case like this where we had, as was stated, 11 witnesses total testified, and out of that only one was the one that was in support of proceeding and a termination, and that was the one that was chosen. And then you hear a judge that essentially defends, that caseworker. I mean, we have human people that are these parents that are looking at the court and expecting to be treated fairly, and that's not fair.
Ms. Fitzsimmons, did the trial judge give each of the other witnesses adequate time to testify? Did he cut anyone off or refuse to listen to any of their testimony?
I don't believe that he did, Your Honor. I think that he did let them proceed forward, but whether or not he was paying attention, even in the record, there was a few times where either myself or co-counsel had indicated an objection, and I know one point specifically he indicated along the lines of, I'll admit it because I'm not necessarily sure I was paying attention. And I did reference that specifically in my reply brief.
How old are the children presently?
Presently, well, I can tell you at the time of the TPR, so I guess I'll add 2 years. The oldest child is 10 years old, approximately. And then going down from there, we would have 9 years old, 6 years old, 5 years old, and then 3-year-old.
Thank you very much.
Absolutely.
Counsel, do you think this case could have gone either way?
I don't. I really don't. I think that in a lot of times I get before the court in a dependency matter, and I very much worry that we have a case of who's your caseworker, who's your GAL, and who's your judge, and that can determine a whole lot. And that is absolutely terrifying to have to tell parents and be reality. I think, honestly, had we may have had a different judge, I think we would have absolutely had a different outcome.
Okay, well, let's say it could go either way. If
Sure.
a case can go either way, is there clear and convincing evidence to terminate?
Well, I guess it would have to then say, I mean, I would love to see how the judge weighed the evidence to make that decision, and we never got that. It was,
But I mean, as a matter of law.
As a matter of-
If a case can go either way,
well, I
is
think,
it possible to have met the clear and convincing evidence standard, which is so overwhelming
Sure.
that a different conclusion is not possible?
I think the reality of American court system is a lot of times it's who your attorney is that can present the case and be able to help get your side to win or excel in whatever area you are. So I don't necessarily know. I mean, in this case, I don't think that we meet that. But in a case that
let
can.
me ask you a question.
Sure.
What would have given you solace in the trial court's opinion to justify his decision to terminate parental rights?
I think even addressing what was testified to by any of the other members of, the termination hearing, because the individuals that Justice Wecht earlier mentioned, Detective Longnecker and a few others, those were all people that were testifying at prior hearings. So we essentially went through the entirety of the journey of the case through the 1925A, but never necessarily went through the journey of what the Orphans Court decision was at the termination proceeding. I mean, I don't necessarily know that that would give me solace. Obviously, I think the best outcome would have been to be successful in a termination hearing, but I mean, that is not the case that's necessarily before you.
Thank you. Thank you.
Very good job.
Well done. Well done.
Very good job.
Well done. Thank you.
And welcome to our bar.
Indeed. Let us hear from the attorney for RMA, Ms. Ford.
Thank you. And before I begin, I will note that I need to leave at 4 o'clock. I have to catch an international flight at BWI, so I apologize.
We would have put you in earlier had we known that. All right.
At least you won't have to fight the Schuylkill Expressway.
And we promised to let you speak for 10 minutes.
Thank you. Thank you, Your Honors. May it please the Court, my name is Christina Forey. I'm court-appointed legal counsel for RMA, who was the only girl out of these 5 children.
And how old is RMA?
She would be, I believe, 6 now.
She's the 6-year-old, all right?
Yes. I believe it is necessary for a trial court to articulate its findings and its determinations on credibility of testimony, specifically when you have testimony that is so conflicting that it's diametrically opposed. And the reasons we would need to do that is because then the parties, of course, involved in the case know the reasons for the court's decision. If witness A says X, witness B says Z, how the judge weighed that is important for the parties to know.
But it's not required.
It is not at this point required, correct. But it would also put future litigants on notice of how the court would weigh such information. And it helps for appellate review, ultimately, because what we have in this case is a trial court that did not address credibility.
Did you guys request the court to articulate the basis of his finding?
Yes, we did.
And what was the response of the court? I didn't see that in the...
We had asked specifically for the court to identify which sections he was ruling under and why, and he just said whatever the agency filed under. He really didn't give us much of a response.
He didn't indicate 2511A or 1358?
He did not. He did not. He just, because I believe it was Attorney Gregory had asked the question, which sections are you finding under for appeal purposes? And he said all the ones the agency filed on.
Okay.
And the problem with those kinds of answers and having a trial judge who indicates that he's not listening to testimony when objections are raised. And then, of course, as Your Honor noted, the statement on the record in defense of a caseworker who was being identified as potentially a biased witness, it creates the impression that the court had already made its decision long before we even walked in the door. The problem with that, obviously, is we're talking about a parent's constitutional right to raise their children is guaranteed under the Due Process Clause of the 14th Amendment. The state is asking to sever forever a child's connection with their parent and the parent's connection with the child. That cannot be taken lightly. It absolutely cannot.
Well, who suggests that anybody's taking it lightly?
I
mean, you're here in the Supreme Court, so we're not taking it lightly.
And I absolutely appreciate that. My concern is that it appeared by the way that the trial court chose to treat the evidence, that he accepted the statements of the caseworker wholesale, discounted the statements of all other witnesses presented, and effectively rubber-stamped the agency's request for termination.
And I mean, the mosaic you're creating now with your argument is, again, very interesting, and I think that your case is getting more compelling as you go. This isn't just about a run-of-the-mill orphans court decision on the termination of parental rights. There is a lot going on in the history, and particularly in front of this judge, that gives you reason to believe that the judge did disregard, didn't just weigh and credit, just absolutely disregarded it. I mean, you have actually articulable reasons to believe that, as opposed to just speculating about it.
Yes, I absolutely agree, Your Honor.
Are you contending that the judge showed hostility toward you or toward any of the parties or counsel?
I wouldn't call it hostility. It seemed to be indifference.
Okay.
And I have a lot of respect for this trial judge. I'm in front of him a lot, so it's not something that I take saying lightly.
All right, go ahead.
Orders need to be clear so that people can understand where they're coming from. Clarity, predictability, and fairness. How can anyone take this opinion and decide any sort of predictability from it? How can we determine what is or is not fair if we don't know how the trial judge weighed conflicting evidence?
Well, he did that in his 1925 statement, did he not?
He did not.
Articulate the basis of his decision?
Well, he articulated old evidence from prior hearings well prior to the TPR
hearing. It was a
hearing.
30-page order. How is that not an articulation of his findings? Or share with me where the judge is required at the end of the dependency or the end of the hearing to provide a copy of his order immediately, as opposed to the rules that required his mandatory compliance with the 1925A request?
There is no rule that says that a judge has to give their decision immediately.
But you're asking this court to assume and infer bad conduct on a fellow judge of common pleas based upon what legal error?
Well, I'm not asserting that the trial court judge engaged in bad conduct. I want to be very clear on that. My assertion is that he wasn't listening, as he said. He wasn't listening.
Did he say on the record, "I'm not listening"?
There were objections that were stated, and he waved his hand and indicated I wasn't listening anyway.
He said that on the record?
Yes, Your Honor.
I'm sorry, what was it? What did he say?
He indicated that he wasn't listening when an objection was raised to testimony.
Meaning he wasn't listening to the testimony, so
Yes.
he was overruling your objection.
It was not my objection, so
Oh,
I don't
well,
recall.
He was overruling the objection because he didn't listen to the testimony that that was the basis of the objection.
Correct.
Which is also a shocking statement.
Yes, it was. The only way that the trial court can create a clear record is to indicate the reasons for their decisions. Now, I'm not suggesting that a trial court has to go through and identify, as they have to do in other areas of law, each individual piece of testimony, each individual piece of evidence, and weight each one. I think, particularly in any kind of juvenile or family court setting, that's a lot to ask. What I am suggesting is that when there is a direct conflict, it at least needs to be acknowledged. So we have one witness saying one thing and several other witnesses saying something entirely different about the same set of facts. That can't be ignored.
But that's particularly, watching the clock for you, that's particularly the principle that we always follow, where we say that judges are not required to. It's in the presence of conflict, all the judge has to do is point to the evidence that the judge relied on. Ergo, rejecting the other one.
And I appreciate that to a point, Your Honor, but when the statements that are being made are beliefs and suspicions and suppositions, how can that possibly hold up to a provider who spends countless hours with the family on the regular?
Was there objection to that testimony? Because that struck me also. Much of the testimony of caseworker Marshall was her belief or her view or her opinion, versus the testimony of the providers was that they aren't using drugs, they aren't selling drugs, they aren't using alcohol, versus I believe they are. I mean, is that a fact? Can you, because at the bottom line, I mean, the findings of the judge have to be based upon evidence of record.
Most certainly.
And is that evidence?
Well, the fact of the matter is Miss Marshall's supposition that she believed that the parents were finding a way to continue to use drugs while they were being actively drug tested and testing negative. I think the evidence itself is the drug tests. I mean, that directly contradicts what she's indicating.
Well, that's not a credibility determination then. That's just there's no evidence of record to support that kind of finding, correct?
Certainly. I think it's a difference.
Your opinion, because I'm watching the court. I'm watching the clock for you also.
I appreciate that. Thank you.
The dissent in the Superior Court was very deferential to the trial court, which I believe this court is always very deferential to trial courts, as you have been. The dissent's perspective was vacate and send it back to the trial court for an opinion addressing these specific issues. What is your view of the correct disposition of this matter?
Bearing in mind that my responsibility is to the child, not the parents, my position would be that it should be remanded for a clearer opinion. I think that's what needs to happen.
What does that mean, a clearer opinion?
Well, if we put the framework before the trial court that they need to identify the conflicts in the evidence and indicate how they've determined credibility or weighted what weight they assign to that specific evidence, that'll give us a clearer order. It may not be what the parents want, certainly, but I think it gives the public, the parties in the case, a knowledge of how these types of things are going to be addressed by this court going forward. by the trial court going forward. Because the alternative that we have here, quite frankly, is we have what appears to be an arbitrary order from a judge who's making statements on behalf of a caseworker who, well, regardless.
Is the child that you represent in kinship care presently?
We are no longer, we don't, once the TPR happened, none of the legal counsel for the children were permitted to continue to participate. We were removed from the case, so I have no idea.
You could ask them.
I will. I will.
I wish I did know that, honestly.
Okay,
I would have loved to keep tabs on her.
I didn't realize that you wouldn't know. All right, thank you.
No, that's all right.
Do you want to leave for the airport now?
I expect I probably do.
Okay, all right, thank you.
Have a safe flight.
Thank you.
Yeah,
Thank you very much, Your Honor.
understand your
Appreciate
argument. Thank you. Safe travels. All right, let's hear from the attorney for E.D.A.
Yes.
Is that right? All right.
May it please the court, I'm Attorney Hoke. He is the 5-year-old.
I can't
Speak up, please.
Sorry, sure. I am Attorney Hoke, and he is currently the 5-year-old. That's how old he is. He was
Okay,
approximately
thank
2 years old at the time of the TPR hearing. I want to try to just address some of the questions that I heard coming from the panel. What I'm asking the court to do is when you have two witnesses that could both be deemed as credible, on its face a caseworker is deemed credible. On its face, an in-home professional or a professional drug and alcohol counselor are also deemed credible. But they're saying two completely different things. What I'm asking the court to do is just do an analysis to reconcile those differences.
But we don't do that anywhere. I mean, in the case of conflicting evidence, there's no reason to require a judge to do that because you have to resolve the conflict, and it's implicit by adopting one piece of conflicting evidence, you're rejecting the other. I mean, that's the reason. We have to pick, we're the court, we have to pick, we're picking this one.
And I think what I'm asking the court to do, though, is behind the scenes in the judge's mind, he's doing that analysis, and he's saying, this is why I found this witness credible and not this one. I just want the judge to be able to reduce it to paper and articulate, this is why. I put in my brief, as an example, a case from 2013 where the judge did that, and there were different members.
Counsels, other than 1925A, share with me the procedural rule that requires the judge to provide you an order that you want.
There is currently not, however.
That's exactly my point.
However,
so what you're asking us to do is what? Make a new rule up?
To give them a roadmap to create a new rule.
Office of Children and the Family in the Court, you read the dependency handbook, correct?
Correct, Your Honor.
And if you go under the section that talks about termination of parental rights, there's a commentary section that indicates judges should make good records in lieu of a written opinion so that in its 1925A it can only refer back to those particular pages for purposes of our fast track appeal. You're aware of that, correct?
I am.
And is that what was performed in this particular case? Was there a 1925 statement that referred back to the history of the case? 30 pages worth of it?
There was.
And how many more pages did you need?
In answer to your question, at the TPR hearing, there was nothing put on the record that was based on evidence presented at the specific TPR hearing that justified the judge's decision.
And did you appeal the fact that the judge did not articulate a factor under 2511A or his understanding of what the 2511B facts were? Did we appeal that?
I appealed all of them because the judge had said on the record that he was terminating parental rights under every section the agency had filed under.
And what did the Superior Court do?
They affirmed.
And did you appeal that?
We did. Well, the parents appealed that.
I'm asking you.
I did not.
Okay, but that's the issue before the court. The issue is that the judge did not articulate the basis of the 2511 that he granted without you knowing, which was the purpose of an appeal which would have come here for a determination of whether the judge abused his discretion, which you probably would have gotten a unanimous yes. But instead, The question is one of error review and for us to reprimand or educate a dependency judge as to complete an order that caters to your need. Tell me how that's not what you're asking.
That is what I'm asking, and I will tell you why. I do a lot of family law practice too. And if we were changing custody from one parent to the other parent, we would make the judge not necessarily have to dictate it right then on the record, but they do have to file an opinion.
Well, it's a little bit different because there you have the factors that the legislature laid out. So custody, it's a different ball of wax there, and I guess I'm not hearing from you a basis upon which we should add to their fast track obligations an obligation to compare and contrast each item of countervailing testimony, which there clearly was, as compared to the traditional standard that we infer when a judge writes his or her opinion and discusses the evidence that he or she found most compelling, that the other evidence was, for him or her, less compelling.
I think with this is not like custody. It's not, where it's a temporary change and a parent can turn around and they can just file in another year. This is permanent. These families are torn apart.
Everybody here understands the enormous stakes involved and the enormous emotions involved, and as I say, Justice Doherty and I judged many of these as trial court judges. So nobody's making light of this situation, but at this court, unlike the Superior Court, where Justice McCaffrey wrote a very thorough dissent, and it could have gone his way, right? It didn't, and you've come to us, and I think I'll speak for myself. I'm searching for a legal hook. Other than, boy, this trial judge really got it wrong, or this trial judge was too close to caseworker Marshall. Not hearing a legal standard. Do you want us to dictate not just for this judge, but for all judges hearing TPRs across the Commonwealth?
Yes. What I'm asking the court to do is so parents aren't sitting guessing what happened here. If the court can articulate, we had two credible witnesses, but for me, this was the deciding factor. And I agree, it's cumbersome for them to have to go through every single court report, every single drug and alcohol test, every single exhibit, and weigh the credibility of each one and every single witness. That's cumbersome. But if there's one specific tangible thing that they can point to, in the case from 2003, what the trial court pulled out and the Superior Court upheld was they said there were witnesses who testified that worked with mom, that mom has these skills. We've worked on parenting. These are things that mom can do. And what they latched onto was testimony of people who had actually witnessed mom in visits and said she might have learned these skills, but she's not actually applying them. She's not actually doing them. And that was where the Superior Court latched on and said because there were specific reasons to reconcile those differences. And that's all I'm asking that the trial courts be made to do, is when you have two credible witnesses that are saying complete polar opposite things, that there is just something. It doesn't have to be lengthy. It can be one line. Just reconcile those differences and why one has more weight than the other.
All right. Thank you very much.
Thank you.
Let's hear from Mr. Miller on behalf of CYF, and perhaps you could introduce or reintroduce your co-counsel.
Good afternoon. My name is Martin Miller, Solicitor for your County Office of Children, Youth, and Family. Seated closest to me is Attorney David Worley, who's guardian ad litem for all 5 of the children. We also have Attorney Christopher Moore, who is legal counsel for E.D.A. the third. We have Attorney Laura Smith, who is legal counsel for A.B.A. And finally, we have Attorney Thomas Kearney, who's legal counsel for B.J.W.
All right. Please proceed.
I'm going to disabuse this concept that the court relied upon one witness. This is the same judge who's heard this case from the beginning. the shelter care, the dependency, all the status reviews, and most importantly, our permanency review hearings, which are our highest level of review. In those 3 permanency review hearings, he consistently and repeatedly found minimal compliance with the permanency plan by mother and father. He consistently found minimal progress toward alleviating the circumstances which necessitated the original placement. When we began our termination, which was a 2-day termination, the trial court incorporated into the orphans court file the actions and proceedings as docketed with the clerk of court in the dependency action. Moreover, there were a number of exhibits that were admitted. We heard testimony from, I believe it was 10 witnesses on the first day of the termination hearing. This same judge has heard this entire matter from the beginning. This same judge heard about the fact that initially the Catholic Charities team closed out unsuccessfully. I believe that's exhibit number 6. We've heard about the team that's working with the parents and how they've observed 400 hours of visitation. That team has been involved with these parents for over a year. Over a year. And we still have not progressed to unsupervised or partially supervised visitation.
Wasn't that because there was the allegations of abuse that were outstanding for that period of time on which no action was taken? That's why they could not
there were allegations
recommend the visitation that you just referred to.
There were allegations of physical abuse involving 2 of the children. Police were allegedly involved. They didn't really move on it. That did serve to retard some issues.
For a year. I mean, you know,
I don't think it was.
I understand your point that we have a judge who is with this throughout, but and one of the reason that it didn't advance is because the parents didn't want to meet with the police without an attorney. I mean, that's their right.
That is their right.
That's their right.
But I think there were other issues in regard to that. And eventually, the agency, we had a finding of abuse hearing.
Just because the judge finally ordered them to act because the police were not.
Correct. The trial court directed the agency to conclude their investigation, because they had pended it, to conclude that investigation by the time we had the next hearing, and the agency did that. But the trial court changed the goal in, I believe, January of 2022. Our termination was in April of 2022. In March of 2022, there were hearings on finding of abuse in regard to both mother and father, in which allegations were that the children were hit with a belt with spikes on it.
2 years prior, and the therapy groups that were working with the parents said that they had progressed from a point in time where they had any concerns about those allegations of abuse. I mean, the reason that ended up on the record as late as it did is because nothing happened with the allegations when they were first made. I mean, what you just recited is correct, but it's historically out of sync because of the delay in the investigation.
Are you asking me a question?
No, I'm just saying your statement was just not an accurate statement of the facts in that regard. Let me ask you another question.
I don't know if I necessarily agree with that, but
I think the point is you're holding that against them.
Yes.
And that was not their fault.
And the judge held it against them, although it wasn't their fault.
But they could have taken mother and father could have taken action, and they never took action.
CYS could have taken action.
Oh, I disagree with that.
The judge could have taken action.
The trial court consistently and repeatedly found in the permanency review orders, 3 of them, that we exercised reasonable efforts to implement the goal, which at that point in time was returned to parent or guardian.
The judge showed a record affinity for CYS. There's no doubt about it.
Well, I would disagree with that conclusion, but That's ultimately your decision to make. I mean, I think it's interesting that there's this vision presented that everything was good with mom and dad. 2 or 3 days before the first day of the termination hearing, our caseworker went to the house that they lived at, which they had lived at for apparently a significant period of time. Dog feces all over, smelled of urine, no sink in the bathroom. And then when the caseworker went to the one room, mom conveniently put her foot over the feces of the dog. But then by the time we went back for the second hearing, about 2 weeks, a little bit more in April, the house apparently was cleaned up.
Is it true mother kept chickens in the house?
I don't recall that.
I remember reading that in the judicial order. I was just wondering.
I don't
part of the feces, there was chicken.
I don't recall that.
That's something that would be hard to forget.
Yeah, I don't recall that. I'll let my colleagues.
Okay.
There's one thing that, Mr. Justice, you asked. All 5 of the children are in the same home that they've been in since, you know, the adjudication and what have you.
And is that a grandparent's home?
I don't know. It's a kinship home. I'm not sure the exact relationship.
But the 5 are together.
Yes. And then there was also an issue raised about mother's older child. I may be incorrect, and our guardian ad litem can correct me. I'm not sure that that child was placed with that family pursuant to under the dependency umbrella. I think it may have been an agreement, but that child has been with that family for a significant period of time as well. I think
Counsel, can I ask you a question real quick? Justice Donahue asked a question earlier, and I thought it was a really interesting one. Do you think this case could have gone either way?
No. No, there was great resistance. Great resistance. Mother and father were supposed to have mental health evaluations. There was difficulty getting that done. Eventually they get that done, and then they start participating in mental health evaluations. And then they stop that.
But they stopped them because of insurance impediments. And when they found out what the insurance impediment was, they started up again.
My recollection is that the reports that we received indicated that they were discharged unsuccessfully, and then they
that may have been very early on in the treatment scheme, but what you're referring to are that there are 2 periods, one for the mother, one for the father, where the where the treatment was terminated because of failure to comply with insurance certifications or whatever, and that was fixed, and then they went back. I mean,
my notes that I wrote in preparation for this hearing was that mother and father did a mental health evaluation. They refused to follow through with recommendations. Later, they started it, but that was unsuccessful.
Counsel, the suggestion that this case could have gone either way reflects that different, skilled, intelligent appellate judges saw it differently, and that on any given day in any given court of common pleas, reasonable, intelligent fact finders, i.e. common pleas judges, could have reached clear and convincing evidence or not reached clear and convincing evidence. What about this case is legally remarkable in any way? What's the legal issue in this case as you see it? Not was there clear and convincing evidence on this or clear and convincing evidence on that, or whether this witness was more compelling than this witness. What's the legal issue for this court from your perspective?
Well, you've defined the legal issue for us, and frankly, I'm not sure why it was accepted, but that's the decision that you made.
Well, let me ask you about clear and convincing evidence for a second. It's a high burden. It's a high
sure,
standard, right? Mm-hmm. If 2 reasonable common pleas court judges could review the evidence and reach different results, how does that satisfy the clear and convincing standard, which requires it to be highly and substantially more likely to be true?
Well, I think the answer to that is the trial court is free to believe all, part, or none of the evidence that's presented.
But that articulation of the law is the exact same articulation of law you would apply to a case that turns on substantial evidence. This is clear and convincing evidence. So So I understand that a trial court judge is free to disregard the evidence, but that's the same standard we apply for substantial evidence cases, which is the absolute lowest burden. So if a reasonable judge in this situation could reach a contrary conclusion based on the evidence of the record, how can we say that this evidence that the trial court judge relied on was so substantially and more likely to be true and meet that clear and convincing standard?
I think part of the trial court's job is to weigh the testimony, what he or she thinks.
I don't disagree with you. I agree with you that what the trial court judge is supposed to do, but that answer doesn't tell me anything differently than how we would look at a trial court judge's findings on a substantial evidence standard versus a clear and convincing evidence standard.
Well, if you believe that his conclusions are based on the record, then my understanding is that appellate courts, generally speaking, defer to what trial courts determine. And I am submitting to you that, contrary to what my friends on the other side indicate, there's a long history of difficulty and really lack of compliance by mother and father.
But eventually they complied. I mean, at least that's the testimony of the treatment professionals at Presley Ridge or whatever the treatment facility was. I mean, you're right. There's a long history. And these parents struggled. I mean, and, there was one hearing in November of 2021 when the orphans court judge said, boy, this is really going in the right direction. A lot of progress was made here. I mean, I think they recognized at that point in time, yeah, they struggled, but, they're really coming around. 2 months later, he's changing the goal at the request of CYS to adoption.
I think another issue that occurred during that time period, Your Honor, is that I'm fairly confident that the agency had received additional referrals in regard to the children, which is different than the referrals we received in regard to the finding of abuse issue, in regard to the belt and the spikes on the belt and what have you.
No, I don't know any of that. I mean, I know about the abuse issues. I know about the abuse issues that dated to the very early involvement of CYF in this case, but I don't know what you're referring to that's of record, because I didn't, parse the record, but I'm certainly not aware of that.
I'm positive we received new referrals and we acted upon them in January. I may be wrong.
I don't know of anything in the record, and I don't recall the orphans court referring to anything such as that. There was an abrupt about face, and it was attendant to the Children and Youth Services decision to move for adoption. That's the goal change. That was the abrupt change. We went from, boy, we're really making progress here, keep up the good work, to we're changing the goal.
Well, with all due respect, Madam Justice, the agency did not file a petition to change the goal in January. Trial court did that sua sponte. That then places us in a position that we're going to have to proceed with the termination. So that's how that kind of unfolded.
Why would that happen, given the trial court's statement on the record? Boy, a lot of progress has been made here. We're moving in the right direction. Why would the trial court sua sponte do that? I mean, you may not know the answer to that. I might be asking you what was in the trial judge's mind, but
sometimes I can't read my wife's mind. I don't know if I can read a judge's mind.
We can take judicial notice.
Yes, exactly.
Yes. There have been, I don't mean to call them allegations, but references to the trial judge being overly deferential to CYF, and particularly to the one caseworker, Ms. Marshall. Can you comment on that?
From my perspective, your county is a small county. We're not Bradford County, we're not Tioga, and we're certainly not Philadelphia or Allegheny. We have the same people that are involved with these matters all the time.
So do we in Philadelphia. Yeah. You're saying you're bigger than Bradford County.
Yeah. Oh, certainly, but my whole point is that it's...
York is not a small county. York is a pretty good-sized county.
My whole point, though, Your Honor, is that it's the same people that are involved. It's the same, not the same, but
Everyone
familiar
knows
faces.
everyone, yeah.
Familiar faces, whether it's our caseworkers, our trial judges, you know, my colleagues and friends that are here, you know, almost half of our dependency bars here today. So it's the same people. So was there a comfort level with trial court and the caseworker? I guess.
Well, it wasn't
But he
just
also-
comfort level. The trial judge said, I am, in response to examination from the parents' counsel, I am going to come to the defense of this caseworker. I'm going to come to the defense of a witness who has counsel there. I mean, I've never heard of a judge doing something like that. I'm going to come to the defense of this witness.
And that was in response to testimony by another CYF caseworker.
Mr. Duggan.
I mean,
Yeah, we're going off on, yeah, I mean, the bottom line in regard to that individual is he was a newly hired caseworker. We're trying to train him, and he was told, go with Miss Marshall to the termination and get a sense of what that's about. So he knew that it was on the schedule. I guess they met a couple days beforehand, and he was not happy with what he saw, and he made comments to my colleagues, and he testified.
That must have been quite a dramatic moment in the York County Court of Common Pleas. I wish I could have seen that.
Yeah, I mean, I don't think it
Well,
said,
maybe I don't.
I can't remember what I represented, but yeah, he quit that day.
Is he still employed?
No, he quit after lunchtime.
I got it.
So-
All right.
I just have one question for you, if I may. Show me or tell me if I'm wrong. There was no, even in the orders, 1925A, there's no discussion of the bond, the 2511B argument by the court.
I don't.
Is that true? Is that true?
I don't recall the 1925. I'm
But-
sure that I am very, very particular, and I'm sure that I had that issue addressed with that, and it's somewhere in the transcript, and I'm sure I referenced it in our brief
I
as
think
well.
To me, that was an important factor. That's,
Sure. Yeah, I know it was addressed. I always address it.
okay, I'll have to look.
Any other questions for Mr. Miller? Thank you, Mr. Miller. I would like to give the guardian ad litem an opportunity if there's anything that you'd like to add.
Thank you. Good
Because
afternoon.
we have all the time in the world.
I know, yeah, we're almost at about 4:30. So may it please the court, my name is Dave Worley. I'm the court-appointed guardian ad litem for
And
all
pull the
five.
microphone a little bit close, up
apologize.
higher to
Oh,
you. You're
higher.
tall. Yeah, there you go.
The court-appointed guardian ad litem for all five children. This is, I've been practicing for 16 years and represented many youth in that time frame, and this is my first time actually before the Pennsylvania Supreme Court. I've been here in this room many times with the Superior Court, but it's a pleasure to be here today.
Welcome.
So the children. The children are in kinship care, just to answer a previous question. They're all doing quite well. I've known them for actually rather too long now. The four oldest ones for about 4 years, and the fifth one for a little bit less than that. They are all placed in a kinship home with two parents. I believe they're cousins or an aunt to the mother. I think that's the relationship, but they don't quote me on that. Yes, they are pre-adoptive. Yes, that's correct. And there is also another child in the home. I believe she's about 15 now, and she has resided in that home, from my understanding, for quite some time, a long time. And I think that was
Another child of mother and father?
Yes, another child of mother. I don't
mother.
think of this father.
This is the child that we heard earlier had been placed with someone voluntarily.
I believe it was through a private custody arrangement. I'm
Okay.
not quite sure. That was long before my time or involvement in the case. But all of the children are doing extremely well. And I was actually just out there last week to the kinship home just to check in with them, make sure they're doing fine. And they are. They're excited for this whole process to be done. They all do wish to be adopted. They all feel very safe. They're all being very well taken care of, all of their medical and educational appointments. I think Attorney Forey said that all counsel were vacated from the case, but that's not true. All the legal counsel, they're still appointed to the orphans court matter. It's just that when a dependency case starts, the guardian ad litem, myself, I'm appointed to the clerk of courts matter. And then when the agency files for termination, then that generates an orphans court docket as well. And then I'm appointed as guardian ad litem in the orphans court, and then the judges typically appoint legal counsel in the orphans court matter. And that those appointments continue until the conclusion of this case, which obviously we're not concluded yet because we're here.
Did you participate in the termination hearings?
Yes, I did, yes. And as far as the children themselves, I agree with the trial court. I think this is in the children's best interest. I think this serves the permanency needs of the children. Again, like I said, I've been with them for a very, very long time. And I've seen them grow up in the system, which is not something that I want to see. But I think this is the absolute best way to move this forward, is for the children to be adopted by their kin, by their family, to remain where they are. And that is what's best for the children, in my opinion.
Are there any questions for the guardian? Thank you so much, sir.
Thank you so much. Thank you.
Thank you all. And Mr. Minner, would you adjourn court?
Where's adjourned?
Before Mr. Minner, I did want to just thank a few people. Just a moment. I wanted to just mention that I wanted to thank PCN for always broadcasting our sessions as an educational tool for the public. We appreciate it. I want to thank our court crier, Brian Minner, our pathonetary, Caitlin Gorman, our court security, John Evans, Gary Shovlin, and Scott Town, as well as the Capitol Police, for all of their assistance to us while our Supreme Court is in session in Harrisburg. Thank you again, Mr. Minner.
Now I mean it.
Yeah, now that time I meant.